Ladies and gentlemen, if we're ready, we'll just go through the sort of the motions on housekeeping before we call the witness. So let's go on the record. Marie, are you ready? And let me just ask the counsel for each party in turn whether there are any housekeeping issues that you wish to raise.
Good morning, Mr. Chairman. There are no housekeeping issues.
Thank you.
Nothing from us, thank you.
Good, thank you very much. I think from the tribunal, not at this stage. I anticipated yesterday that we will have some questions to put to you. We do have those. We will reflect on them in a coffee break and probably send them around to you before lunch. These will be without prejudice to further rounds of questions and so on. We'll see how we go on timing. I think as of yesterday, we were about 50 minutes behind, but I expect that we'll be able to make that up comfortably during the course of the day. And we've got a little bit of fallow time, or not fallow time, but we were planning to end a little bit early today. So I think we should be back on track. Hopefully we'll be back on track by the end of today. So I think without more ado, we can move to the first of our expert witnesses. And let me just make sure that when I refer to her, that I'm doing so correctly. Is it Ms. Bruksanin or is it Ms. Tomic? How should I? Tomic, that's what I thought. Thank you very much. Ms. Tomic, welcome. Could someone close to the door, just close the door, please, of the Thank you very much. Ms. Tomic, welcome. You're testifying in English?
Yes.
Thank you very much. You should have in front of you an expert declaration. If you could read that into the record, please.
I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Thank you very much. Before we hand over to you to give your opening presentation, I'll hand you over to counsel just to see whether there are any corrections that need to be made and so.
Thank you. Good morning, Mrs. Tomic.
Good morning.
Mrs. Tomic, do you recall submitting 2 expert reports in this arbitration?
Yes, I do.
And do you have these 2 reports in front of you?
Yes, I do.
Could you please go to the last page of each report and confirm that there is your signature there?
Yes, there is.
Thank you. Mrs. Tomic, do you have any corrections to make to your reports?
I have actually one correction to make. It is in my second report. In terms of Article 54.
Is that paragraph 54?
Paragraph 54, I apologize, yes. Paragraph 54, where I wrote that I understand that analogous company management bodies exist under Canadian law, in which I claim no expertise, but I said that I understand that this is pursuant to the Canada Business Corporations Act. I was since instructed that this company was actually regulated under BVI, Corporate Business Act. So that is the correction I would like to make.
So just to be clear, that's simply effectively a substitution of BVI for Canada.
Yes, yes, exactly. Not the federal, but BVI.
Are you sure it's BVI?
Well, if you were instructed, perhaps those who are instructing you will clarify.
Oh, it was British Columbia.
British Columbia. British
Columbia, yes. BVI is British Virgin Islands. So maybe,
yeah. Oh my God.
Yes. Okay. It's all.
Yep. Thank you very much.
Thank you.
That's it. Well, then I think over to you for your opening presentation. Thank you.
Okay. Thank you so much, Mr. President. My name is Bojana Tomic-Brkušanin, and I will now present the main findings of my 2 expert reports I produced in this case. First of all, I will briefly outline my relevant experience. Namely, I was actually employed by the Securities Commission of the Republic of Serbia for almost 7 years. I served there as a chief of staff, senior legal advisor, head of international cooperation and development department. And also, I have to state that during my time in the SEC, I also was a legal advisor in the securities department, which in its competence actually had preparing drafts of legislation related to share of the issues and takeover bids. And also I was actually reviewing takeover bids. In this presentation, I will briefly speak about basically two acquisitions that took place. First of which is acquisition of 70% shares in Obnova AD Beograd by Cypriot claimants in 2012, with my two main conclusions being that, first of all, Cypriot claimants acted in good faith when they did not publish a mandatory takeover bid with respect to this acquisition. And secondly, I will speak about consequences potential of the failure to publish this takeover bid, with the emphasis on the fact that such a failure did not, could not, does not actually affect the validity of the acquisition itself. Secondly, I will speak about acquisition of 10% of Obnova's shares by Maple Leaf Investments in 2017, where I will argue that MLI and its owner, Mr. Broshko, did not have an obligation to issue a mandatory takeover bid in accordance with the law. And also, I will outline that a potential failure to publish a takeover bid also did not, could not, does not affect the validity of the acquisition itself or the ownership over shares. So first of all, let's take a look at the 2012 acquisition, where I find it that Cypriot claimants acted in good faith when they did not publish a takeover bid with respect to this transaction. If you take a look at the timeline of relevant events related to this acquisition, I would say, first of all, on 19 July 2007, that the SEC adopted an opinion, which I will relate to as the 2007 opinion, according to which this acquisition did not trigger a takeover bid because there was no actual change in control in this as a consequence of this transaction. And the purpose of takeover law is actually to protect minority shareholders in the case there is such a change of control. Then on January 4, 2012, amendments of the takeover law entered into force. So there was introduction of additional express exemption from a takeover bid obligation for transfers of shares between persons who acted in concert in the takeover bid. Then, on April 26, 2012, Mr. Obradovic contributed as an in-kind contribution to Kalemegdan his 70% of Obnova's shares. In May, this transaction was registered in the Central Securities Depository, making Kalemegdan nominal owner of these shares. Then, on May 23rd and 29th, Mr. Obradovic and Kalemegdan, in line with the capital markets law, notified the SEC and Belgrade Stock Exchange that this transaction occurred. And finally, on 28 September 2012, the SEC adopted something I will refer to as 2012 SEC opinion, according to which this transaction did trigger a mandatory takeover bid obligation under the amendments of the law from the January. So let's take a look at the 2007 SEC opinion and what does it say. This opinion was, I have to note, in force for almost 5 years. And it noted that it is irrelevant which of the persons acting in concert owns a certain percentage of shares with voting rights, but only the total percentage matters. And also that related parties can acquire and dispose of shares of the target company on the organized market amongst themselves without the obligation to make a takeover bid, provided that the total number of those shares remains unchanged. I have to say that this opinion was actually deduced from the principles of the law that you need to have an actual change of control and not from any express exemption written in the law, but it was deduced from the Articles 4 and 5 of the takeover law. Under the SEC's interpretation of the takeover law in this opinion, 2012 acquisition was not subject to a takeover bid obligation because in reality, it did not result in a change of control over Obnova, and SEC thought that there was no need to protect shareholders in such instances. This opinion, as I said, was in force for almost 5 years, is relied on both by the SEC in its decision-making and by entities potentially subject to takeover bid obligation, as well as their counsels. This is something we already basically covered. What was 2012 acquisition all about? Mr. Đuro Obradović contributing to Kalemegdan his shares in Obnova, Central Securities Depository registering that transaction, and then, as I said, both Mr. Obradović and Kalemegdan, in line with the capital markets law, and represented by their legal counsel, Karanović and Nikolić, which I have to say are really most prominent and leading Serbian law firm, or certainly one of, notified the SEC about this acquisition. However, after the amendments of the law from the January, SEC on 28 September 2012 now adopted 2012 SEC opinion and basically adopted a more restrictive interpretation of the takeover law, according to which transactions not resulting in the change of control over the target company were exempted from an obligation to publish a takeover bid only if the parties acting in concert had already issued a takeover bid in the past. And this was basically interpretation of the new additional exemption, which was introduced in Article 8, which actually provided for this. So according to the 2012 SEC opinion, this acquisition did trigger the obligation to publish a takeover bid, since no takeover bid had been published in the past by Cypriot claimants prior to this transaction. This is why I basically am stating that I think that this opinion could not have been expected by Cypriot claimants, and basically that they acted in good faith. First of all, before the issuance of this opinion, the SEC did not publicly indicate that it would depart from the 2007 SEC opinion, and that actually introduction of additional exemption from an obligation to issue a takeover bid, which prior to this didn't even exist in the law, was in reality restricting rather than expanding the universe of exempted transactions in accordance with this opinion. And similarly, if we also take a look at the statement of reasons for these amendments of the law, they also did not in any way indicate that introduction of an additional exemption should be interpreted as narrowing rather than widening the scope of available exemptions. Also, I consider that Cypriot claimants acted in good faith with respect to their obligations under the 2000 takeover law. First of all, because under the 2007 SEC opinion, this acquisition would be subject to a takeover bid only if it resulted in a change of control over Obnova, which is one of the main principles of the takeover law, and that this acquisition did not result in a change of control over Obnova. Obviously, we had basically Mr. Obradović transferring his shares to the Kalemegdan, where he was the owner. Kalemegdan reasonably, in my opinion, relied on the 2007 SEC opinion in May 2012, because the opinion was based also, as I mentioned, on certain parts of Articles 4 and 5 of the 2006 takeover law, which did not change after the adoption of the 2012 takeover law. And this opinion was published on 17th October 2012, months after the acquisition took place. Also, I think it's important to note that SEC in reality never expressed any reservations regarding this acquisition, despite the fact that it was notified of the same. So in accordance with the capital market law, the SEC was actually provided with all the information that it needed to introduce supervisory proceedings, in my opinion, because it actually, the capital markets law provides that parties, when they reach or fall below certain thresholds in the public joint stock companies, they need to notify the SEC. So the SEC basically saw with this notification that there was a new majority nominal shareholder in a publicly listed company, which was all the information it needed to initiate supervisory proceedings to investigate whether a takeover bid was required. SEC did not require Cypriot claimants to issue a takeover bid, even after the SEC adopted the 2012 opinion later in the year. Let us now take a look at basically what would be consequences of potential failure to publish a takeover bid, with the emphasis on the fact that those consequences do not foresee any effect on the validity of the acquisition of shares. So basically, my main conclusion is, as I said, that the potential failure to publish a takeover bid does not invalidate the transaction acquisition itself. I consider it undisputed that the 2012 acquisition was a lawful method of transfer of shares. It was expressly recognized under Serbian law, and Dr. Lepetic agrees with this. Basically, acquisition of shares as a result of an in-kind contribution is a lawful manner of change of ownership of the shares. So also to that point, takeover law does not govern the validity of share transfers, and actually takeover law only applies once we have a valid change of control, because invalid transfer of shares cannot cause the obligation to issue a takeover bid. Moreover, the validity of share transfers is primarily governed by the company's law and the capital markets law, and neither of these laws, or any other provision of Serbian law for that matter, sanctions the acquirer's failure to publish a takeover bid by voiding the transfer of shares or by depriving the acquirer of its ownership of the shares. Actually, many of the rights remain with the acquirer, like the right to dividend or liquidation surplus, and Dr. Lepetic does not dispute any of these conclusions. So what would actually be consequences of failure to publish a takeover bid? First of all, SEC could order, after conducting a supervisory proceeding, Cypriot claimants to publish a takeover bid. As I understand it, the SEC has not initiated any supervisory proceedings. Then, as I think the most significant consequence, Kalemegdan's inability to vote Obnova's shares at the shareholders' meeting. I will note here that Kalemegdan's voting can also be challenged by other shareholders. This is time barred to 3 months from the date of the assembly. This also never happened, as I was advised. Kalemegdan could have been fined up to approximately 30,000 euros. This fine is subject to a 3-year limitation period, which lapsed. And Obnova's other shareholders, in line with Article 41b of the takeover law, could request the court, could have requested the court to order Cypriot claimants to buy their shares under the same conditions as if the takeover bid had been made. No such request, as I am aware, was made in the present case, and this right became actually time barred in 2022. Now let's take a look at the 2017 acquisition, when with the main conclusion from my side that Mr. Broshko and MLI did not have an obligation to issue a mandatory takeover bid as a consequence of this acquisition. So what happened in this acquisition is that on 14th November 2017, Mr. Broshko, through MLI, purchased 10% of Obnova's shares on the Belgrade Stock Exchange, becoming minority shareholder in Obnova. It is undisputed that Mr. Broshko and MLI have never reached the control threshold needed for a mandatory takeover bid under the 2016 takeover law, which was applicable at the time of this acquisition. And equally undisputed that as a result, this acquisition would have triggered the obligation to publish a takeover bid only if Mr. Broshko and MLI had acted in concert with Kalemegdan, Mr. Obradović, Coropi, or Mr. Rand, who acted in concert in relation to the control over Obnova. Article 4, paragraph 1 of the 2016 takeover law provides that persons are acting in concert if they cooperate on the basis of an agreement, which can be written or oral, expressed or tacit, to acquire shares with voting rights, to coordinate exercise of voting rights, or to prevent another person from carrying out the takeover procedure. I am not aware that any such agreement concluded between Mr. Broshko and MLI on one hand and Kalemegdan, Mr. Obradović, Coropi, or Mr. Rand. So what happens if we do not have such an agreement? SEC may still conclude that parties acted in concert in situations covered under one of the irrebuttable presumptions of control, which are set forth in the Article 4, paragraphs 2 to 7 of the 2016 takeover law. I consider it undisputed that the 2017 acquisition did not trigger any of the irrebuttable presumptions, which are exhaustively listed in Article 4 of the 2016 takeover law. 2017 acquisition, if we do not have an agreement and we do not have irrebuttable presumptions, SEC would in supervisory proceedings could also determine that there was acting in concert when there were other circumstances pointing out to the presence of such an agreement. And there are some circumstances that the SEC in that situation would particularly take into account in accordance with the law. And these are the circumstances. First of all, time and period of acquisition of shares. None of Kalemegdan, Coropi, or Mr. Erinn acquired shares in Obnova shortly before or after the 2017 acquisition. Then place and method of acquisition. This acquisition was carried out as a regular trade on the Belgrade Stock Exchange. Provisions of the acquisition contract, there was not such a contract, it was traded on the Belgrade Stock Exchange. Then value of acquired shares and the financing of the transaction. I have been instructed that this transaction was solely financed by MLI and Mr. Broshko. And finally, proposing and voting for the appointment or dismissal of the majority of members of the management body. This also, of course, indicates that in reality, a change of control happened. I have been instructed there were no changes in Obnova's management bodies after this acquisition. I also think there are no strong indications that Mr. Broshko and MLI had acted in concert with Kalemegdan, Mr. Obradović, Coropi, or Mr. Erinn. In Dr. Lepetić's agreement, we see two basically indications in her opinion. First of all, I do not consider the fact that Mr. Broshko supervised Mr. Erinn's investments in Serbia, including his investment in Obnova, to be a strong indication that they acted in concert with this particular transaction. And to that point, Mr. Broshko and Erinn confirmed that Mr. Broshko decided to acquire shares in Obnova independently of Mr. Erinn. Secondly, I consider that Mr. Broshko's 2017 acquisition of 10% shareholding in Crveni Signal to be irrelevant to the assessment of whether he acted in concert with Mr. Erinn with respect to the acquisition of shareholding in Obnova. Basically, the fact that Mr. Broshko acquired in the same year 10% shareholding in two companies that he supervised, for me, in no way suggests that he did so in concert with Mr. Erinn rather than independently. And moreover, Crveni Signal acquisition is in no way related to increasing or changing the control over Obnova. Let's take a look at the consequences of potential failure to publish a takeover bid, again with the emphasis that that fact could not have, even if it happened in reality, could not have affected the validity of this acquisition. Again, my arguments are really similar. It is undisputed that this acquisition was a lawful method of transfer of shares. It was done in the open market. Secondly, potential failure to publish a takeover bid in accordance with Serbian law does not affect the validity of the transaction. Takeover law only enters into force once we have a valid transaction which resulted in the change of control. Validity of share transfers is governed by other laws, and none of them stipulate that the sanction for failure to publish a takeover bid is annulment on the ownership of the shares. And Dr. Lepetić does not dispute differently in any of her conclusions. What would be the consequences of the failure to publish a takeover bid? Basically the same as with the 2012 acquisition. MLI could have been deprived of the right to vote at the acquired shares at Obnova's shareholders meeting. No such challenge has been made in the present case by shareholders assembly. MLI could have been fined up to approximately 30,000 euros and Mr. Broshko up to 400 euros. This fine is subject to a 3-year limitation period and it lapsed on November 14, 2020. And finally, Obnova's other shareholders could have requested the court to order Mr. Broshko or MLI to buy their shares under the same conditions as if the takeover bid had been made. No such request was made in the present case. Thank you.
Thank you very much indeed. And thank you for your hard copy of your presentation as well. Respondents, it's you. Ms. Lemoyne.
Good morning.
Good morning.
My name is Sarah Lemoyne, and I'm part of the council team for the Republic of Serbia. So we'll be having a discussion today about your two legal opinions. Just as a preliminary matter, is it Ms. Tomic or Bukushinen?
Ms. Tomic is fine.
Tomic, okay,
Yes.
as you wish. So let's begin then maybe with your first legal opinion, just to go over a few details regarding your experience and backgrounds. If we could turn to paragraph 3 of your first legal opinion.
Mhm.
So you mentioned here that you started to work at the commission in August 2012, where you were an advisor at the Securities Commission and in charge of reviewing takeover bids.
Yes.
And you mentioned this as well in
Yes.
your presentation this morning, I noted. Okay, and then from just looking now onto paragraph 4, it says from July 2013 to March 2017, I served as chief of staff of the SEC. And then you go on to sort of describe the activities you're working in.
Yes.
Were you still reviewing takeover bids at this stage?
At this stage, I was not reviewing individual takeover bids as basically the main person who was in charge of that. At that point, I was basically in charge of reviewing all materials before they go to the session of the commission on behalf of basically of members of the commission. So I was only reviewing them, not as a primary person who does them, but basically just checking their legality, completeness before they were introduced to the members of the commission.
Okay. Then in paragraph 5, you mentioned that from March 2017 to March 2008, I was a senior legal advisor in the market participants department of the SEC. My work consisted of issuing licenses to market participants and drafting legislation in that area.
Yes.
So you weren't involved at this time then with takeover bids?
Yes, in this period, I was not involved.
Okay. And you left the commission in 2019, is that right?
Yes.
May I ask why?
Well, basically, to be honest, I felt that that the capital markets in Serbia were not really developing, and I was basically acquiring a lot of knowledge that I could not really implement basically in the state of the capital markets in Serbia. So I decided to start basically working on something else also.
Okay. And that's when you first moved to the Foreign Investors Council.
Yes.
And just briefly, can you explain what your work was there?
Well, basically, I was advocating for changes in Serbian legislation related to Serbia's business climate. So I would take a look at the regulation that was in preparation and work with the foreign companies in Serbia to see whether they have some objections, and then advocate to the state, basically, if they thought that some improvements were necessary.
Okay. And then, so you're there for about a year and then switched over to Digital Serbia initiative?
Yes.
And this is also discussed just for the tribunal's reference in your CV as well on page 21. So maybe I'll just quickly refer there as well. And so it says that you were responsible for designing and implementing projects aimed at removing regulatory obstacles related to development of digital economy, innovation, startups, and IT industry.
Yes.
Okay, so your work is, again, maybe, please correct me if I'm wrong, like focusing on improving the business climate.
Yes, exactly. I basically continue the same thing as in the SEC, but with the, as in the Foreign Investors Council, but this time with the emphasis on digital economy.
Okay. And then since June 2022, you've been acting as an independent consultant?
Yes.
And this is, again, in the fields of digital assets and...
I did some work in the capital markets and the digital assets.
Okay, thank you. Now let's then turn to the 2012 acquisition.
Mhm.
And now, I think it would be helpful to clarify a couple of statements you make in your first opinion. So if you will, could you please turn to maybe paragraph 21?
Mhm. Yes.
The second sentence of that paragraph, so beginning on page 5, you state, under the SEC's interpretation of the takeover law set out in the 2007 SEC opinion, the 2012 acquisition was not subject to a takeover bid obligation because it did not result in a change of control over Obnova. And this was also explained in your presentation again this morning. Okay, so this is the 2007 opinion, and it basically exempts concerning parties which dispose of shares among themselves.
Yes.
For making a takeover bid.
Yes, because basically, as I said, the main purpose of the takeover law and the takeover directive, which was transposed in the Serbian legislation, basically via the takeover law, is to protect the interests of minority shareholders in case there is a change of control over the company. As the takeover law did not have any exemption related to that situation, there was a demand from the SEC to basically say what is their opinion in case that this situation occurs, that parties are already in control because they are acting in concert, and then start basically restructuring by transferring the shares amongst themselves. And since there was no exemption in the law at that time for this kind of transactions, the SEC went from these principles of the law and some of the basically parts of the articles 4 and 5, and basically said, we consider that these kind of transactions do not impact the control over the company, and they are therefore exempted. So that was before the amendments of the law and subsequent opinion.
Okay, that was quite a lengthy answer. Maybe let's unpack that a bit. Just from the start, though, do you agree then that with respect to the 2012 acquisition, the Kalemegdan was acting in concert with Mr. Obradović?
Yes.
And as well with Coropi?
Yes, and Mr.
Erinn.
Yes,
Okay.
yes, I do.
And then going back to this 2007 opinion, so you mentioned that it was essentially addressing a gap in the law,
Yes.
and this was a gap in the law and takeover from
Well,
2006?
Yeah, I cannot basically say whether it was a gap or not. Basically, the law did not opine on such situations. There were no exemptions related to these kind of situations, and obviously, someone asked the SEC to now issue their public stance on these kind of transactions, because, as I said, they do not result in the change of control. So why are you protecting minority shareholders? And then the SEC said, okay, these transactions should in fact be exempt. They were looking at the law as a whole. What is the purpose of the law and what is happening in the reality, and introduced this opinion.
But the 2007 opinion is interpreting the law as it existed and was enforced at the time, and correct?
Yes, it was in line with the law that was in force at the time.
And that would have been the 2006 law and takeover. Maybe, could we maybe just put that on the screen? This is C557. And I understand the law and takeover was amended, has been amended a few times since then.
Yes, yes, exactly.
This is the 2006 version. And if you could just scroll down to page 3. So the law does set out some exemptions from the obligation to publish a takeover bid.
Exactly.
And there's no exemption here that for transactions among related parties.
Exactly. No such exemption, which is why the SEC introduced this opinion. It felt that in line with the general principles of the law, these kinds of transactions should be exempted because they do not result in the change of control over the target company.
the interpretive opinions by the commission binding, or what is their legal status?
Yes, they're not legally binding, but they are, of course, heavily impacting in reality application of the law, because if you are a party, let's say, who wants to transfer shares, and you know that the SEC will consider that transaction as an exempt, then that is, of course, heavily relied by all market participants. And that is why these opinions are really important in reality of the application of these laws. SEC is the supervisory authority on the capital markets and takeover markets in the Republic of Serbia. And if you know that this is how the SEC is actually implementing the law, then it heavily influences, of course, the behavior of the participants.
Sure. And then, but as you know, the law on takeover was amended
Yes.
a couple times after
Yes.
2006, I think in 2009, and again in January 2012.
Yes, yes, exactly.
Okay. And the 2012 acquisition, as you mentioned in your report, that took place in May, correct?
Yes.
Of that year, correct?
Yes.
So then the law on takeover, as it was amended in January 2012, that would have applied to the 2012.
Yes,
acquisition.
exactly.
Okay. Then, if I may turn you then to the 2012 law on takeover, just for reference, this is the law on takeover as amended in January
Mhm.
2012. So, C559. And if you can go to page 5. So on page 5, again, in Article 8, it sets out all the statutory exemptions to the takeover bid. And if we go to paragraph 11, I understand there was a new exemption was introduced
Yes.
in January 2012, and it states here, after the takeover bid has been carried out, he, and that's a reference to the acquires shares of the target company by transfer between persons who acted in concert in the takeover bid.
Yes.
So like the exemption that's contemplated in the 27 opinion, this one also concerns transactions among concerting parties where there's no
Yes.
change of control, right?
Yes.
Is it fair to say it's sort of filling in that gap in the law that the 2007 opinion had been seeking to address or remedy?
Well, yes, you could say that now, before this amendment, basically, the exemption from the obligation for parties acting in concert was relied on by the general principles and parts of the articles 4 and 5 of the takeover law, while now it was expressly stated that there are instances when these transactions are exempted. So yes, I agree.
Okay, but the difference here is that this exemption specifically states
Yes,
or envisages that a previous takeover bid has been made.
yes, that this party needed to have takeover bid in the past.
Okay. And just to be clear, this was enforced and would have been known then, this provision to the Cypriot claimants at the time they acquired.
Yes, I think just first of all, the fact that the previous opinion was in force for so long that it was implemented in the situation where no exemption existed in the law. The fact that provisions where that opinion was based on basically did not change in these amendments. But we have, like you stated, the new exemption now expressly written in this law, that there was, I would say, there could have been some confusion on the market whether now that exemption now applies only in this case, and that is why obviously someone asked the SEC to opine on that months later. So I am not saying that there was no obligation to publish a takeover bid. I am just saying that in this instance, it could have been in, let's say, good faith, as I'm saying, that parties could have, were not sure actually, or could have thought that they still do not have that obligation. And I was advised that claimants also asked the lawyers, Karanovic and Nikolic, who told them that in their opinion, there is still no obligation to publish a takeover bid. Since there is now new additional exemption, while all the provisions that were the basis for 2007 opinion were actually still in force.
Okay, so you agree that there was an obligation?
Yes.
But the Cypriot claimants
Yes.
reasonably
Yes.
relied on this
Yes, yes,
exemption?
yes,
But you mentioned they also had some lawyers
yes.
that were handling this matter. That's
Yes, yes.
the law firm Kranovic and Nikolic.
Yes, and I mean, further to that, I think the fact that they actually sent a notification to the SEC where they said there was actually this acquisition, and the SEC did nothing even after this exemption was introduced. And as I was working in the SEC for 7 years, I know exactly that these notifications on thresholds were used to initiate supervisory proceedings. Because the SEC actually got the notification, there is a new majority shareholder, and if they saw that there was not a takeover bid, that would be the basis to start investigating into the matter, which did not happen in this case, even though they were notified of the transaction.
Okay.
So all those things together, just for me, make me conclude that this could have actually been omission done in good faith, not that there was no obligation, basically.
Okay, you mentioned that you were advised that the Cypriot claimants, one moment, please, that they had relied on the 2007 opinion.
Yes.
Did you see any memos or
No.
emails documenting this?
No. I was advised.
By counsel
Yes.
for claimants?
Yes.
And you described this law firm as a leading law firm, as leading Serbian law firm.
The ICSID Karanovic is one of the leading law firms in Serbia. That's my opinion.
So it's fair to say they would have had they have a high level of knowledge in company law matters in Serbia.
Yes.
Okay. And they would have they would have been familiar with this change in the law.
I cannot say, but in my opinion, they probably would have been aware.
Okay. And do you know if they ever sought an opinion from the commission on?
They did not seek out an opinion, as far as I know.
And just stick on this point about the reliance on the 2007 opinion. You mentioned it had been in force for 5 years. Does the commission, when it does depart from an interpretive opinion, does it make a public statement or?
Well, in most cases, it happens as in this case. There is another party that wants the opinion, and then the SEC will provide it. The SEC, I would say, definitely does it like on its own initiative. There needs to be a demand. There needs to be a demand for an opinion.
But let's assume that someone hadn't asked for an interpretation of this new exemption or of the exemptions in Article 8 in early 2012, in your view, would have been reasonable for persons on the market to continue relying on the 2007 opinion until another opinion was issued?
I think the reality was the following, that because obviously Serbia is a small country and there are not so many participants on the capital markets, that there was some confusion after this additional additional exemption and how it could now be interpreted, to how the SEC will now behave in these situations. And that's why the opinion was asked. And I think that's what happens basically in most cases when there is some confusion, especially when the new law enters into force or amendments of the law. That's when the SEC gets the most initiatives for providing opinions, basically.
But I mean, isn't it possible that something comparable to the 2012 opinion just wouldn't have been issued? It could have been months or even years later till this.
Yes, we can imagine this
And
situation,
then
of course.
Parties could still keep relying on the 27 opinion.
I think there would probably be some situation. Yes, first of all, they could, but then they would be in the breach of the law like this situation here.
Yeah. Now, you mentioned in your presentation also a statement of reason. Perhaps we could take a look at that. That's Exhibit C712. So I understand this was issued prior to or alongside the amendments to the 2012 law on takeover.
Yes.
Do you know who issued this statement?
Well, it is always basically the ministry that is where the changes of the law are in their competency. So it would be Ministry of Finance, basically, which is authorized to propose amendments of the takeover law.
Okay, so then not the commission.
Yes.
And here it refers to the exemptions under the Article 8 of the law on takeover. And it states, Article 8 of the law is amended to expand the number of specific situations in accordance with the solutions from the comparative regulations of neighboring countries in which the acquirer is not obliged to announce a takeover bid.
Yes.
And as it was established, the 2007 opinion doesn't correspond to any of the exemptions listed in Article 8. And this doesn't make any reference as well to the 2007 opinion.
Well, no, it would be highly unusual for the ministry to opine on SSC opinions because SSC is independent body from the ministry. But I can say that here in basically the provision you highlighted, it says to expand the number also of specific situations. So we said the situation where the transaction is exempt, even though there is no exemption to refer to it. And now we have a situation that there is an exemption of the law, and it actually says in the explanation that the law is amended to expand the number of specific situations. In reality, it actually narrowed the number of specific situations. So I think my point that it could have caused confusion and parties to act in good faith, like in this situation, stands basically.
But is it fair to say, though, that it's referring, when it talks about expanding the number of specific situations, it's a reference to the exemptions in Article 8,
Yes.
not the 2007 opinion?
Yeah, as I said, they will not comment on SEC's opinion. I have never seen Ministry of Finance comment because the SEC is in charge of implementing the law. Ministry of Finance just adopts the laws while Commission adopts all the bylaws and interprets the law.
And if we look at the first bullet point, it says if after a conducted takeover bid, the bidder acquires shares of the target company through a transfer between persons who acted jointly in the takeover bid.
Yes.
This is the new Article 8,
Yes.
paragraph 11.
Yes. Yes. Yes.
And here again, it mentions this condition of there being a previous takeover bid.
Yes. 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 I mean, not again, this is the first time it is this exemption is introduced. So here it says after a conducted takeover bid. I agree.
Sorry, Ms. Lumen, can I just check this extract, because it is just an extract, is of Article 8 of the Act, is it? Because it doesn't actually say on the top of the extract what it is from. But
I understand it's the statement of reason that was passed by the Ministry of.
When Ministry of Finance proposes the laws to be adopted by the Assembly, it will provide the text of the amendments, but also the statement of reasons where it will explain basically what were the intentions of the changes. And here, as we can see, the Ministry of Finance says that this article is amended to expand the number of specific situations where there does not need to be obligation to announce a takeover bid. And then we have this.
thank you. I understand that. I'm just, if you look at the document, as you scroll down to the next page, you see the Serbian original. And I'd just like to know which part of the Serbian original is extracted in English, because it doesn't actually say. So I'm trying to establish whether that is the reference to,
I think you need to go further below. And here, it will be here.
So where is the extract?
Still below, and here it is.
Ah, I see. Okay, so it's on page 15 of the.
Yes, yes.
Thank you very much.
First, there is this. This is actually what you scrolled before. It is actually the text of the amendment, and then below where we are looking for is that explanation of the amendments.
let's move on. I'd like to now just discuss the 2017 acquisition in which Mr. Broshko acquired a 10% interest in Obnova through his Serbian company, Maple Leaf Investments, or MLI.
Mhm.
And you mentioned this morning that there would have only been a takeover bid obligation if he had been acting in concert
Yes,
with Mr. Rand or Coropi or Kalemegdan. Is that correct?
yes.
You mentioned or. Is it, so would it suffice if he was simply acting in concert with, for example, Mr. Rand?
If he was acting in concert with Mr. Rand, yes.
And if he was only acting in concert with, say, Coropi, that would be enough to
Yes.
trigger the takeover bid obligation. Then let's look at, so as this transaction happened in 2017, the law on takeover which applied was the one that had been amended in 2016.
Yes.
So let's take then a look at the 2016 law on takeover, which is Exhibit 560. And I'd like to go to Article 4, which is at the bottom of page 1. And Article 4 sets out, it governs sort of in what circumstances parties are acting in concert.
Yes.
And so in the first paragraph, there's a definition of what it means to be acting in concert.
Yes, this is basically, I would say, the bottom line of this article, that there needs to be agreement between those parties to either acquire the shares with voting rights, or to mutually exercise voting rights, or to prevent another person from carrying a takeover procedure.
And then below that, it sets out, it says it is considered that the following persons are acting in concert. And there's a list that follows.
Yes.
For example, members of executive and supervisory boards of companies that are acting in concert. And then it goes on from there. Further down, natural and other persons are considered to be acting in concert when one of them directly or indirectly controls another person, another legal person, or other legal persons.
Yes, this is related to control of legal persons.
So these are all different circumstances in which gives rise to a presumption, if you will,
Yes.
that parties are acting in concert when they acquire shares. And I understand it's from your second opinion, and we can go there. It's paragraph 57. That you don't consider that these different presumptions in Article 4 can be assessed cumulatively or holistically. And in your second,
I think they can be assessed cumulatively and holistically, but then it's the other circumstances. If you want irrebuttable presumption, that means that you have proved actually acting in concert, then the law says, for example, a director is acting in concert with the company. But then if this company acts in concert with a different company, and this company acts in concert with their member of supervisory board, and member of supervisory boards acts in concert with his son-in-law, that doesn't mean that this initial person is irrebuttably acting in concert with this. In that case, for example, when the SEC determines who has the right to publish a takeover bid, I think in a lot of cases, it would be hundreds of persons who never heard of that company, and they're all acting in concert. So basically, you can say that you have an irrebuttable presumption between the company and its manager. And then further on, you can assess it holistically, but then it's all the circumstances that you need to take into account that to prove that there was actual acting in concert, in terms that there was an agreement for them to act together to gain control. Otherwise, it would just be absurd, because the law states that the establishment of acting in concert is equated with the acquisition of shares. So the moment, for example, I acquire shares, my daughters are now obligated to do a takeover bid. They could be fined. The SEC could fine hundreds of persons every time someone acquires shares. So in reality, you have irrebuttable presumption, which exists in these cases, basically that you now showed in the screen. But if there is no irrebuttable presumption, then of course you can, the SEC can take a look at all the other circumstances related to acquisition in order to prove, to demonstrate that there was actual agreement to act in concert.
Just so I understand you correctly, you can have multiple irrebuttable presumptions sort of activated under this provision? And
You can activate them, but they're no longer irrebuttable. Irrebuttable presumption are listed exhaustively in this article. So it is, if the company acquires, member of its management body is irrebuttably changed, then there is no need to demonstrate anything further. But if you want to keep all those irrebuttable presumptions piling up, then this end person will not be acting in concert irrebuttably, how to say, with the first person. You need actual, nowhere in the law is stated that, and it would lead to results that are really absurd and completely divorced from reality. So the SEC looks at those persons that are actually in accordance with these presumptions that you said. If you have a company and a member of supervisory body also, they will act in concert. But then their son-in-law, if they are in another company and that company has a manager and that manager has daughter and that daughter is a supervisory body in some fifth company, it's not like they're all irrebuttably working together. And the law nowhere provides that. It just says manager with the company. Anything further than that, you need to prove that these persons are acting in concert.
how would you prove that?
Well, first of all, you have, I think, those special instances, for example, financing, existence of some agreement, they all acquired shares at the same time. And I would say, but this is just my personal, I think the SEC during its work while I was working there was mostly demonstrating, for example, by funds. If a lot of funds were needed for transaction, we would ask for flows of the money. And if the transaction was financed by someone else, we would say, okay, there is a high probability that there is actually acting in concert and person is buying these shares from someone else. So there are many instances how you would prove that, or they are connected, for example, through these multiple chains, and they are buying the shares at the same time. And in my opinion, also the one that is listed in the law as the special circumstances that the SEC would take into account if there was a change in management. So if you have two persons who you can see are connected basically through this chain, for example, and then when they acquire shares, they start voting and immediately change basically how the company was being run, majority of the members of the board, that is a strong indication that these persons were actually working in concert. And in my opinion, this is, for example, why none of Obnova's shareholders ever basically challenged anything as a result of this acquisition. Nothing changed in their reality by Mr. Broshko acquiring 10%. It's not like he acquired it and then all of a sudden there were changes in management, changes in policy. Nothing changed for them as a result of this acquisition.
Okay,
So that is basically my opinion.
Okay,
That I was
you.
explaining here.
Okay,
why they
thanks.
were not.
Oh, then maybe let's look at your first legal opinion. If you could look at paragraph 33.
Okay.
And in this context, just for reference, you're talking about the 2005 acquisition where Mr. Obradovic acquired the Obnova shares through the assignment of the privatization agreement for Obnova. So you state in paragraph 33, in the second sentence, that the 2005 acquisition is, however, relevant from the perspective of the takeover law because it had established acting in concert between Mr. Rand and Mr. Obradovic within the meaning of the law. So that presumably is takeover law. So you state here that they were acting in concerts because they had an agreement. Then if we then go forward to paragraph 34, states the top, Coropi has also been acting in concert with Mr. Rand and Obradovic because since 11 March 2010 until today, Coropi has been owned by the Ahola Family Trust, whose beneficial owners were Mr. Rand's 3 children. So I understand this is you're applying one of the presumptions under Article 4.
Yes, but there is, I would say, a really significant difference. These persons actually are admitting that they're acting in concert. Like when we say, okay, I established this structure, for example, Mr. Rand, in order to actually control Obnova, it's different than to say this is irrebuttable presumption. Here we have actual situation that these persons are saying, yes, we actually want to control Obnova through this structure, and they are openly admitting it, and that is why they did it. It is different than to say it is irrebuttable presumption that every time you have a third cousin of the management body of the connected company, and that is irrebuttable, it's demonstrated. So that is the difference.
But which persons do you mean, Mr. Rand and Mr. Obradovic?
Yes.
Okay. And then with you.
But with all these persons, basically, Mr. Rand established this structure in order to be able to control Obnova, and in reality, he did.
And then you state at the bottom of this paragraph, as a result, Mr. Rand's children and thus also Coropi have been acting in concert with Mr. Rand and all those acting in concert with him, including Mr. Obradovic.
Yes, yes.
And you're saying that this is based on the fact that there was an agreement between Mr. Obradovic and Mr. Rand.
Yes, basically there was agreement between these parties that this structure will be used.
Sure.
So Mr. Rand in the end has ultimate control over Obnova, and that is the reality of this.
But you also mentioned Article 4, Paragraph 6 of the 2006 Takeover Law, which provides that natural persons are considered to act in concert.
Yes, because they are important in assessing. We are saying this is basically the mechanism from all these provisions that they use to establish control.
Okay, and then you also consider that Mr. Rand, that Coropi acted in concert with Mr. Rand because it was controlled by Mr. Rand?
Yes.
Okay, so then is this not also one of fall under the scope of Article 4, where persons act in concert when one of them controls another?
Yes, yes. You can have a person controlling another, and you can have the reality where that person, but of course, Mr. Rand is controlling Coropi. I mean that, for example, Mr. Rand's control over Coropi is irrebuttable because he was actually director there. But in order to say he was also controlling Obnova, you need to take a look at the facts of the case. Anytime you start chaining, basically, you need to demonstrate that all these chains are actually used for control. You cannot just assume, like I said, in reality, that would lead to the SEC every time, because the SEC needs in its decision to say who are persons acting in concert. They would every time list hundreds of people who are in any way connected to the person who acquires shares, and they obviously do not have control over the company.
Okay. Thank you. Then let's just stay on the paragraph or on Article 4 of the 2016 Law on Takeover. So we have sort of these lists of circumstances or different presumptions. And can you go back to 560, C560, and scroll down a bit? So to the last, just further up, the last paragraph of Article 4 states, when determining acting in concert, as referred to in paragraph 1 of this article, the commission particularly takes into account the following circumstances. And you've mentioned this also in your presentation this morning. Okay. So do you agree this is not a closed list of circumstances?
Yes, these are, but the law actually obliges SEC here to always particularly take into account these circumstances. But of course, SEC can take a look at any other circumstance as well.
And you were present in the room yesterday.
Yes.
And so you would have heard that you were here for Mr. Broshko's testimony. Correct?
Yes.
So you would have heard that he discussed that he supervises a number of Mr. Rand's investments, and he also has a consulting agreement with Rand Investments.
Yes.
Okay. And you will have also heard him discuss his use of the title managing director.
Yes, I heard that.
Okay.
But to that end, there is nothing that he said, basically, that for me demonstrated that he actually, that someone can say, but in this particular transaction, when you bought these 10% of the shares, it is now basically proven that you acted in concert in relation to this concrete acquisition. He is a natural person. You, in my opinion, you have not demonstrated acting in concert. The fact that I'm supervising as a consultant something, let's say for my boss, doesn't mean that I cannot make my own personal investments. In my opinion, that is not evidence.
You also mentioned in your presentation that his acquisition in 2017 of another investment of Kalemegdan.
Yeah.
This is his acquisition of 10% of the shares in Cerveni Signal.
Cerveni Signal,
Yeah.
yes.
Okay. So Cerveni Signal is also, so he also supervises this company, correct? And Kalemegdan owns 70% of the shares in Cerveni Signal.
Yes, but in no way does that acquisition is in any way related, right, to control over Obnova. Because he bought 10 and became minority shareholder in Cerveni Signal, did anything change in control over Obnova? No. So for me, that is completely irrelevant transaction. He could have invested in 50 more companies. If they did not result in any change in terms of Obnova, I would say they're irrelevant.
Could we perhaps call up exhibit C389? So I don't think you've seen this document before.
No.
So we'll just have a look at it together. It's a loan agreement between Cerveni Signal and MLI, and you can see on the top it's dated May 25, 2015. So between Cerveni Signal and Maple Leaf Investments, and if you kind of scroll down, you'll see that it's a down to the subject matter. Okay, that MLI is paying off. It's essentially a loan where MLI is giving money to Cerveni Signal. And if you can go down a bit further. It was signed by, on behalf of Cerveni Signal, signed by Mr. Igor Markicevic as General Director, and on behalf of MLI by Mr. Broshko as Director. Then if we could also just look at, sorry, exhibit C392. This is another agreement between Maple Leaf Investments and Cerveni Signal, dated April 15th, 2016. And on page 2, when you look at the subject matter of the agreement, it states that MLI will be repaying certain debts of Cerveni Signal. And just going down to the signature page on page 4. We got, it's signed on behalf of Cerveni Signal, this time by Milan. I'm not going to even try to pronounce that last name, but the relevant bit is for MLI, it was signed by Mr. Igor Markicevic as Director of Maple Leaf Investments. does this influence at all your assessment of whether Mr. Broshko's acquisition of the shares in Obnova, that he was acting in concert with
With whom?
with Coropi, Kalemegdan?
Right. But we have, first of all, I have never seen this. So it's really hard for me to opine, but if you could point, I fail to see any still. So we have loans between MLI and some company that he bought. How is this related to Obnova?
Sorry, I should mention, pardon me, Mr. Markicevic is the general manager and director of Obnova. And he's also, as I understand, the director and Kalemegdan of Coropi.
So, I mean, I'm sorry, I honestly struggle to see. So there were some loans. But how is this related to Obnova? Igor, right here is, I don't know but I don't understand how is this impacting Obnova, control over Obnova, even Obnova's operations control. How is this? I apologize. I have not seen it before, so maybe, but I do not. Right now, I do not see basically any connection. Why would this change my opinion? He was a shareholder, minority shareholder in Crveni Signal. He did some transactions, but why is that? How that means in any way impacts control over Obnova? I do not understand. I do not see the connection.
Okay, no,
Mhm.
that's fine. Then let's park that and move on to another topic that came up in your presentation. Yes, please.
A follow-up question. And forgive me, Mr. Tomic, if I'm just misunderstanding. So as you've just heard from Respondents' Council, Mr. Markicevic is director of Maple Leaf Investments. He's director of Obnova. He's director of Kalemegdan. He's director of Coropi. Does that not suggest, if there is a single director of all of these companies, that there is some kind of concerted conduct going on?
For me also, that is really not enough to say in any way that Mr. Broshko didn't acquire that 10% of shares because he wanted to acquire them. You need to have an agreement to establish control over a company, to change the management. To me, none of these things, they're so far circumstantial. I mean, the consequences of establishing that someone is acting in concert are really significant. I mean, you are now obligated to do a takeover bid over all the remaining shareholders. You really need to establish that. If you do not have irrebuttable presumptions, you really need to demonstrate and establish that actually in relation to that transaction, these people wanted to change control basically over a company. All these are really, really circumstantial to me, and they are not basically enough. And I have not seen anything to demonstrate that Mr. Broshko could not have acquired these shares by himself. And because there are no irrebuttable presumptions, you really need to prove that. So you're going to court. I mean, basically with this, even if SEC opened those kind of proceedings, which it did not. Even if the SEC determined from this, but this is just, I don't know. For me, it's not enough. I have not seen anything that would point me in that direction. But let's say the SEC decided, you will still need to go to court, and the person is saying, I bought this by myself. You really need to have a strong case to demonstrate that they acted in concert.
So I understand that. Mr. Mann, forgive me if I just pursue this question a little bit further. So I understand that there's no irrebuttable presumption, and I understand that this is all circumstantial. Perhaps you could just explain, and forgive me if I've missed this as I've been concentrating on other points, but for the SEC, presumably there is an intermediate step before going to court. There are investigations, there are inquiries, there may be a soft letter which goes to the director or the managing director saying, can you please enlighten us further?
Yes.
I mean, what would trigger the SEC simply to make a soft inquiry in circumstances in which, on the basis of circumstantial evidence, it suggests that there is some kind of connection between various parties?
So I would say that for the SEC to start basically such investigation, it was mostly in reality two situations. One was, for example, if SEC was notified, like in 2012 acquisition, you now have new majority shareholder, and they have not initiated a takeover bid. The SEC would start investigating into that if they thought the takeover bid should have, that there was change of control and takeover bid should have been published. And the second situation, for example, in situations like this, there would need to be, in most certainly, someone, in most cases, they were minority shareholders who would send basically a letter to the SEC asking SEC to start investigating a certain situation, and that minority shareholder would basically write down why they thought there was a change of control and what happened. So that was like the most, in practice, that was mostly what would happen.
So
someone, yes, would send, because in all situations during my time there, when the SEC would start these investigating procedures, these were the situations when something in the company as a result of these transactions, what I have to say, I have to keep emphasizing, really changed. There was actual change of control. So even there, for example, let's say 5% was acquired by someone who seems unrelated party, they actually start, I don't know, change of business policies, they start changing management. So it's obvious that the change of control happened, and then minority shareholders would basically send a letter to the SEC and say, please start investigating into this. I think in Obnova, nothing changed in terms of.
Thank you. I'm going to invite you to hold that. We may come
Yes.
back to it in tribunal's questions and pass
Yes,
back
yes.
to Respondents' Council.
Thank you. Excuse me. You just, on the topic of the consequences of a failure to issue a takeover bid, just, you mentioned this morning a couple consequences that could be enforced by the minority shareholders in a target company. These were one, that the shareholders could challenge the acquirer's voting of its shares in the company, and also that they could go to the court to get an order obliging the acquirer to buy their own shares. But for either of these consequences to materialize, the minority shareholders would have to first sort of be aware that there had been a change of control.
Yes, exactly. But I think that's also one of my points. When there is a change, how do minority shareholders see the change of control? There is actually consequences in their company. That's when there is a real change of control. Something happens, I think, for minority shareholders in this case, where, for example, in case of change, when it went from Mr. Obradović to Kalemegdan, to that point, that is publicly available information. There's minority shareholders could see anywhere that you have a new, basically nominal majority shareholder, but they never initiated anything because it's not like intuitive for them that there was a change of control when nothing changed. They see the same people, the same management, the company is doing the same things. So that is why minority shareholders were not active even in that case. And let's say in this, I agree with you, they would not know that MLI bought 10%.
And they wouldn't have known if MLI was acting in concert.
Yes, obviously they wouldn't.
They
They
wouldn't
would, they would, like what I was explaining to Mr. President, if they saw a shift in companies, policies, management, that's when minority shareholders, while I was working in SEC, become active. And they say, okay, something happened, please investigate into this further, even though they have seen nothing like in this case.
And equally with the 2012 acquisition.
With 2012, they could have actually seen it. There it was obvious. They in business registry and in central depository, you had one nominal owner, Mr. Obradović, then you had Kalemegdan. But basically, why would they even go into all of that when they see the same management, the same things are happening within the company?
But would they have known that the
There
connection
it was
between
publicly-
Kalemegdan?
Yeah, there it was publicly
and
available
Obradović.
information. Yeah.
And would they have known about Mr. Rand's involvement or
No,
Coropi?
no. They would not know. They obviously would not know that. But if hypothetically, even if they did, it's again the same person controlling it all through these transactions.
You also mentioned that a fine could be issued. If we could go to your first legal opinion, then paragraph 44.
Okay.
Says pursuant to Article 47 of the 2012 takeover law, the SEC may issue a fine ranging from 1 million dinar to 3 million dinar to any acquirer who failed to notify the acquisition to the regulated market. Or if the does not publish a takeover bid. So this is, and then you refer in the footnotes to the law on economic offenses.
Yes, this is an economic offense.
Okay. You would classify this as an economic offense failure to make a takeover bid,
Yes.
and it would be prosecutable then.
Yes, basically SEC would, at that point, SEC would, first of all, adopt a decision where it establishes that there was acting in concert, that there was an obligation to publish a takeover bid, and it would send a letter basically to the court proposing to impose this fine for economic offense.
So the fine would be imposed then by the courts.
Yes.
Okay. Just for the record, you state here that the SEC may issue a fine, so.
Well, no, SEC would send it to the court and ask the court to issue this fine. But in my experience, courts never always did what the SEC said.
Then, thank you. I think those will conclude my questions for this morning.
Thank you.
Thank you very much. Redirect.
Thank you. Just a few questions. Again, if I could use the good offices of Respondents Council for pulling up documents. Thank you very much. So let's go back to document C392, please. This is a document which you were shown about the loan agreements. Do you recall that?
Yes.
And please, if you could go to the beginning of the document to see if we have a date there. And no, we don't. Yeah, we have a date. Could you tell us what the date is, please?
April 15th, 2016.
Mm-hmm. So when the SEC assesses acting in concert for the purposes of a certain acquisition of shares, does it look at historical information or contemporaneous information?
Well, basically, SSC would be mostly looking at the time of the acquisition, what was going on. So whether there was actually concerted effort at the time of the acquisition. That is mostly what they would be interested in, to take a look at that transaction, to see how it was financed, what was happening around that time.
So now if we could please scroll down to the signature page. So the point made to you was that as of April 2016, Mr. Markicevic was a director of MLI. Do you recall that?
Yes.
Would the SEC look at so as of which date would the MLI look at Mr. Markicevic's directorship at MLI potentially in connection with the 2017 transaction?
Can you please repeat the question?
Yes. Because in your previous answer, you stated that the SEC looks at information as of the date of the transaction. You recall that?
Yes, it basically it looks at the circumstances which are related to when the transaction happened.
And do you remember the date when the 2017 transaction happened?
2017.
Yes. So my question is,
Yes, on November 2017.
so let's assume that Mr. Markicevic's quality of the director of MLI is relevant. Would the SEC look into the fact that he's a director as of 15 April 2016 or as of November 2017?
Yeah, first of all, I would repeat that I do not find it really relevant because we're talking, and then I would say it would mostly be looking at the period around 14th November 2017.
Have you seen any evidence that Mr. Markicevic was a director of MLI in November 2017?
No, I have not.
Thank you. Now, my second topic is relating to the very last line of questioning about, let's say, what the minority shareholders of Obnova would have done and why in connection with the transactions. And with respect to the 2012 transaction, I believe you stated that the change in registered ownership from Mr. Obradovic to Kalemegdan was publicly available information. Do you recall that?
Yes, I do.
Could you remind us where that information was publicly available?
Well, it was publicly available on multiple places. It's at the business registry. It is at the Central Securities Depository. It is at the Belgrade Stock Exchange. In my opinion, most shareholders, when they're looking for that information, it's always at the Central Securities Depository. But you can find it at multiple public registries.
Was it also publicly available information that Kalemegdan is owned by Mr. Obradovic?
I think yes, but I'm not.
Not sure. But then there was a follow-up question that, and I believe you answered that it was not necessarily publicly known that, Mr. Rand was in control of it all and so on. Okay. So now I'm a minority shareholder And I see from publicly available information that the ownership changed from Obradović to Kalemegdan.
Okay.
And let's assume I do not know that Mr. Obradović controls Kalemegdan. What do I do?
Can you please repeat it?
Yes, I am a minority shareholder.
Okay.
I see publicly available information that it was this change from Obradović to Kalemegdan.
Okay.
Let's assume I do not know that Obradović also owns Kalemegdan.
Okay.
So do I think there was a change of control?
Yes.
And if I think there was a change of control, can I assert my rights accordingly?
Yes.
Have you seen any evidence that any minority shareholder
Yes. There are
asserted
many,
any rights in
Yeah.
connection with 2012?
yes. Basically,
transaction?
there are many things that you can do. First of all, in my opinion, shareholders would always go to the SEC, as that is obviously the most quick way to realize their rights, because in the court proceedings, it's really long in Serbia and it takes a while, but the SEC has huge authorities as an independent regulatory body and would be much basically quicker than the court. So first they would send a letter to the SEC asking to investigate. They could, of course, even if the SEC did nothing, or even in the case that SEC says there is actually no obligation to publish a takeover bid, you can still go to court in accordance with Article 41B and make your case there that there was actually an obligation to publish a takeover bid, and the court would investigate it no matter basically what the SEC said. As far as I'm aware, here shareholders did nothing.
Thank you. That concludes my redirect.
Thank you. There are just a few questions from the tribunal.
Right, well, thank you. Good morning, Ms. Tomic.
Good morning.
I have one that is a follow-up question that was just made to you. Obnova, I understand, is a company that is registered as public and the shares are traded, right?
Yes.
Under Serbian law, these companies have certain, the need to have certain information available to the public, correct?
Yes.
Not like a privately held company.
Yes, there are these applications that are bigger with publicly listed companies.
And if I go into the webpage or, there, I imagine I will find the key relevant information. There's some disclosure information and things like that I will find there. So
yes, basically you would find most of them at the Belgrade Stock Exchange. They need to always update their
Exactly.
information, financial reports and stuff. Yes.
Exactly. And I assume that one of the information that I will find there, who are the shareholders.
Yes, of course. Yes.
So coming back to the question that council was asking you. So if I realize that there was a change in the ownership, because
Yes.
now appears Kalemegdan as opposed to Mr. Branovic, I
Yes.
can go and find out,
Yes.
right?
Yes, definitely. And I mean, when you are like invited to the General Assembly and stuff, you will see basically who is inviting you, who is now a majority shareholder. So this is all information that is available. That is just my opinion, that minority shareholders, they become really engaged only when they see actual changes in the way that companies manage. They sense that the control changed, and then they start investigating basically into it more. But all of this information was publicly available to them in multiple places in regards to 2012 acquisition.
And you have also a year, as I said, the General Assembly, I assume is every year, and well,
Yes,
there's information of the company.
Yes.
So now I having said that, they would have realized that there was a proper change in control. For example, that
Yes.
someone else, not Mr. Obradovic, was
Yes.
the owner or the majority owner of Kalemegdan, right?
Yes.
So in that regard, I have a question. So you said that the purpose of the takeover law is to, protect minority shareholders in a case, a situation of change of control.
Exactly.
So if a party A, right, that controls a company, contribute to the shares to a party B, and then in exchange acquires the same amount of shares from that party B, and therefore effectively controls party B, right? So it's, again, you are the shareholder of a company A,
Yes.
shareholder A, and you contribute your shares to a company that is B, right?
Okay.
And you get shares from that company B. So what that means is control now company B,
Yes.
and through company B you control obviously
Yes.
the original.
So-
So you would say that in that case there is no change in control.
If A is now controlling B, no change in control.
No change in
Yes.
control.
Yes. Exactly.
Right?
Yes.
So my question is, and I was looking at the law, there is a few provisions, Article
Yes.
7, I was looking, where it somehow considered this precisely, that if there is
Yes.
no change in control because
Yes.
basically it's the same person.
Yes. Yes. You can-
Wouldn't that also be in this case the situation?
Yes, basically, there are situations when it's just a restructuring of
Yes.
a group of companies which are under holding. And I would say that this is also really similar situation to that. I'm not sure if, for example, Coropi would qualify as a holding under the Serbian whatever companies law or stuff like that. But it's obvious that in this case, also, like you said, and the law does say that if you have a restructuring within a holding, basically that is also exempted because there is no change of control.
Yeah, and actually I was looking at this number 7, right?
Yeah,
When it says that if you are a legal entity and you
Yes.
contribute your shares to another legal entity and are the same shareholders in the new legal
Yes.
entity.
Yes, yes. If it's the same shareholders, yes.
It's the same shareholder,
yeah, they
which
need-
is similar as
Yes,
well.
yes,
And I assume that the rationale behind is because at the end there is no
yes,
there is
yes, exactly,
there is no
exactly.
change in control.
Exactly, sir. There are numerous basically exemptions that because really the goal is to actually find the cases where there is a real change of control. And then you need to protect minority shareholders. I mean, the ratio legis for this in the takeover directive and then in the law is that shareholders buy these shares. They're only minority shareholders because they think that the company has certain vision, management and stuff like that. Then you have the change of control. That's not why they bought it. And because they're actually the weaker party, then you offer them some kind of protection by saying you now have the ability basically to opt out of that company because something changed which you had no control over. But if there is no change of control, then takeover law needs to capture those situations. That's when you need to protect minority shareholders.
And my question is, why would be the reason why, for example, something like number 7 would not apply? Is because technicalities or?
I think is basically technicalities, and we had basically many. For example, for that holding, you need, if you just go to restructuring within a holding, for example, if you go to basically Serbian companies law, it would say that holding needs to be registered as holding in Serbian basically registry. But I mean, all of these exemptions are trying to cover this situation, and mostly because of formalities or technicalities, you would apply one or the other.
Either you are here, you're there.
Yes, yes, yes.
Okay. And I had a lot of questions that I think you already answered, but I want to confirm. I understand that the SEC doesn't have the monopoly in terms of sanctioning these behaviors, like in some places where they do have the monopoly. It can be challenging court, but still has to be the SEC. I understand that here you can go directly to the court and request that the takeover will take place or request the fine. How it works?
in terms of the fine, in terms of the what the law grants to the shareholders is in 41B, where that covers the situation, for example, if the minority shareholder is not really happy with the SEC, that they did nothing, did not initiate, or they decided there was no. So it protects this right of minority shareholder and is basically accountability of SEC to the courts. So they can go directly to the court and say, even though there was never a decision, I think that there should have been a takeover attempt, and I would like this person that acquired control to buy me out, to buy my remaining shares of the company at the same price that he would have had to pay me if I actually published a takeover bid. And then the court would basically do full proceedings to determine whether there was a change of control and can actually give that right to the shareholder and order a person to buy them out.
And can request a fine as well?
Court could then, for example, that court could then send it to administrative and said there was an obligation here. We suggest
So-
you impose, yes,
send it back.
also fine, yes.
Okay, thank you very much.
Thank you.
Thank you. Just a couple of questions from me. Mr. Tomic, you mentioned in response to a Respondents' Council question about why you left the SEC in 2019 by saying that the capital markets in Serbia were not really developing. And that's at 9:26 this morning. And that suggests that you were dissatisfied with the way in which the SEC was fulfilling its mandate?
No, not really. I was not really dissatisfied with the SEC, but basically, if you look at the capital markets, if you take a look at Belgrade Stock Exchange, for example, it simply is not working. I mean, we have not had IPOs successful. We basically have all these companies which were privatized and by force put on the capital markets, and they do not belong on Belgrade Stock Exchange, and our strongest companies are not joining the Belgrade Stock Exchange. So it's completely dysfunctional capital markets, in my opinion, and we don't have corporate bond. We have basically nothing. And then I am sitting there because I was really working a lot on legislation and legislation related to innovations. And I drafted, for example, first laws on hedge funds and stuff like that. So I'm learning all of these things, transposing MiFID II, talking about high frequent algorithmic trading. And I was just learning a lot of these complicated concepts where I had no way to apply them in Serbia because nothing existed. We only had, I mean, I was like basically that current in SEC that said we need to put an end to this. All these companies that do not belong on stock exchange, they should not be there and stuff like. So I was just not happy the way capital markets were developing, and I felt that I spent a lot of my time learning really in depth all of these things, and basically there was not a market for that knowledge, in my opinion.
You were becoming frustrated.
Yes, I was becoming frustrated.
So there was no suggestion then, or let me put it to you, was there ever any concern expressed in the market that the SEC was adopting a rather loose policy of the application of the law in order to encourage acquisitions or economic activity?
I would say that if you ask market participants from my experience, and I think I was like basically the person that was open known in the SEC to be open to industry basically feedback. I think that the SEC was really strict in its interpretations most of the time, because in Serbia there is this really high dependency on the formality of the laws and form over substance and stuff like that. And when you have a body that is like the SEC that has huge discretionary powers, and we were, I would say, working there a lot of times afraid when we saw something, it's clear. For example, there is no change of control, but maybe you will go to court for corruption and stuff like that. So I would not say that the SEC was lenient basically at any time. It was really strict and had a lot of really formalistic rules. Like you can even see in the takeover law. directive only cares for true changes of control. And here we are saying if they at least once, why would they need to do takeover bid? I mean, in reality, why would there need to be a takeover bid for this to be exempt? We were saying, oh, let's give at least one takeover bid to shareholders, even though there is no change of control. So I would say SEC was never definitely lenient.
Thank you for that. But do I understand correctly from your responses to the previous questions that other than in circumstances in which there was an irrebuttable connection, or in which there was an objection or a complaint from a minority shareholder, it is unlikely that the SEC would have proprio motu undertaken an inquiry of its own?
Well, SEC would inquire if it had any way of finding out, but how the SEC actually finds out about changes of control? Mostly by, first of all, there are changes in the registry, which are, let's say, obvious and reporting to the SEC. But in reality, how the SEC would start on itself without minority shareholders, anything, it would actually be through those notifications of passing or going below the thresholds, because there you would capture less than 50%, basically, because the takeover law says 25% is enough for control, which is obviously, in terms of Serbia's capital markets, not really like that, where you have concentrated ownership because of privatization. But basically, that is how the SEC would capture it. Someone would have to tell you most of the time. We would definitely start investigating anytime, or for example, we saw suspicious activity on the Belgrade Stock Exchange. That would also maybe trigger us. But basically, reporting, notifications for minority shareholders, or the activity on Belgrade Stock Exchange, where you get a report that there is some suspicious activity.
So unless there was suspicious activity, someone would have to tell you, would have to alert you.
Yes.
You're an expert, so I'm going to ask for your view, but this is subject to the comforting caveat to you. I hope that as I think of the question I'm about to put to you, it seems to me that there is going to be some complexity which I don't need you to unpack. There was obviously, in the case of the 2017 10% acquisition by Mr. Broshko, there obviously wasn't a triggering activity. But I understood your earlier testimony, let's see if I've understood it correctly, to say that if there was a concert between Mr. Broshko through MLI and Mr. Rand, that would have triggered a takeover obligation.
If they were acting in concert
Yes.
in an agreement, they wanted to say, let's increase control.
Whatever the reason, if they
Okay.
were acting in concert, that would have triggered a takeover obligation.
Well, in accordance with Article 4, paragraph 1, if we can put it in there, it says that that effort needs to be basically either to acquire a shareholding, to change management, or I cannot remember what was the third one in Article 4, paragraph 1.
I'm again not so focused on the detail, and let me stress that I am not implying that that we have any view that they were acting in concert. I'm just trying to establish that if they were acting in concert, that would have triggered, at least an inquiry into the application of Article 4.
Yes.
So and again, appreciating your evidence about the consequences of failing to launch a takeover bid. But if this tribunal were to conclude on the facts before us, which would not necessarily have been facts before the SEC, that Mr. Broshko and Mr. Rand were in fact acting in concert, then it sounds to me that you would accept that we were in Article 4 territory, and that the tribunal would have to address its mind to the evidence that you have given about the application of Article 4 and so on.
Yes, it's Article 4, definitely.
Thank you. Now, you say in your first witness statement at paragraph 14, I don't need to take you to it, that you served as a legal expert to the claimants, and by that I understand to mean you served as an expert witness in the Rand investment proceedings.
Yes.
Now we have, I think, 5 or 6 documents on the record from the Rand investment proceedings. We do not have your witness statements on the record of these proceedings. What was the scope of your expert testimony in the Rand investments case?
I was also, and please, someone remind me if I missed anything, but
No one's going to remind you.
It was,
Yes.
it was some while ago, but it was also mostly takeover law. I think in that case, most talking also about the obligations to publish a takeover bid. And I was also saying that in terms of takeover law, I was arguing that Serbian law does not recognize only nominal shareholding, but that we also have a takeover law, which is now trying to capture, I would say, the spirit of beneficial ownership, because it does not concern itself only with who is like manager in the registry or who has the nominal shareholding. Takeover law actually tries to capture the essence and relationships above that reality. So in a way, takeover law actually acknowledges some effect of beneficial ownership in Serbian law. That was my...
Was your expert testimony in that case challenged by expert evidence on the other side?
Yes, there was also expert witness on the other side.
May I simply, for counsel's benefit, but perhaps also for your benefit, ask the council to please call up CL 112, which is the Rand Award. And could we go to paragraphs 392, please, and 5? And if you could just give the witness an opportunity to read paragraphs 392 and 393, please.
Okay.
Yes. So hopefully that's refreshed your memory a little bit.
Yes,
yes.
It's coming back to me.
Yes.
Okay.
I'm just interested in the sentence in the middle of paragraph 393, where it says, this is the tribunal's finding, indeed the testimony of the claimant's expert, Ms. Tomic, according to which Article 37 could not be applied retroactively, has not been cogently rebutted. And moreover, and in any event, as observed, only violations of fundamental rules would deprive the tribunal of its jurisdiction in Serbia, etc. I just like to ask you whether, in your recollection, and we won't hold you to this, and I'm going to be putting question to counsel on this basis, but whether your evidence in those proceedings, first of all, overlapped with the evidence that you are giving here with regards to the consequences of these rules, whether they are relevant to these proceedings, and whether your evidence then is consistent with your evidence now.
Yes, it is consistent, and basically it was the same. The consequences to issue a takeover bid, they were practically the same. What was different there?
You don't have to scratch at your memory.
Yeah, I'm just trying to remember what was. It was similar, but it was that in that case, if I remember, they did not have an obligation because they're acting in concert, and they did not have transactions after the laws were amended, so that persons in concert need to issue a takeover bid even if they did not. Basically, they happened before this rule that we are talking about. So persons acting in concert, if they did some transactions, they did not have to issue a takeover bid. I think that, if I recollect well, that was the difference, basically.
Thank you very much. Those are all my questions. Before I pass back to council for any redirects on this basis, let me just thank you for that response, but it also explain both to you and to council for both parties that the reason for my putting this particular question to you is that, as you probably recall, we've asked the parties to assist us with their views on the relevance, if at all, on the overlap between the RAND Investments Award and the issues engaged in these proceedings. And I wanted to elicit some response from you so that council will be able to address these issues. And let me say to council, nothing will be taken against you if you don't put redirect questions to the witness on this particular issue, because I am going to, or the tribunal is going to invite you to address these issues in submissions on Friday, and we are also going to be inviting you to submit into the record of these proceedings the record of the RAND proceedings, because you've, I think, already put in half a dozen documents, but not all of the documents, and there is constant reference. So I think that we would like to see that evidence so that we can form for ourselves the relevance. So with that said, let me pass back to Respondents' Council to see if there's any redirect on the basis of the questions that the tribunal has put to the witness.
We reserve our right to address this in Friday's submissions.
You'll be able to address this. I'm gratified to hear it's submissions now. You of course can reserve your right, but the question is, do you have any redirect to the witness?
On the RAND award?
No, just generally on the basis of the questions that the tribunal has put to the witness. Don't feel compelled.
I had one question, Ms. Tomic, just to go back to the query regarding the 2012 acquisition and whether or not the minority shareholders would have been aware of Mr. Obradovic and Kalemegdan's acting in concert. As you're aware, Kalemegdan is a Cypriot entity.
Mm-hmm. Yeah.
So to ascertain the relationship between these two individuals, they would have to presumably go to the Cypriot
Yes, for me,
register?
yes. So for me, they knew what they needed to do to know the most if they wanted to react. They knew there was a new nominal share, a new nominal majority shareholder. For all the other information, they would have to go to foreign registries to know about Mr. Rand. So I think in reality, they did not investigate because nothing changed. My answer there remains the same. They had at their disposal in all public registries information that there is a new majority shareholder, that is Kalemegdan, in order to learn about these other, like you said, about these other connections, which showed that there was no real change of control. They would have to do some basically further investigating, but they did not do it that's just my guess, because they saw that nothing changed in their reality of that one.
And then just to go back to the Rand case, you mentioned that the scope of your opinion in that arbitration covered beneficial ownership
No,
or
not
nominal
really.
ownership.
Yeah, not really. I was not really opining on beneficial ownership per se. There was a different expert witness. I was just showing that in takeover law, it is recognized that there can be actually consequences imposed by Serbian law, even if persons are not nominal shareholders.
As you might be aware, Professor Lepetić also just discusses the topic of equitable or beneficial ownership of shares under Serbian law in her reports.
Yeah, I'm not an expert in that.
And you were not asked to
No, I was not asked.
opine on that. Okay, thank you. Those are all my questions.
No questions, Mr. Chairman.
Thank you very much. I think that draws your evidence to an end, and thank you very much indeed for assisting us. And no doubt we will get the opportunity to read your testimony some years ago as well, but you are excused from the witness stand.
Thank you so much.
Council, you have you've heard the sort of additional point about this this witness's contribution in the Rand case. We'll come back to that in our questions. I think in terms of timing, we are happily more or less back on the record, or back on the schedule. I'm going to propose that we take the coffee break, and that this time that we do take the coffee break for the full 30 minutes, because it will allow the tribunal an opportunity just to finalize the questions that we want to put to you on an interim basis. So we will reconvene at 11:30 for the respondents expert, this time Dr. Lepetić. Is that correct? Yes. Thank you very much. You all connected? Right. Well, while you're sorting that out, let me just say to both parties that the Tribunal Secretary will momentarily send to you by email a list of questions. There are 23 questions as a beginning. I propose to walk you through the questions in the housekeeping at the end of the day, so that if you've got any questions or clarification, we can address that. Then. No point of housekeeping from either party at this stage. No. Well, then let's move on to the evidence of Professor Lepetic. She can be invited to the stand. Welcome. It's a different seat from the seat you've been sitting in up until now.
Yes.
You should have the expert witness attestation in front of you.
Yes, I have only one.
You have it?
Yeah, I have only one witness statement. There should be.
Well, it's not the witness one, it's for the experts. You should.
Yes.
You have that available?
I have only one.
Sorry.
And
It's only one, but it's.
It's
No.
both of them.
It's the declaration, the expert witness declaration.
Okay. Expert declaration. I thought that you are asking me about.
Yes, could you
Okay.
read that into
Yes,
record,
thank you.
please?
I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere beliefs.
Thank you very much. Let me hand you over to Respondents' Counsel just to take you to your witness statement and check whether there are any corrections and things like that.
Thank you. Professor Lepetic, so before you, there's the binder. Could you please confirm that all three opinions of yours are in there?
Yes.
Thank you. Do you have any corrections to make?
No, I don't.
Thank you.
You to make your presentation.
Yes, thank you. I will start with a short introduction. I'm an associate professor at the Faculty of Law, University of Belgrade, where I teach company law and insolvency law in Serbian and EU company law in English. I'm also an active arbitrator at the Serbian Chamber of Commerce. I'm an active associate of several international and domestic associations of lawyers. And I'm also an author of several books and articles on the matters covering company law, capital market law, and insolvency law. And I would now like to start with my presentation. So to start with, the matter of takeovers in Serbia is regulated by the 2006 law on takeover, which was subsequently amended 3 times. Firstly, in 2009, second time in 2011, and third time in 2016. The 2011 amendment is referred in my reports as the 2012 takeover law, because although the amendment is adopted by the parliament in 2011, it came into effect at the beginning of 2012. This law sets the rules regarding the arising of the obligation to launch a takeover bid. This obligation arises when certain thresholds set by the law are exceeded. The first one, which is relevant for the case at issue, is the control threshold. It is related to the 25% of voting shares. Also, other thresholds is relevant for the obligation to launch a takeover bid. So when an acquirer acquires more than 10% of voting shares, which is called additional thresholds, he will again have an obligation to launch a takeover bid. And finally, which is an exception, even if the acquirer acquires less than this 10% of voting shares, he will still have the obligation to launch a takeover bid if the final thresholds, which relates to the 75% of voting shares, is reached. So just to clarify, in all of these cases, it doesn't have to be the change of control. So, for example, as you may see, the additional threshold, which is 10% of shares, does not have to be related to the change of control, and especially not the final threshold regarding exceeding the 75% of voting shares. These thresholds, especially the control one, is very low because the Serbian capital market is very undeveloped, and the majority of the acquisition occurred in Serbia are actually related to privatizations. And the legislator wanted to give the opportunity to the minority shareholders, which are often employees of these privatized companies, to sell their shares, to have this option. So if the acquirer exceeds any of these control thresholds, he is obliged to make a notice of takeover intent, to publish it also, and to send it to the Securities Commission and to the other relevant institutions within 1 or 2 working days, depending on which of the laws apply. Subsequently, he is also within 15 working days obliged to make an application for an approval of takeover bid to the Securities Commission. So the Commission is the one who has to approve this obligation, and afterwards the takeover bid should be launched. Please, next slide. It is very important whether the acquirer acts independently, individually, or by acting in concert with other persons, because our law sets the rule that each of these persons who act in concert have an obligation to launch a takeover bid. This is because the legislator equated the establishment of this relationship with the acquisition of voting shares. Acting in concert is clearly defined in Article 4, Paragraph 1 of the law on takeover, according to which provision person acting in concert shall be the persons who cooperate among themselves or with the target company. These were raised by the 2016 amendment on the basis of the agreement, which might be express or tacit, either oral or written, this is important, aimed at acquiring voting rights, exercising voting rights in concert, or frustrating the successful outcome of a bid of another person. Please, next slide. There are 3 important consequences related to non-compliance with the obligation to launch a takeover bid. The first one is related to the suspension of the acquired shares, and not only of these acquired shares, but all acquired shares by the acquirer, according to the Article 37 of the law on takeover. So this is a serious sanction, and so there was no need to prescribe that, for example, the transaction is null or void, because the idea is to make impossible for the acquirer to exercise these voting rights. The second, again, very serious consequence is that any shareholder of the target company may request redemption of shares in court proceedings under the conditions which would apply if the takeover bid had been launched. So this is the basic idea of the law on takeover, where we see the manifestation of the need to protect the minority shareholders in the cases when some acquisitions occurred. And finally, there is a fine for economic offense. The range is between 1 million and 3 million dinars for this economic violation, which is committed by the legal entity which did not launch a takeover bid, although it was obliged to it by the law. When the Commission explores and investigates and finds out that there was this breach of law, it has to submit a request to the public prosecutor, who will then, of course, act, and the proceedings will be managed by the commercial court. This is very exotic because the court will apply the criminal proceedings law when something is not regulated by the law on economic offenses. So the Commission has only the obligation to submit a request to the public prosecutor. So those are these consequences. Now, I addressed 2 acquisitions of Obnova shares in my reports. There were 3 reports that I have drafted. The first acquisition was a result of the in-kind contribution, and it occurred in 2012. And the second one is the result of the purchase of shares on Belgrade Stock Exchange in 2017. Now I will first address the 2012 acquisition. In this acquisition, Kalemegdan acquired approximately 70% of shares in Obnova. We saw that as a contribution in kind made by Mr. Obradović, so natural person to the legal entity who became a new shareholder of Obnova. Since 70% of shares was acquired, it is undoubtful that the control threshold, which relates to the 25% of voting shares, was triggered in the case at issue, according to the 2012 law on takeover. None of the exceptions applied, including the one provided in Article 8, Paragraph 1, Item 11, since the takeover bid has not been carried out previously. This is the exception which is mentioned in the reports of Ms. Tomić-Brkušanin. I would add here now that also the exception regarding the restructuring within the holding and also the transfer of shares between different companies may not be applied, which is one of the enlisted exemptions in the Article 8 of this law, because here the transfer occur between a natural person, Mr. Obradović, and Kalemegdan, which is a legal entity. Therefore, my conclusion is still the same, and neither the acquirer nor the person with whom the acquirer acted in concert, which are actually Coropi and Mr. Rand, which is again not disputed by Ms. Tomić-Brkušanin, launched a takeover bid, and Kalemegdan was obliged to launch a takeover bid because the control threshold was exceeded. Since none of these persons who acted in concert launched the bid, the 2012 acquisition was not in accordance with Serbian law. Could we please now move on to the 2017 acquisition? Thank you. In 2017, Mr. Broshko acquired 10% of shares in Obnova through Maple Leaf Investments, the company that he owns. And according to the applicable 2016 law on takeover, it is undoubtful again and confirmed by Ms. Tomić-Brkušanin that the obligation to launch a takeover bid would have arisen if Mr. Broshko acted in concert with Kalemegdan, Coropi, and or Mr. Rand. In the first and the second reports that I drafted, I considered only the scenario where Mr. Broshko was considered as a director of Rand Investment. So I will now address this scenario. If Mr. Broshko may be considered a director of Rand Investments, there is an irrebuttable presumption that he acted in concert with Rand Investments, Coropi, Kalemegdan, and Mr. Rand. This is in accordance with the Article 4 of the Takeover Law, which sets many presumptions, irrebuttable presumptions, when the persons are acting in concert, and also unless certain circumstances which has to be especially considered by the Commission, whether there was or there was not acting in concert. Of course, that the Commission may take into consideration other circumstances as well. This Article 4 actually, from the 8 paragraphs in total, has 5 paragraphs which relates to sets the irrebuttable presumptions. This article has to be interpreted entirely, in totally, because it would be completely inefficient and illogical to interpret only a paragraph separately by paragraph. This is something which is called in the Ms. Tomić-Brkušanin report as chaining. I would not call that chaining. I have never seen that term in any of scholarly writings. This is just the interpretation of the entire article. I will just give a few simple examples why this is needed to take into consideration not one presumption, but many, two or more, because in many situations, not only a legal person, but also natural persons are involved in the transactions, and the relationships between the related parties who are natural persons is based on the kinship. If the relationship should be based between the legal entities, of course, that the relationship is based on the control. But there are also situations when there is a legal person which act in concert with a natural person. For example, if you have two companies and these two companies have a managing director who has a spouse, and in order to just not be obliged and to skip the obligation to launch a takeover bid, the controller of these two companies asked the managing director to ask his wife to establish a company in order to acquire the shares, which are already acquired, some other shares by those two companies which are related. So if we have control of the two companies and the person, for example, natural person, asks the managing director to establish a new company, again, we will have the links, we will have many companies who are related companies and who are under control of the same, for example, natural person. Of course, that the idea and the whole logic of the rebuttable presumption is to enable the Commission just to see and not request for the proofs and how to prove how all these that all these persons act in concert. Of course, that if persons are related persons, based on the fact, for example, that they are controlled by the same persons, all of them, including the person who controls them, the natural persons, will be persons acting in concert. And definitely, if A and B are related party, the idea of the presumptions is to relate C to A. This is the whole point of it. In any other scenario, everybody, of course, would be easy to escape the obligation to launch a takeover bid. There is no afraid that this will involve too many persons. As I already said, Serbian capital market is really undeveloped. If you see, for example, prime market at the Belgrade Stock Exchange, there are only 5 issuers in total. So having so many people involved to acquire shares in the same companies, this is really not a realistic scenario. In the third legal opinion, I consider the different scenario when Mr. Broshko may not be considered as managing director of the RAND investments. So even in this scenario, there still are some indications, some circumstances which indicated that Mr. Broshko, through Maple Leaf Investments, actually acted in concert with Coropi and with Mr. Rand and Kalemegdan. So this analysis doesn't need the involvement of the Rand investments. So these are different scenarios, but in any of these, my conclusion is that Mr. Broshko acted in concert with these persons. So can we please move to the next slide? And just to, again, I didn't say this, sorry, just to add this, since none of these concerted parties launched takeover bid, the acquisitions of this 10% of voting shares of Obnova was not in accordance with Serbian law, and none of the exceptions applied. And finally, I will just say a few words about the legal effect of trust deeds according to Serbian law, which was not actually discussed in Ms. Tomić-Brekušanin reports. As a matter of Serbian law, Coropi may not be regarded as a shareholder of Obnova as a person who has a shareholder's rights in Obnova, of course, on the basis of the trust deeds. This is because Serbian law system is a civil law system. And I will just quote two famous professors, Serbian professors, Professor Stankovic and Professor Orlic, and the most famous manual still used at the Faculty of Law and every Faculty of Law in Serbia, that two ownership rights cannot exist on the same asset at the same time. And also, this is again logical that the trust may not be created according to the Serbian law. Trusts are mentioned in some of the Serbian laws, but just to note that this exists in the foreign laws, that this is a foreign law person. You can see here the example of the law on the prevention of money laundering and the financing of terrorism in Article 3, Item 4, which says exactly this, that a foreign law person means a legal arrangement which does not exist in domestic legislation, for example, trust. These are the words of the law. The only definition of the shareholders which is relevant for the establishment of ownership of shares is the one provided in the law on companies. You can see that according to Article 249, it is considered that a shareholder in relation to a joint stock company and third parties is a person who is entered in the central registry as a legal holder of a share, and the day of the entering in the central registry is the day of acquiring the share. And we came to my last slide, please, the final slide. Indirect shareholder, also beneficial shareholder, ultimate shareholder. This is all mentioned in various Serbian laws. I gave some example in my reports, for example, law on prevention of money laundering and financing of terrorism, the law on taxes of legal entities, even the law on takeover, which I also mentioned, the indirectly acquisition. But any of these laws do not confer any rights to these persons. These notions, these terms, these words are mentioned and included in the law to enable for the legislator to set the obligations for these persons, to enable the transparency, to enable, for example, the independent auditing. This is now the law on capital market that I am mentioning now. So in any of these laws, for example, to prevent also the money laundering and preventing the terrorism, you have also the law on the central register of the beneficial owners. So the idea is to find, it is almost always the natural person, not the legal entity behind all the legal entities which are involved in some transaction to prevent, for example, money laundering. And I would conclude with this, that any reference to Coropi as direct beneficial owner of Kalemegdan's share and indirect beneficial owners of Obnova shares may be related only to the possibility of imposing obligations on Coropi in accordance with the law, and cannot lead to conclusion that Coropi has rights as an owner of Obnova's shares, of course, according to the Serbian law. Thank you.
Thank you very much indeed. I think without more ado, I'll pass you to Claimant's Counsel for cross-examination.
Mr. Chairman. Good morning, Professor Lepetic. My name is Rostislav Pekas. I am counsel for the claimants, and I'll ask you a few questions regarding your three reports and also the presentation that we saw today. I would actually like to start on the presentation, so we will just wait until the systems take note of the change of control. And my question will relate to your last slide.
Yes.
On your last slide, you state that, which relates to the issue of beneficial ownership.
Yes.
And on the last slide, you state that as a matter of Serbian law, Coropi is not an owner of shares in Obnova and is not entitled to any rights deriving from these shares. And my question is the following. So as a matter of Serbian law, which entity is the owner of Obnova?
As a matter of Serbian law, it is the entity which is entered in the Central Depository Registry. And as I know, the owner of Kalemegdan shares, actually Kalemegdan shares, Kalemegdan is the entity registered in Cyprus, as I remember. If
No.
you are asking me for the Kalemegdan.
No, I was asking you about Obnova.
Obnova, it is the Kalemegdan, of course. If it is still, I don't know, are you asking me regarding the acquisition, the period of acquisition, or now? I have not checked the register today, I have to admit that. So at the time, it was Kalemegdan, since it was registered as an owner of Obnova shares, if I am right.
Mhm. And that would be also because the 2011 acquisition was a valid way of acquisition of the Obnova shares by Kalemegdan, correct?
Yes, this is without any doubt. This was a lawful way of acquiring shares. So contributions in kind are completely lawful way to acquire shares.
And shares, so under Serbian law, obviously, shares acquired by in-kind contribution are protected just exactly the same as shares purchased on the market, correct?
Yes, that is correct.
Or purchased through a over-the-counter direct transaction, correct?
That is correct again.
Now, you, in your opinion, the 2012 acquisition was unlawful because the obligation to launch a takeover bid was not respected, correct?
Yes.
Assuming that your opinion is correct, that still would not have any impact on the validity of the acquisition and on the existence of Kalemegdan's ownership of the Obnova shares, correct?
No, I stated exactly that in my opinions. So definitely the transaction itself, the transfer of the shares would stay valid, and it is valid.
Mhm. And would you also agree with me that, again, under this scenario, Kalemegdan would still be entitled to dividends, liquidation surplus,
Yes.
and this kind of economic benefits
Yes.
related to ownership of shares?
Yes.
I would now like to discuss the 2000 and actually now, and there also is the 2017 acquisition, where you state that Kalemegdan and some other entities, and we'll come to that later, had an obligation to launch a takeover bid as well. And again, your opinion is that this obligation was not complied with because no takeover bid was launched at the time. Would the failure to launch such a takeover bid have any impact on Kalemegdan's ownership of Obnova's shares?
No, the answer is the same, because there is no idea even anywhere in the scholarly writing that the transaction itself should be null and void.
Mm-hmm.
The idea is to prevent the acquirer to use its voting rights. And of course, there are other sanctions which we talked about, but it is never nullity of the transaction, and it should not be, according to my opinion.
Yeah. Yeah, and again, just to clarify, even though you've answered, that would also apply to Kalemegdan's right to dividends, liquidation
Yes.
surplus, and these economic
Yes.
rights.
Yes, because he's a shareholder.
Mhm.
A shareholder, of course, has a shareholder's rights.
Now, just to exhaust this topic entirely, we know that in the 2017 acquisition, that was an acquisition of approximately 10% of shares by a Serbian company whose name I will abbreviate as MLI, owned by Mr. Broshko. So again, the acquisition of the shares by that company would be valid regardless of the claimed non-compliance with the takeover bid obligation.
That is correct.
And the same would also hold true for the right to dividends and liquidation surplus. and
That is
other
correct.
economic benefits. Mhm. Thank you. So now I would actually, since we finished with the 2017 acquisition, I would start with that, and we will come to the 2012 acquisition in a moment. If you could please refer to page 18 of your first report. There is the title of section 2, which states Mr. Broshko, i.e. MLI, Kalemegdan, Coropi, and Mr. Rand were obliged to launch a takeover bid in 2017. We will pull it up on the screen.
Because I didn't find it.
Yeah,
Aha,
so it's
60.
right above paragraph 61. Can you see
Okay.
that? Yeah, so
Okay.
is it that each of these entities had that obligation to launch a takeover bid?
Each of these entities, do you mean also Mr. Broshko? Because he is not an entity, a natural person, as I would say.
Yes, I also mean Mr. Broshko.
Yes, because Mr. Broshko indirectly acquired the shares. That is what we actually mentioned a minute before regarding the first slide. So the acquisition, of course, involves not only direct acquisitions, but indirect acquisition in order to make the obligation to launch a takeover bid regarding these persons. Again, the obligations, not the right. So yes, Mr. Broshko, because he purchased the shares through Maple Leaf Investments, and did I mention here someone else in 61? No.
Okay. So and that, in your opinion, that obligation arose because these entities were acting in concert, correct?
Not these entities. So Mr. Broshko is indirect acquirer, and Maple Leaf Investments is a direct acquirer. And Mr. Broshko, as an indirect acquirer, and also, again, Maple Leaf Investments as a direct acquirer, were concerting parties, were acting in concert with these other persons, which are not mentioned here, but which I refer to in my statements, which are Coropi, Kalemegdan, and Mr. Rand. And of course, I'm mentioning Rand Investments in the scenario when Mr. Broshko may be considered as a managing director of Rand Investments. In the scenario when this is not a case, I'm not, of course, mentioning Rand Investments.
Okay, so I apologize, I maybe misspoke, because when I refer to these entities, the entities I had in mind are those which are listed in, here in the title.
You didn't, okay, yes, of course, all of these entities, and including Kalemegdan, of course, because the whole idea is Kalemegdan already acquired through in-kind contribution by Mr. Obradovic 70% of voting shares. And now Mr. Broshko indirectly acquired 10% of shares of the same company. So in Obnova company, we are talking about it. So 70% of shares plus 10% of shares is 80% of shares. And 80% of shares is more than 75% of shares, which is related to the final threshold, which I mentioned, which is, of course, regulated by the Article 6 of the law on takeover. So that is why, of course, we have to take into consideration Kalemegdan. And I skipped to say this because I thought that you are referring me to the paragraph 61. So I hope that now I'm clear.
So we understand that this is because the thresholds were reached. So I think we can put that issue aside. You state here that Coropi also has an obligation to publish a takeover, or had an obligation to publish a takeover bid in 2017, correct?
Yes.
So why was that?
Because, again, Coropi is the company who exercise control. We hear that many times here. I think it is not doubtful, who exercise control over Kalemegdan. And according to Serbian law, there is also an irrebuttable presumption that the company, the legal entity, or the natural persons who exercise control over other legal entity is the person who acts in concert with that particular company. Since Kalemegdan has acquired 70% of shares, of course, it is relevant who is controlling Kalemegdan, and we are now adding the shares acquired by Mr. Broshko to this. That was the idea.
Yeah. So I suggest that we now look at the text of this Article 4,
Okay.
which we can find in document C 560. So first of all, you recognize that provision.
Of course.
Yeah. And so I'll just read it out loud for everyone's benefit. Persons acting in concert are persons who cooperate mutually or with the target company. That was deleted, we know, later on. Based on an agreement, explicit or implicit, oral or in writing, the aim of which is acquisition of shares with voting rights, mutually agreed exercise of voting rights, or preventing another person from carrying out a takeover procedure. Then that's an accurate translation of the Serbian.
Yes, it
provision.
is.
Yeah. So the acting in, would you agree with me that the acting in concert here is defined as acting in concert with a specific goal?
Yes, for example, acquisition of shares with voting rights, which is the matter here.
Yeah. So the acting in concert must specifically pursue the goal of acquiring shares with voting rights, correct?
Yes,
Or it can also have the specific aim of a mutually agreed exercise of voting rights, correct?
correct.
Or it may have the specific goal of preventing another person from carrying out a takeover procedure, correct?
Correct.
If persons act in concert, and now I'm not referring, I'm just saying acting in concert for some other goal, that would not fit in the definition of Article 4.1, correct?
Correct.
And therefore, whoever wishes to establish that there is acting in concert in accordance with this provision of Article 4.1 needs to establish the existence of one of the three qualified goals, if I may call it that way.
Yes, but actually those would be the facts of the case. If it is the matter of the acquisition, it is easy to say whether there was an acquisition or not. So it is a fact.
No, but well, there has to be acting in concert specifically with the acquisition. So the two have to agree, let's acquire shares, no?
Yes, of course, but this agreement, as you can see and you have read it, it is explicit or implicit, oral or in writing. That is why we have presumptions, because it is almost impossible to prove that somebody actually had an oral agreement. For example, I will give you the money, or I will not give you the money. I will repay sometimes, maybe never, to establish a company, for example, and use that company to acquire shares in some other company. Since if you do not do that, for the commission, it will be easily to see that I already, for example, again, exceeded some threshold and that I am, for example, obliged to launch a takeover bid. This is actually the essence of this Article 4.
Professor Lepetich, I will turn to the assumption or rebuttable presumptions in a second. Just
Okay.
now let's focus on, let's say we are in a situation where where no irrebuttable presumption applies.
Okay.
So in that case, if no irrebuttable presumption applies, whoever wishes to establish the existence of acting in concert within the meaning of Article 4.1 needs to establish that there was acting in concert specifically aimed at the acquisition of shares with voting rights, correct?
Yes, and that is why if we are not talking about the rebuttable presumptions, there are other circumstances which the commission can or is obliged to take into consideration when analyzing this. Again, just to make it more easier for the commission, because as I already said, you have to prove that somebody actually agreed that they will acquire of shares with voting rights, and only one of them appears in the register. So you don't have to know anything about some other persons who are behind the whole transaction. So that is why I'm saying this is really not easy. And that is why this article is very helpful, and it should really be analyzed and interpreted entirely.
So you are advocating for some holistic interpretation.
Of course, this is the only kind of interpretation that is known to me. I'm not used to interpreting provision by provision, if not looking at this whole article. So I think it is quite regular kind of interpretation.
So I will just, give you an example.
Okay.
And again, we are in the world where the irrebuttable presumptions do not exist.
Okay.
So I am the owner of a company. Let's say, let's not discuss the threshold. So let's say I'm a 70% owner. Yeah? And then I have a manager in the company who purchases 10%.
Okay.
Is the mere fact that he bought the 10% shares sufficient to conclude that we are acting in concert?
It can be a real, let's say, indication, because of course there are many other rules which would apply to that situation that you said. First of all, it is conflict of interest. It would be expected, for example, that the company should, for example, approve that particular acquisition. And of course, there are many other, but I will not, it is again, why he's purchasing or that managing director. So definitely this would be an indication.
Yes, it's an indication, but in itself, it is not sufficient to establish the existence of acting in concert, correct?
For the commission, if the commission is convinced that this circumstance, for example, alone, which I don't think that this is the case, the commission may come to this conclusion. It is not forbidden. But if I would be the employee of the commission, I would possibly try to look for also something else, if you are asking me personally. But according to the law said the commission especially takes into account this, this, and this. You can also take into account many other circumstances, and that is all. Because the whole idea is that the commission, for example, it will not find out something like that. It will not be possible. For example, if it is a foreign entity, the commission is hard that it will look at some foreign register. Maybe they don't know the language, to see who is the managing director. Is that the managing director of this company? When he was the managing director? Is the archive also available in that company? That is why I'm saying. So it depends, but it could be, but it doesn't have to be. That is the honest answer.
And and we may scroll down to this paragraph actually, which introduces the additional criteria that the commission shall take into account. And this is this, this is the last part.
Paragraph 8,
yeah, I'm always puzzled by the Serbian custom not to number these subparagraphs, but okay.
We are used to it, sorry.
Let's make sure that people can count at least to 10, because they exercise that quite often. Oops.
Sorry.
Will be. I don't know what's going on. I'm sorry. Okay, good. You just need to kick the device and it seems to work. That's why it's called hardware. So if we look at this paragraph 8, we can see that it speaks of the commission. So the commission makes the determination.
Yes.
And I have two sets of questions relating to this. So first of all, is the commission's determination reviewable in courts?
Yes. Actually, I have, let's say, great knowledge about that because just recently I have published an article where I reviewed all the decisions of the administrative court. Almost half of them were related to takeover, which were decided by the administrative court. And now it is published. You can find this. It is European Business and Organization Law Review. It is in English. It is well-known ranking journal for corporate law. So definitely the court may do that. But the problem with Serbian law, again, which I have to admit, is that the jurisdiction is within the administrative court. And the administrative court, who is used to deal with the elections, for example, I have to admit, does not maybe have enough knowledge and experience regarding the issues of capital market law, unfortunately. So in practice, in all the court decisions that I have seen, you will be surprised, and I was surprised, there was no definition, nothing about acting in concert. So the court always accepted what the commission said because they just couldn't go into details. They always just used the procedural issues to reject, for example, or to approve the claim. So that is happening in practice. So I'm certain about it because I told you I have reviewed all the decisions, and there is only 41 of them till 2 years ago when the court gave me all the decisions. Just of course, not to mention any details regarding the parties for the academic research. So, and you can see the results of my research.
Then the court is not bound by the commission's decisions, is it?
No, no.
So maybe one day when the court is better educated, they might disagree with a specific decision.
Actually, there is a huge discussion in French law also about the authorities, but this is now, let's say, an academic topic, but still, if you are asking about the discretionary powers of the authorities, such are Securities Commission and especially national banks. And with regard to the national banks, and also in Serbia, it is said that the administrative court, and this also is related to the Securities Commission, may not give any decision in something which is called dispute in full jurisdiction. I know maybe actually you are maybe familiar from your jurisdiction about this. I am aware that in Poland also there is completely the same results and the completely same law, which I was surprised to see, but it is the same in Serbia, which means when the commission has some discretionary powers, but there is a problem, what is discretionary to the commission? This is the first step. Then the court may not go into it and make a decision which will actually completely replace the decision of the commission. Or if the commission was silent, failed to decide, the court would not be able to deliver this decision. So only when there are discretionary powers. But the problem is that we don't know what are the discretionary powers sometimes. It depends on the wording of the law. So in practice in Serbia, what we see is that definitely what the commission would say that it is acting in concert, I think it would be accepted and even not so much discussed by the court, unfortunately. There are, of course, other kinds of proceedings. We mentioned today, and there are many proceedings actually before the commercial courts regarding the redemption of shares. And mostly those are the cases.
I'm sorry, I will interrupt you now because I think that we have moved off topic. So would you agree with me that as of today, these considerations have not been put in practice in Serbia to the extent of the full jurisdiction or
For the full jurisdiction, it is certain that the court may not deliver a decision which will replace the decision of the commission, but maybe others are not familiar what this means. That means that the court will actually act like an administrative authority, deliver a decision. It is not like a classical court decision.
Professor Labic, I was asking about Serbia.
Yes,
Today.
in Serbia today, we are talking about that.
Yes, but can an administrative court quash a decision it disagrees with?
If it quash the decisions, he can, of course, quash the decisions if he agrees with the arguments put in the claim. Of course, that it can, and it will return the case to the commission to make a new decision.
Yes.
Of course.
And the reasoning of the court will be binding on the commission.
Yes, it will be. But in practice, we have things that it is like ping pong, that the court is again delivering a new decision, again returning the case to the commission, and the commission does the same or something similar. So in practice, it is not that great as it may seem on the paper.
But and now there's one thing which puzzled me when I saw this specific wording of this subparagraph or paragraph 8 of this article, because it says what the commission takes into account.
Yes.
And for example, when I was putting to you the hypothetical and the question whether the simple fact of acquisition would have or would not have been sufficient, and you said that in your opinion not, but the commission has the power, or the employee of the commission dealing with the matter basically has the power or the possibility to think that this is enough. You recall that exchange?
Yes, I recall that.
So the one thing which is puzzling me is that how do I know whether I act in concert or not if it ultimately depends on the assessment of the commission, which takes into account some circumstances, and I have no way of knowing beforehand what their assessment will be?
The legislature thought about that. If you would look at the long capital market, you would see that the commission has among its competencies, authorities, it is giving the interpretations of the law. So you would make a request, you would pay a fee for the commission, and you would say, company A is acquired already some percentage of the share. The director of this company plans to acquire the shares of the same company. Would this apply? And the commission will definitely reply, and you will be able to know what the commission will do, which is really fine. And this interpretive opinions of the commission are important with that regard. So anyone, I didn't mention that, have an opportunity to ask the commission whatever he wants regarding its authorities.
Would you know how many of these requests the commission gets a year?
Actually, I don't know, but there are several of them because when I was preparing the drafts of my reports, of course, that I looked in all opinions of the commission related to the takeovers, and I looked, for example, for maybe 20 of them, 30, and of course, there are many other opinions. So I think that there are hundreds of them. Well, not hundreds, many, but hundreds.
Okay.
Yeah, you can find it on the website of the commission.
How many trades are there on the stock exchange?
How many
Trades are there on the stock exchange?
trades? Actually, capital market capitalization on Belgrade Stock Exchange, you are asking me, that is pretty low. As I already told you, our capital market is very undeveloped. Only recently, the government adopted a strategy for development of the capital market of Serbia. It is always ranked as frontier market, for example, if you are familiar with the terminology. Maybe I know, for example, that sometimes in the best years, it can be, for example, 200,000 transactions in total. Again, this is available at the website of the Belgrade Stock Exchange. I don't know by heart, I have to admit, but I know some. For example, as I remember this one, there was some good points of the Belgrade Stock Exchange before, for example, 2007 and 2008, when the economic crisis also influenced the Serbian capital market. The number of transactions again arose maybe in 2012, but again, we have some decrease. So it is not a perfect situation at all.
But you would agree with me that if there is 100 requests for published opinions and hundreds of thousands of trades in a year, that only a very small percentage of transactions gives rise to, questions put to the Commission, correct?
Yes, of course, but you have to acknowledge that most of these transactions are not concerning actually maybe the 25% of acquisitions. We don't know that. We should have the statistics. I could do that, of course, if I would need to prepare that, and we might have seen this, because everything which is not regarded to any threshold will not be also interesting thing to ask the Commission. And there are so many small transactions. As I told you, many of these transactions are actually between the employees, former employees of the privatized companies who actually sold their shares. And the most of these transactions actually happened in relation to the privatization. And that's why I said before the economic crisis, there were many of the transaction in 2007.
No, but I guess my point was different. My point was that we have seen here that this paragraph 8 of this article gives a large power to the Commission to determine, whether the circumstances are met or not. I asked you, how come that, how am I supposed to know, therefore, whether I am acting in concert or not? And you said, well, that's easy. You just ask the Commission.
Yes.
And on the basis of the opinions which are published, it seems that over the, how many, 20 years?
Of this law on capital market, it was in 2011, actually. That,
So,
but
So
that I
over the
mentioned.
13 years, only 100 persons asked.
Yes, but actually that is quite a lot. In my opinion, I wouldn't really agree with you, because we have a small number of issuers and shares which are traded on Belgrade Stock Exchange. I think it is huge. It is a huge work for the Commission, in my opinion. So I cannot agree with you.
Professor Lepetic, in your opinion, if there is 200,000 trades per year, we have 13 years.
Yes.
That means 2,600,000 transactions. For you, the fact that 2,600,000 transactions generates 100 questions is a lot.
It is
And
not.
we can leave it at that if you agree with that.
Actually, I do not agree, I have to say, because as I told you, I think that it was the best year when it was 200,000, if you remember that I said that. And also, I think that it is quite a lot, because we talked about the opinions which are related to the takeovers, and not all the inquiries related to the takeovers are related again to the acting in concert. There were, before 2011, there were many, for example, opinions related to the privatization, only to the privatization, which I have to say. That's why I'm saying in total, this is a huge work of the Commission, and many opinions have been issued, because a takeover is only a part of the competences of the Commission. There is the whole law on capital market. There are laws on investment funds also. There is now law on digital assets. So I would say that the Commission did a lot of work. I'm not saying how the work has been done, but it was a lot of work.
So when you state how the work has been done, you imply by that the Commission doesn't always do a good work?
No, I did not, because I did not review all the opinions. I wanted just to make that clear. I'm talking about the opinions, and I may only talk about the opinions that I have read entirely. And I did not read all the opinions available of the website of the Commission. I admit that.
So you stated a while ago that showing the existence of acting in concert without the presence of irrebuttable presumptions is hard.
Yes,
Correct.
definitely.
Yeah. So now let's look at the irrebuttable presumptions.
Yes.
And am I right to understand that basically, when I analyze a situation, there are two very different paths which are to be followed. One is the path of looking at the reality, if I may say so. And this is the hard one, because then I need to establish the existence of acting in concert on the basis of the facts rather than any presumptions. And the other one is just to use the presumptions. Would that be correct?
No, because to use the presumptions, you need the facts. I will give you the example in this case. For example, in order
Sorry,
to...
if I may.
Okay,
I would kindly ask you to focus on my questions.
okay, then
you know,
no,
and answer
I
my
do
questions.
not agree with your
Mhm.
opinion or
And
statement.
you disagree because I need to look at the facts.
Yes,
And is the fact I would be looking at whether there was acting in concert, or just the fact that the hypothesis of a irrebuttable presumption is met?
I didn't understand your question, I have to admit.
Yeah, because you said I will be looking at the facts, and this is what lawyers do all the time. So is the fact I need to look at is what is set out in paragraph 1, that is the existence of an agreement, explicit or implicit, oral or in writing, the aim of which is acquisition of shares with voting rights, mutually agreed exercise of voting rights, or preventing another person?
Okay,
Or do I look at the fact which establishes that one of the irrebuttable presumptions is triggered?
you have to look the facts of the case first to see whether these facts refer to any of the presumptions. Then you have to look to all the circumstances enlisted in the paragraph 8 of this Article 4 of the law on takeover. Also, you can look to other circumstances as well in order to establish whether paragraph 1 applies. So that would be a logical steps in order to establish whether some persons acted in concert by mutually agreed exercise of voting rights, you said, or preventing another person from carrying out a takeover procedure. And the first one, which we're mostly talking about, the aim of which is acquisition of shares with voting rights. So you have to go through all the article in order to establish this, but you need the facts.
Okay, so
of the
I will
case.
maybe use an example which will
Okay.
illustrate my question better. And we may focus, for example, if we scroll down a little bit, on the what would that then be 7, I think, subparagraph 7. It is considered the natural persons are acting in concert if they are spouses, parents, and descendants, adoptive parents and adoptive children, foster parents, foster children, and their descendants, relatives up to the 3rd degree of collateral kinship, including in-law kinship. So I would assume that my brother and I would meet that definition, correct?
Yes.
Yeah. So now imagine I have 50% of a company, and my brother, and the remaining 50% is free float, and somehow my brother manages to buy the other 50%. Is such an acquisition acting in concert or not?
Yes, and the problem with that particular acquisition that you just explained is, and would arise if that company of which shares are acquired is not established in Serbia, because
No,
only
if I-
if this, but this is
Apologies.
important.
No, I didn't ask about Serbia or, my hypothetical, this is,
But if it is a Serbian law,
Yes.
then sorry, it is.
no,
That's why
no,
I'm
the
saying.
company is in Serbia.
But
and I
it is the
am-
Belgrade Stock Exchange, and
Yes.
please precise your
Well,
questions.
this is what this
So
law
the
applies to,
commission
no?
Yes, this would be applicable, but the problem is how the commission might have known that this is your brother.
That's not,
That's the
sorry,
idea.
sorry, that was not my question. We
Yes.
tell the whole world that we are brothers.
Yes, the commission definitely then would have to react because you two are persons acting in concert. So you already acquired 50% of shares and your brother is now acquiring 50% of shares and he acquired those shares on Belgrade Stock Exchanges. I
Yeah.
understood you. And those are the shares acquired the Stock Exchange of Belgrade, I suppose that the issuer is also a Serbian company.
And would it matter that hypothetically, we are like the Adidas brothers who hate each other? And actually he does that because he wants to prevent my control over that company.
Actually, it wouldn't matter for the commission because you will still be obliged to launch a takeover bid. But here, because your example, I have to say, is not a representative one because you said that you two would have all, sorry, but I have to say this, if I may, because it is 100% of shares. So the launch of obligation to launch a takeover bid is futile. So I don't understand your...
Professor Lech, I'd say council may get there in due
Okay.
course, but he wants to get there in his own way. So I think you should
Okay.
respond to the question he asked.
Okay, so then I'm not sure about to answer this because this hypothetical situation would mean that commission would now see, I really am not certain what the commission would do, that 100% of shares is in the hands of your and your brother. And if it investigates and finds this, the obligation to launch a takeover bid would arise for both of you. So who are the minority shareholders who will have the opportunity to sell the shares? That's why I'm saying I needed to react, I'm sorry. But this example is definitely not a representative one. So you should acquire 100% of shares. So to be honest, I have never seen such a situation, and I'm not sure what the commission would do because the whole idea of the loan takeover is futile in this situation. There are no minority shareholders.
Okay, and if now I change my hypothetical
Okay.
and it's 45% and 45% for me and my brother, and there's 10% which is left.
Okay,
So in that case, are we acting in concert?
yes, you do.
And we are acting in concert solely on the basis of the irrebuttable presumption?
Yes, regardless of which one of the three situations in paragraph 1 is applicable. The idea is that both of you are going to have an obligation to launch a takeover bid in order to enable to rest these 10% of minority shareholders who hold 10% of shares to leave the company because, for example, they do not want to be a part of your conflict. For example, you said that he did it purposely.
Yes, and so, well, actually, I would put to you that it applies even if none of the three aims under paragraph 1 applies, correct?
It is not none, because there is an irrebuttable presumption that you and your brother acted in concert. It becomes irrelevant what was your aim, whether to exercise these rights jointly, whether you wanted to prevent someone else, I don't know what might be. For example, maybe it was sell out of shares. Maybe you wanted to prevent some minority shareholder to exit the company. I don't know what could be the aim. It could be many things. But this will not be relevant. That is the point, because there is an irrebuttable presumption.
As I, just so that I'm clear, I understood, so council put to you, well, so actually I would put it to you that it applies even if none of the three aims under paragraph 1 applies, correct? And I understood your answer to be saying, yes, correct. So paragraph 7, in other words, applies whether or not paragraph 1 is engaged.
Actually, not completely, but it would just be irrelevant which of the three situations is applicable here. So the commission wouldn't have to say which of these one is relevant, but actually I believe that in practice it would refer to the definitely acquisition of shares with voting rights, because this was happening here. We see this from the facts. One brother already acquired the shares, the other brother already now acquired the shares. So they would assume that the aim of which would be of this acquisition would be the acquisition of shares with voting rights. I just wanted to clarify that, but that would be irrelevant which part of the provision is applied.
Council, I have a follow-up question on this, but perhaps I'll let you continue. Or would you?
Oh, I was going to ask a follow-up question. So.
Well, it's simply just to understand correctly. So are you saying, Professor Lepic, that the paragraph 7 characterization of persons who are acting in concert, in this case brothers, but any of those kinship relationships, simply has to be read into the words acting in concert in paragraph 1, but that you then still have to go on and read that subject to the language, the aim of which is acquisition of shares of voting, etc., etc. Is that your testimony, that acting in concert in paragraph 7 is only a qualification of the words acting in concert in paragraph 1?
Yes, because it is saying, if we can read it together.
No.
Yes.
Let me just ask you, because I have a follow-up question.
Yes.
Is that a correct reading?
Yes.
Because there is an alternative reading, which says that paragraph 1 refers to persons who are acting in concert with the aim of those 3 aims. And then paragraph 7, notwithstanding your holistic interpretation, but paragraph 7 is dealing with something which is entirely separate, and it's to say persons are acting in concert if they have a relationship.
This is actually a good question for the meaning of the law. But as it is written now, I could read this in a way that you suggested. Although there should be, in my opinion, some clarification regarding this. And I didn't see it in any, for example, the opinions of the Commission. Something like that did not arise.
I'm going to leave the rest to Council.
Thank you.
Yeah. Thank you. So just to make that absolutely clear, your opinion is that, as you answered to the President, that acting in concert in paragraph 7 is only a qualification of the words acting in concert in paragraph 11.
Yes, but again, I'm saying that also the other part of the sentence is relevant, but for the example that you showed me, it would be probably the first option. It is very hard to answer this question because it is a hypothetical situation which I have never seen in practice. This is really a hard question, what you are asking me, and a really strange one. 2 brothers are acquiring shares on Belgrade Stock Exchange, and they didn't act in concert, really? They didn't have an agreement? Or that is the part that I didn't understand. They then would have to prove, but it is impossible to prove that they didn't act in concert. That's why I'm saying it would be really, even before the court, I think that it would be almost impossible for them to prove that they didn't act in concert. How could you do that? I don't know. That would be for the court to decide. That would end at the court. I'm definitely sure for that case.
But the fact that they are brothers in itself would not be sufficient to establish acting in concert.
Again, your hypothetical situation that you ask me, I would say that yes, because you told me 45% of shares, 45% of shares was already acquired by one brother, and the other brother acquired 45% of shares on the Belgrade Stock Exchange in this very same company. So for the Commission, I would say that it would be a conclusion that they acted in concert. But again, there might be, and I think that it would be, they didn't act in concert, that could end up at the court, and then you would have to prove, you and your brother, that you did not act in concert. So the idea of the presumption is to make it easy for the commission. But the court, of course, again, will examine your proofs that you did not act in concert. But this is very difficult.
So it means that the presumptions actually is rebuttable.
When the commission decides about this, it has to be irrebuttable. If you look at this, it is considered that natural persons are acting in concert if they are spouses. So the idea would be to say, if this is not a rebuttable presumption, that you can say that you are not, for example, brothers, or I don't know. So definitely this is irrebuttable presumption. So if you are brothers, you are considered as persons acting in concert. On the court, you can only prove that you did not act in concert with the aims which are stated in the Article 1. But for the commission, this would not be relevant. The commission would see that you are brothers who acted in concert, and the commission would order to you to launch a takeover bid. Then you would apply to the administrative court and you would say, look, we are brothers, really, that there is an irrebuttable presumption, but there was no aim. There was no joint aim. I have never talked with my brother about this. We didn't want to do anything together. We didn't want to acquire shares together. You would have to prove that to the court. I think that it would be like that. But again, saying this is very difficult, hypothetical question, and it is really interesting question, I have to admit.
But then if the court agreed with me,
Yes.
the court would quash the decision of the commission.
Yes, it might.
Because the presumption is actually rebuttable before a court.
If you put it in that way, but this is really, we are now in very exotic interpretation, a theoretical interpretation. I would say, as a legal scholar, that it might be possible, but this is very exotic now. We are in the hypothetical situations. I admit that there are no legal writings regarding this. There are no court decisions regarding this. This is a hard question for some very serious article.
Okay, so now, but from you said that from the commission's perspective, at least,
Yes,
they would
that is
apply
clear.
This. Yeah,
Yeah.
that is clear. And now, I don't know if you are, so the obligation to launch a takeover bid is incumbent on all persons acting in concert, correct?
Yes.
So was, I don't know if you were familiar with her, but Mrs. Broshko is sitting here at this table. And I represent to you that she was Mr. Broshko's spouse in November 2017, and then long before, when the 2017 takeover bid obligation occurred. Sorry, the 2017 acquisition occurred, and therefore, when, in accordance with your opinion, Mr. Broshko had an obligation to publish a takeover bid. Did Mrs. Broshko also have an obligation to publish a takeover bid?
No, because she was not involved in any way, as maybe she is really, but I wouldn't know even from Coropi and from Rand if there was no disarbitration, for example, trust deeds and everything. So we are suggesting that she was not involved. There are no any evidences. No, she's not connected in any of that way.
Was she acting in concert with Mr. Broshko just on the basis of her being his spouse?
No, because you are mixing that interpretation of the articles is mixing some things which shouldn't be mixed. If we go in that way, like you are saying, we will come to some completely, again, non-representative examples. We can do this, what you call chaining also in your submission. We can do it forever. There is always someone else. But the thing is, that you should identify only the persons which are involved, because the idea is to connect these two persons which are really involved in the acquisitions. And there are many persons in between in order to hide the person behind the acquisition. I don't think that, or maybe she really controls Maple Leaf Investments. Maybe there is some trust deed with MLI. No, really, why not? Because it was the story with the Coropi and Kalemegdan. So we know from the case here that Mr. Broshko, if I'm correct, is the only owner of Maple Leaf Investments. But maybe Maple Leaf Investments have some trust deed with, I'm sorry, Mrs. Lee Broshko. We do not know that. And if we would speak about the commission, there is no possible way that the commission could have come to such information. That's why I'm saying all these hypothetical cases are completely out of reality, what we are doing now, because the commission will see that what is registered and the information which it gets from the notification. That's why I'm saying, if they are connected somehow with the Maple Leaf Investments, which we know now how it is connected with, for example, other investments of Mr. Rand, I hear that only today, I didn't know that before, then yes. But we don't know that. That's why I'm saying we would just have to have new and new evidences. It is possible, but it doesn't have to be.
Yeah, well, the use of hypotheticals is a good way to test legal propositions because sometimes they allow us to focus on the specific fact rather than the multitude of facts which may be relevant for a case. So this is just to explain that. But you stated that the commission will see relevant information from a notification, correct?
Yes, I did.
But then whether or not a transaction needs to be notified depends on whether persons act in concert, correct?
Correct.
So aren't we creating here a sort of vicious circle?
No, unfortunately not. We are trying to protect minority shareholders, actually not we, but the legislator, which in practice is sometimes very futile because it is really easy to establish a company somewhere, to use some of your relatives to acquire some shares, and the commission might have never found out about this. And unfortunately, I think that that is one of the reasons why there are there is a small number of takeover bids also in Serbia and a small number of cases before the court. Because as I told you, 40 cases only.
Yeah. I believe you haven't answered my question because my point is this. In order to know whether I have an obligation to file, I need to know whether to notify the commission. I need to know whether I'm acting in concert. And
Yes.
I may be acting in concert, just there's 170% shareholder. I'm acquiring just 0.5, and I may be acting in concert. I may have an obligation to file, but I then I could understand the irrebuttable presumptions if they were really irrebuttable, but I understand now from your testimony that they are irrebuttable before the commission, but not before the court.
I told you I'm not sure. Very exotic interpretation.
Yeah.
I have never seen anything about it. It's very hard to say something like that without any practice of the court, without any opinion of the commission.
Mm-hmm. Yeah. So would you then agree with me that it's very hard for a person to know whether they are acting in concert or not?
No, because as I already said, you have an opportunity always to pay a small fee and to ask the commission.
Okay.
And you will know the answer. So that is the legal certainty. Everybody will be happy.
Yeah, I see. So basically I should put my hypothetical to the commission.
Of course.
Yes.
And this
how long does it take the commission to answer?
Not very long, because the commission applies the law on administrative proceedings, actually. So, but I'm not now an expert in this field, but I would say a month or two, maybe. But I don't know. Again, I'm not an expert in this field. But if it applies the law on administrative proceedings, it's really not a long time, and I think it does.
Okay, so now let's go back, and I'm cognizant of the fact that we should be breaking for lunch. Now you basically stated that, if I take your answer correctly, that on the basis of the facts as you know it, assuming that Mrs. Broshko is not related to the economic transactions regarding Obnova in any way, the presumption in paragraph 7 is not sufficient.
Is not
to-
relevant.
or is not relevant.
Because she is not involved. That's why I told you that first you have
No.
to start with the facts.
Thank you. Yeah, I start with the facts.
Yes.
And which part of this Article 4 then I apply the facts to?
You have to apply the whole article. That is the idea. So you have to go from the presumption by presumption. Something similar, I don't agree completely, was done by Ms. Tomic Brehorshon in her report. She applied one by one, but she didn't apply these presumptions while involving grant investments.
Okay,
So
so-
that was
Yeah, if I
the
may.
only difference.
If I, okay, so I look at it holistically and I see, this paragraph 7 actually suggests that she acts in concert. Which part of this Article 4 then tells me that she doesn't?
It wouldn't go like that because you are on the factual ground. There is no fact. You do not know about Ms. Broshko. We
No,
are
no.
talking about commission.
Professor Lepedic, I will stop you.
Okay.
Yeah? Yeah, I told you that this hypothetical is based on the idea that Mrs. Broshko has no involvement whatsoever with the economic activities of her husband. The only link is the marital link they have. Yeah, on the basis of that information alone, in the context of the 2017 acquisition, if I look at paragraph 7 tells me that she acts in concert with Mr. Broshko.
Again, this is not applicable, any of this, because she is not mentioned anywhere. She is not mentioned in the
No.
register. It is not possible. You cannot apply this to Mrs. Broshko because she doesn't exist for the commission and for the transaction. If the commission
No,
would
but-
have known, you should tell the commission, this is my wife, she is a related party, we are acting in concert. So
No.
I don't, this is not possible what you are asking.
No, but then, no, Mr. Broshko tells the commission that he has a spouse.
Nothing. They would ask, how is she involved in the transaction? It would be
Mhm.
completely in that way relevant. You have to start from the facts
Okay.
from the transaction.
Yes. Which part of this article allows me to see what is relevant for me to conclude that someone is involved in the transaction?
In the Article 6 would be the first one. You would see there that it is relevant whether you directly or indirectly acquire shares. You would see that it is relevant whether you have done it by acting in concert
Mhm.
with other parties or not. And you would know if you have acted with other parties, you would again go to see what is happening over there. If you believe that you are exempted from the obligation, you would again have an obligation to submit all the information to the commission and to explain why you are exempted from this obligation. And you would have to look
Okay.
at the article.
So I will try one last time with Mrs. Broshko.
Okay,
She is the spouse of Mr. Broshko. On the basis of paragraph 7,
7.
I
It
believe
cannot be
it's,
paragraph 7. I'm sorry. That one should not be relevant here. You
it
should
is
check.
considered the natural persons. Look, this one,
You mean Article 4, paragraph 7. Okay.
yes, we are talking about Article
Okay.
4, yeah, for
Okay.
quite some time. On that basis, she's acting, there's a presumption that she's acting in concert with Mr. Broshko, correct? I then asked for the purposes of the transaction, and you said no, because she's not involved in any way, and I agree, she's not involved in any way. But which paragraph of Article 4 gives me a criterion for me to assess whether Mrs. Broshko is involved in the 2017 acquisition or not?
I have to repeat, you are looking at the wrong article. You should look at the Article 6 and start from the facts, what you did in the acquisition. So again, did you directly or indirectly, so this means through some company, acquire the shares, acting in concert with someone or not. If you did, then you would have to see what is happening over there.
No.
And if this, okay.
No, but in your own description of Article 6, you state, oh, you have to look at the fact whether you acted in concert with someone in the acquisition of some shares.
We are
And
talking about the
here, in
commission.
paragraph 7, we are discussing the definition of acting in concert, but that I would put to you that that creates a vicious circle. Because if you say that I can overcome Article 8, paragraph 7, by looking at Article 6, which however also uses the notion of acting in concert, then I have acting in concert on both sides. Yeah, and one sends me to the other.
Can I answer?
Yes, please.
Again, Article 6 is relevant for the acquirer and mostly for the acquirer. Article 4 exists. Its aim is to help the Commission to understand whether there is an obligation to launch a takeover bid or not. So you, as an acquirer, would look at the Article 6. If you have any doubts, you should ask the Commission to resolve these doubts. If this comes to the Commission, of course, will apply Article 4. In case you are not satisfied with the application of Article 4 by the Commission, you would file a claim to the administrative court. I don't see a vicious cycle. I'm sorry. I think that this is a very clear. The only problem with this is this hypothetical, the other situation that you said that really occupied my mind, because it is very, very strange.
But then, wouldn't then be the case that the way you propose to break the vicious circle is simply to ask the Commission? That's the only answer you have?
That's not the only answer. That's a good answer. That is a good law. That is an example of a good provision of the law on capital market. I have to say this.
It might be convenient to break.
Just before we do break, Professor Lepetic, I'd just like to go back to a response that you gave to Council's question right at the beginning of your testimony, so that at least I, perhaps my colleagues as well, understand the import of the almost an hour exchange on this particular issue. At transcripts reference 120807, the question was put to you, 120807 or 120758. Now, in your opinion, the 2012 acquisition was unlawful because the obligation to launch a takeover bid was not respected. Correct. Answer, yes. Question, assuming that your opinion is correct, that would still not have had any impact on the validity of the acquisition and on the existence of Kalemegdan's ownership of the Obnova shares. Correct. No, I stated exactly that in my opinions. So definitely the transactions itself, the transfer of the shares would still stay valid. That is valid. So am I understanding correctly that let's assume for a moment that the parties in question to whom counsel is referring were indeed acting in concert. That's your testimony. I understand your testimony also to be saying that the consequences of them acting in concert might be fines, might be all sorts of other things, but the validity of the shareholding would remain. Is that correct?
That is correct.
Okay, let's just leave it there. And counsel will no doubt reflect on the time that is being spent on addressing this acting in concert, when really from the tribunal's perspective, we want to know what the consequences of this is, whether you're acting in concert or not. Second point, and I'm not inviting an answer now, but it's for both for council and for you to reflect on. For myself, I must say, although this examination so far has been very interesting, I remain at this point completely uncertain as to what, I speak for myself here, should be taking away about the interpretation of Article 4. It seems to me that Article 4 can be read in one of two ways, and I put to you those two alternatives. The one way, which I understand, Professor Lepetich, is your reading, is that paragraph 1 is the chapeau, and then paragraphs 2 to 8, if you like, are clarifications of the language of acting in concert in paragraph 1. And that's a way of reading it holistically, but the chapeau is controlling everything. An alternative way of reading it, and when I put this to you, you said that's a very good question. Essentially, it seems legitimate, but no one has addressed it, is that Article 4 essentially deals with 6 different ways of establishing that there is acting in concert. And those ways are paragraph 1, acting in concert where there is agreement, the aim of which is, all of those provisions. Then you have paragraph 2, which simply says the following persons are acting in concert. This is a deemed matter. They are acting in concert regardless of their aim. Then paragraph 3, the acting in concert when a management company, this is deemed, whether or not there is any agreement. Then you've got to read paragraphs 4 and 5 together because paragraph 5 qualifies paragraph 4. Natural and other persons are considered to be acting in concert when one of them. Again, it's a deeming. Then paragraph 6, it's a deeming. Paragraph 7, it's a deeming. And then paragraph 8 is a qualification on paragraph 1. So we've had an hour of cross-examination, but I am not illuminated on whether which two interpretations of paragraph 4 are authoritative, if there is one that is authoritative. And I am understanding your evidence to this point to be saying that your expert opinion is on the first option, in other words, the chapeau option, and everything else qualifies the chapeau. But the alternative is one that perhaps you hadn't really considered or the commission hadn't really considered. It may be reasonable, but there isn't anything out there that addresses that. First of all, is that a correct understanding of what your expert opinion is, the chapeau approach?
Yes, it is
Okay.
a chapeau approach,
Okay.
definitely.
And do you accept that the alternative reading, that there are 6 different provisions? There is the paragraph 1, which is dependent on an agreement, but there are also each of the others which provide that acting in concert is a deemed matter when you've got spouses, etc., etc. Just a very brief answer, because then I'd like everyone to go away and think about that. If that is, if you accept that that is a possible interpretation.
That is a possible interpretation, but my only barrier would be when it comes to the group of companies. Then you cannot look at separately. It is not possible. Really, it's not possible, because if you have a group of companies controlled by one company, you have to look more of these provisions together. And even if on the top of these companies, it is a natural person, it would be impossible to come to the conclusion that these persons are acting in concert without these irrebuttable presumptions. And I have to add that all theory in Serbia is unified in interpreting this, and that these are irrebuttable presumptions. I really discussed it exotically, and
that's very helpful. I'm also, for myself, trying to establish where the two experts agree and where you disagree. And I want to be very precise about this,
Yes.
because at the end of the day, I say this to council as well, these matters for the tribunal are matters of fact. We are going to weigh very heavily your evidence, and we're going to weigh very heavily the evidence of Mr. Tomic, and we're going to hear the submissions of the parties. But I want to be absolutely clear that my understanding is accurate. So I think, without more ado, let's take that break for lunch, and I propose that we reconvene here at 2:15. So it'll be 4 minutes short of the hour, 2:15. Thank you very much. And I should, on the record, just give you the usual admonition for witnesses, which you'll understand. You can't talk to anyone. You can go for a walk. Don't talk to yourself, as it were, but you can't talk to anyone.
Okay, thank you. I
Thank you.
will do that.
My apologies. I'll be with you in just 1 second. Council, back to you.
Good afternoon, Professor Lepetic.
Good afternoon.
I will now continue with one last subtopic with respect to the 2017 acquisition, and then we will move to the 2012 acquisition. I'd kindly ask you to review paragraph 16 of your third expert report. It's on the screen in front of you. And I'd like you to focus on the second sentence, which states that if Mr. Broshko is not a member of any corporate management bodies of Erinn Investments, I assume Article 4, Paragraph 2, Item 2 of the 2016 law on takeover, according to which there is an irrebuttable presumption that members of the corporate management bodies with companies wherein they are also member of such bodies are considered persons acting in concert, may not be applied. So I believe this is what you alluded to also in your opening presentation, where you stated that, as a matter of fact, you do not know whether he is a member of a corporate management body of Erinn Investments, but that in your opinion, if he is, then there is a irrebuttable presumption that he was acting in concert with Mr. Rand, Coropi, Kalemegdan. And if not, then such irrebuttable presumption does not exist. Did I get it right?
Yes, perfect.
Yeah, thank you. So now, would it be sufficient for the irrebuttable presumption to exist that Mr. Broshko is not a member of a corporate management body, but that he has the authority to bind Rand investment in some other capacity?
According to Serbian law.
Yes, according to Serbian law.
According to Serbian law, this would not be sufficient because law on companies is very clear about this. There is some other legal notion which is called de facto representatives of the company, which we do have, but it only to a certain extent overlaps with the notion of de facto directors, as we can see and find in many common law systems. So only to a certain extent. There are some, of course, legal scholars which would say that there are de facto directors also according to Serbian law. I am not that sure. So I would say that there is an overlap. There is also a notion of responsible persons, which is again broader than these three, but I think that these three are not completely the same, and that is why I opine this way. But you can find opinions in Serbian theory that even Serbian law knows about de facto directors, but I'm not one of these scholars, and this is my opinion.
Okay, so in your opinion, the provision of Article 4, Paragraph 2, Item 2 is triggered only if a person is a, let's say, registered member of a corporate management body of a company.
Yes, because from the wording of the provision, I don't see the possibility to include in it de facto legal representative, which is Mr. Broshko according to Serbian law. There would be some consequences, definitely, of him presenting himself as a managing director in Serbia. Definitely, these consequences would be that there are some contracts, for example, between some third parties who didn't know about the real identity of Mr. Broshko and Rand Investments. But I don't see it as the same is covered by this provision. I think that provision is strict, and I'm saying there are no court decisions. They are saying otherwise. Or also, I needed to add this, but there are some scholarly thinking that de facto directors exist in Serbia. So because of this de facto legal representatives, which really exist, there is a provision in loan companies. It is Article 32, paragraph 2, definitely that exists. I have to say that is true. And that would be Mr. Broshko. According to Serbian law, when someone would ask you what is Mr. Broshko, according to Serbian law, to the RAND investments, it would be de facto legal representative of RAND investments. And because some would say that the managing directors are actually legal representatives of companies, that is how this connection may be done. But it is a connection, but not strong enough, in my opinion, to say he is de facto director and this is covered by that.
Thank you. So now we can move to the 2012 acquisition. And I would like to start our discussion by looking at what is called in this arbitration, the 2007 opinion, which is document C562. We are just waiting for the system to
No problem.
show us, so please bear with us for a second. Okay, so maybe before we have the text of the opinion, I will ask some follow-up. Well, I will start from a different end, shall we say.
Okay.
So the 2007 opinion was published by 2007, as its name seems to indicate, correct?
I don't know the date of the issuing of the opinion, but I will believe what you said. It's right, of course.
Yeah, and it interpreted the 2006 version of the takeover law, correct?
That's undoubtable.
Yes. And now, would you agree that if the takeover law had not changed, so assume it, the amendments
Never happened.
never happened, would you agree that under the 2006 takeover law, taking into account the 2007 SEC opinion, the 2012 acquisition did not trigger a mandatory takeover bid?
I would agree to that.
The 2007, now we will be able to progress. Yeah, so this is an opinion concerning the obligation of consortium members to publish a takeover bid. We will just go through that quickly to make sure that we have the right document. I assume that you are familiar with this
I am
opinion.
familiar.
Yes.
Don't worry,
Yeah.
yes.
So then we can go directly to the second page. So, well, sorry, just for the benefit of the members of the tribunal. So what we have here on the first page is a short description of how the opinion came to be, of the question which was asked of the commission by a company curious about interpretation of the takeover law, correct?
Yes.
And then, so this is what we have on this first page. And then on the second page, there is how the commission understands the question. So it summarizes it in bold, and that the request asks the question if there is there an obligation to publish a takeover bid if company D increases its ownership stake in relation to other members of the consortium through conclusion of a new annex to the consortium agreement, correct?
Correct.
Yeah. So basically they were opining on what happens if within a group of companies, shareholdings are reshuffled, but the total aggregate amount of shareholding does not change, correct?
I have to add, You cannot see it because it is somewhere above. Just to clarify that this is about acting in concert of the consortium member, because the consortium was established because of the acquisition and the privatization. So it is the transfer of shares between the persons acting in concert. That is the, in more detail, the precise idea of this opinion.
Yes. Thank you for the specification. And then we can see the opinion. And we can see that the opinion refers first to Article 4 of the law on takeover.
Yes.
And then if we look more at the second paragraph, so it states, namely, in accordance with Article 4 of the law, legal persons are acting jointly if they are mutually affiliated in the meaning of the law on takeover and the law on companies. And then to establish acting in concert, it is essential that the votes of acquirer are added to the votes of persons acting in concert with the acquirer in accordance with Article 5 of the law. So that's the two provisions the opinion refers to, correct?
One more, if you will just go before the opinion, what was the actual question? You will see Article 8. We have to mention this because the Article 8 is the only article which provides for the exemptions from the obligation to launch a takeover bid. So actually it is that article, but a commission, maybe I should not go before you.
Yeah, exactly. So the commission in the formulation of the question says that it issued its decision in light of Article 4, 5, and 8. And then it reasons in this opinion part with respect to Articles 4 and 5, correct?
Correct.
And it states the conclusion is that if the aggregate amount of shares does not change, there is no addition of new shares, there is no need to publish a takeover bid, correct?
That is correct.
Yes. So this is the 2007 opinion.
Yes.
Now, I would like to take you to to a document which, and then I think we can establish, we know that what happened in 2011 at the end of the year, applicable as of the beginning of 2012, that a new exemption was added into Article 8, relating specifically to transfers within
Concerting
parties in the event that there had been a takeover bid before, correct?
Correct.
Yes. And now I would like to take you to the statement of reasons for the new law, which
Yes.
was I think you were here for the cross-examination of Mrs. Tomic, so you saw it on the screen.
No, you saw the document earlier also. It was attached.
But it will be the same part. So this is document 5, C563. No, sorry, C712. And we went through it already. So this is the extract from the rational report, which comments on the changes made to Article 8. And it states that Article 8 of the law is amended to expand the number of specific situations in accordance with the solutions from comparative regulations of neighboring countries, in which the acquirer is not obliged to announce a takeover bid. And then the first one is the one which is interesting for us. If after a conducted takeover bid, the bidder acquires shares of the target company through a transfer between persons who acted jointly in the takeover bid. Can you see that?
Yes, of course.
Yeah. Would you agree with me that the provisions of Articles 4 and 5 did not change materially?
Yes,
as a
because
result of this amendment?
they are dealing with acting of concert and the manner of acting in concert. So there was nothing to do with the Article 8, with the exemptions, only partially.
Yeah.
So
yeah, I mean, like generally this
In general, yes,
2011 amendment did not materially change Articles 4 and 5.
Yes, these are different things. So there is acting in concert and the manner of acting in concert. So Article 4, acting in concert, manner of acting in concert is Article 5. So of course, these two remain unchanged, because the changed was the article referring to the specific situations which lead to the exceptions from the obligation to launch a takeover bid. So only that one was actually amended after the critiques from many professionals and legal scholars. I can add that. I was aware of this.
Could you, I think we had that from Ms. Tomic, but I would be also interested in hearing from you, like who prepares this statement of reasons?
The ministry. So the idea is that the ministry makes the draft of the law. Then this draft of the law becomes a proposal of the law once the government is ready. Then the proposal of the law is in the parliament. You always can find, for example, drafts of the law on the website of the various ministries, and the text of the proposal of the laws, which contains this reasons why the laws are adopting or amending, you will find on the website of the parliament. And then the parliament, of course, the members of the parliament, they vote on the amendments, taking into consideration the reasons, of course, why the amendment is needed. So when the government and ministry, actually it was the ministry before, drafted this explanation, this is a quite clear explanation, they wanted to say that the number of reasons which are exclusions, exemptions from the obligations to launch a takeover bid are not enough, that this list should be expanded, and that is what they did. So they referred to the previous law. They said it is too narrow. Let's now enlist some more exemptions. That's why they say is amended to expand the number of specific situations. And that is why I said that, of course, that the Article 5 and 4 remain the same. This is different thing. This is more than just this one exception that we talked about. The other ones was actually that the one you can see.
Yeah.
Never mind. I think
you
that
very
I
much.
was clear.
And so is it your experience that the drafter of this statement, so first of all, do I take it from your answer that the statement of reasons is a pretty important document?
Actually, in practice, before Serbian courts, not at all. But in my experience in international arbitrations, yes, sometimes because it is important to explain to someone who is not native, who is not surrounded by the domestic law, why something is happening. But before the Serbian court, this would be completely irrelevant. They would say, this was the law, which one is the applicable law for the time being, and they would just go to the Article 8. And why this is enacted, they wouldn't care. But of course, scholars knows about it. That is why I already knew about this.
But that would presumably be also important for the members of parliament who vote on the amendment, no?
Yes, but you have to understand that this is the decision of the government to give this law to propose this law to the parliament. And of course, that the majority of the parliament is the majority party. And if they have some agreement, this law will pass. I said it more like declaratively, but in practice, if you have this law, if there is no some special, I don't know, requirement from the public, from the, especially from the academics also, that will pass. Moreover, nobody will take care what was the concrete explanation. But here, this is a real explanation. This really shows what was the situation back then.
And the yeah, this is, so you said that the government plays an important role, given that by definition it should have majority in the parliament. So this is in a way the intent of the legislature, right? Which is then approved by the actual legislature.
I wouldn't say that. It would be really, again, an exotic interpretation. I don't like exotic interpretations. The law, which is adopted, is the law of the parliament. So this is the legislator, and this is not done by the parliament. So I wouldn't go into that direction. I understand what you mean, but it is not formally true.
Yeah, okay, not formally true, but maybe
No.
close to real life, no?
Again, that's politics, which party is the majority, has the majority in the parliament and everything. So I wouldn't go into that.
So now, would you agree with me that the drafter of this statement of reasons takes into account the law and its application practice when they draft these reasons?
I would definitely say so. At least some in the group for drafting the law, because, for example, I was in one other group for drafting some other law regarding companies. I am aware of really how it goes. There is sometimes an academician, some scholar. There could be, for example, in this case, someone from the from the commission, Securities Commission. It doesn't have to be so. It can be only the officials working in the ministry. So there are various practices, but for sure, they have known about the 2007 opinion. And if I may say, if you allow to me, I believe that they wanted to limit that what the commission done in the practice. And I know actually why, because there were many critiques back then on the law, how this was done. They actually wanted to make secure that at least once the shareholders in the privatized companies have an opportunities to sell their shares. And that is why they added the second part of the sentence, which was not a part of the 2007 opinion. So I think that there was an intention. They had to be aware of this. And maybe someone from the commission was in the drafting group. I don't know that, but I'm telling you it is possible. It could be even some of our professors. I really don't know for every law who are the members of the group, but it is quite usual to have persons from many sectors, from academia, practitioners, and also, of course, the majority are the officials who work at the ministry.
Is it intention to limit the practice of the Securities Commission mentioned here or elsewhere? Because we have it in Serbian, so feel
Yes,
free
it
to...
is not mentioned here, is the statute of reasons, because Mrs. Tomic Bikurshanen put it quite well, really. That would be quite strange. You could never do that because this is legislator. We have to understand the role of the commission. So this is the law.
Professor,
and
I ask you a question, is it there? No.
No, here, no, but you asked me where it is.
No, I didn't ask you where
here,
it is.
This is
I was asking you whether it is here or in another part of the statement of reasons.
No.
Actually, here, what we can read is that this is intended to, or that the change is brought to expand the number of specific situations in accordance with the solutions from comparative regulations of neighboring countries in which the acquirer is not obliged to announce a takeover bid, correct?
Correct. Expanding, that is the word.
Yes. And was this piece of legislation, as well as the takeover law in general, influenced by European legislation on that subject matter? So is it likely that this is what the drafter had in mind when they stated in accordance with the solutions from comparative regulations of neighboring countries?
No, because many of the neighboring countries, as you are aware, are not part of the European Union. So they thought about the ex-Yugoslav countries mostly, which had the same problems. It was again related to the privatizations, because you are aware the privatization led to many problems for many of these countries, if not all of them. So neighborhood countries are mostly, we are talking about the 2011 here, December 2011, when the law was adopted. I don't know when the proposal went into the parliament. So it can be months before this. Yeah. I don't think that it is written over there. So in that time, there were many, and still there are neighborhood countries struggling who are not members of the EU.
So Hungary was not meant here.
I don't think so. Actually, as I am aware of, anything from our company law and capital market law is not based on the Hungarian law. If we are talking about any European country, now member of the EU, which we would take a look into, it would be Croatia, to be honest, but not so much because the Croatian law is again based on German law. So
Yeah, but
this is
I
a-
was speaking specifically with the takeover law.
I don't think
believe
so.
that you
No,
admitted that the
Hungary.
takeover law is modeled after EU legislation.
It always is trying to be, but you are aware that takeover bid directives is adopted in 2004. And of course, there are many different practices even in the EU regarding this, and there are no specific rules regarding this in the EU directive on takeover bids.
But you would agree with me that in the EU takeover on directive bids, this idea that minority shareholders should have at least one round of a takeover bid is completely absent, right?
The idea that minority shareholders should have the opportunity to sell their shares is the core also of this directive. I think that I also stated it, and Mrs. Tomic-Kushanin agreed in her opinion regarding the EU directive on takeovers. I even made it in italic, if I remember correctly. It is directive on takeover bids. We always call it takeover directive, but it is the directive on takeover bids. That's the exact name. And that shows that the core, the idea of actually adopting this directive was to protect the minority shareholders.
But would you also agree with me that the core idea was to protect them in the event of change of control?
Of course, but as you know, this is a directive, so the harmonization doesn't have to be on the maximum level. So even the EU member states, and I would like to remind you that Serbia is not an EU member state. We are trying to harmonize our law, but I have to admit that there are still many laws which are not harmonized with EU law, with the acquis. We always receive a regular statements of the European Commission regarding that, and that is general knowledge. So we were not obliged to do so. Of course, that you should look at a good practice, but you have to, when you transplant something, you have to adjust it to your own needs. And we had needs. This was, as I told you, related to the takeovers in privatizations.
But these needs are not set out in this statement of reasons, correct?
No, it wasn't necessary. As I told you, this is just the proposal, and nobody actually would so much take care about what was written here, because the matter was what was written in the law. That is always the question. In a civil,
this proposal comments on what is written in the law, no?
Yes, and it is written very explicitly that the Article 8 is amending to expand the number of specific situations. As I recall, and I think that I recall correctly, no exemptions regarding persons acting in concert was mentioned before the 2012 amendment, but there was that exception regarding the restructuring in holding, but this was related only to the transfer. Something is now happened, only to the transfer between the legal entities, and that is why it wasn't applicable to these cases at all. So definitely the completely new reason for exemption was provided in the 2012 law on takeover.
Yes, but there was also the exemption under Articles 4 and 5 spelled out in the 2007 SEC opinion, correct?
No, because as I already told you, Article 4 and Article 5 does not mention exemptions anywhere. I recall well, I hope so, that in Article 4 there are 8 paragraphs. Okay.
But the 2007 SEC opinion sets out an exemption, no? It describes an exemption, correct?
Correct, because they feel the gap in the law, which I completely agree with the Ms. Tomic Brkušan in today's testimony. So they feel the gap. Of course, they cannot refer to a specific paragraph when there is no such an exception. So of course that they may only refer to the acting in concert, which is partly mentioned, and again, this new exception of the law. But if you look at the question of the one who submitted the request, you will see that Article 8 is mentioned. That's quite normal. And I would, if I'm a lawyer, I would look at Article 8. Oh, no, there is nothing here about exemption regarding acting in concert. And that's it. That's why.
And yes, and you stated a while ago that the drafter of this statement of reason is aware not only of the text of the law, but also of the interpretative and application practice, correct?
No, in the Serbian courts, no. In the scholarly writing, I would use something like that when I try to figure out, because sometimes it's really not easy to figure out the chaotic sometimes legislators' intentions and even mistakes that was happening and is still sometimes happening, especially with legal transplants. So before Serbian courts, I'm not aware of any case ever that would refer to something like this. They would not care. It is important what is written in the law. But in the international arbitrations, as I told you, in my experience, I would refer for something like this just to acknowledge this to the arbitral tribunal, to somehow follow the idea what was happening in Serbia back then, because we know, and someone who is from other jurisdiction, it does not. But this has no some specific meaning, and even for as a proof, let me say so. But what is important, even if you want to take that this is very important, which I don't think so, it is clearly stated that the law expanded the number of specific situations enumerated in Article 8. Everything is clear. This exception did not exist in the law. Now it exists. And it contains of two different facts. First of all, there has to be persons acting in concert.
Professor
Okay.
Babic,
Okay.
yeah, I was referring to, and I speak under the control of my colleagues, at 1439. I asked you a question now. Would you agree with me that the drafter of this statement of reasons takes into account the law and its application practice when they draft these reasons? Yeah, both the law and the application practice. And your answer was at 1440, I would definitely say so. And then you were explaining why.
Of course, this is guessing. I was not a member of the drafting group, just to clarify this.
So you wish to amend your answer?
If this is an amendment, but I don't think so. I would like to clarify that I was not a member of the group for drafting the amendments of this law, and that I'm not aware of who was in this group. I said that it could be some scholar, some professor from my university, because I know that because I was in the other groups, not for this one, for this law, never, to clarify this. So for the law takeover, I have never been a member of any group for drafting the law, to clarify once again. So this can be practiced. This can be practiced that in these groups may be persons for many sectors, but it doesn't have to be so. It can even be only the officials of the ministry. So my guess would be that they would ask someone to help from academia at least. And someone from academia would know about the 2007 opinion.
Okay, so when at 1440-19, your answer was, I would definitely say so, you were in fact speculating.
Yes, because I was not a member of the group. Definitely, it's if this is speculation, then yes.
Okay. So now let's look at the notification of the 2012 application, which was made by both Kalemegdan and Mr. Obradovic. So let's look at the one which was sent by Kalemegdan. It's C363. Okay, so I will first walk through the document a little bit so we can see that it's a more than one-page document sent on the 23rd of May 2012 to the Securities Commission. It was received on the same day, and it was sent by Karanovic Nikolic, correct?
Yes,
Now, would you agree with me that Karanovic Nikolic is a prominent Serbian law firm?
I definitely would.
And then if we look at the text, it states, "Dear sirs, acting in accordance with the obligation to notify provided for in Article 57 of the law on the capital market, we, in the capacity of a representative of the company Kalemegdan Investments Limited," then the identification of that company, "represented by its directors, notify you about the following. On May 17, 2012, the company acquired, and there is a number of ordinary shares with voting rights, again identified, of the company Obnova, AD, JSC Belgrade, then identification of Obnova, which is here referred to as the issuer, whereby the company's shares in the issuer's management reached almost 70% of the total number of votes in the issuer's assembly, based on the agreement on capital increase of April 26, 2012. And then it continues on the following page, just explaining what is attached. Now, would you agree with me that this is not something which would be done by someone who wishes to hide the fact that they acquired 70% in Obnova, correct?
That doesn't have to be correct. This is again a speculation. I could never say something like that because the share transfer would appear in the business registers agency. So someone could have known what could happen, definitely. So I don't know what was the intention, but it was not any intention regarding the takeover law. If you can see the beginning of this document, you will see that it starts with acting in accordance with the obligation to notify provided for in Article 57 of the law on the capital market. The aim of the notifications in accordance with the law on capital market is completely different than the one provided in and requested for the acquirer to submit to the Commission in accordance with the law on takeover. I will simply explain this. According to Article 57, you have to notify when you exceed, reach, or even fall some major holdings. We would say it is 5%, 10%, 25%, 33%, 50%. The idea is not only connected, it is, or it may be connected, of course, to the takeover, because the Commission might have seen this and then understand what happened. But the idea is much broader. For example, when you acquire 5, for example, percentage of shares, or you fall below this percentage, it may be a sign, for example, of insider dealing. So this is transparency on the capital market. It is not notification with regard to the law on takeover, which clearly states that when you acquire voting shares of more than 25%, more than 25%, you need to submit a notification within 1 day or 2 working days, depending on the law applicable, to the Securities Commission. Then it would be written something else. It would be written in accordance with the Article 6, I don't remember the exact paragraph, of the law on takeovers. And you maybe don't have it in English, but there is another part of this notification in Serbian, which are in columns, and you will see the informations which are provided. I don't know, it's original, maybe you have it in Serbian or not, but I saw somewhere. But there were many notifications. In some of them, there was a Serbian form how you should do this. And these notifications are different. So if someone wanted, I'm not now speaking about this case. If someone wanted, for example, to avoid the launching of takeover bid, but they knew that it's not possible to hide that there was some kind of position, you would always send a notification in accordance with Article 57 loan capital markets, but you would not do the other one, and you can say, if it passes, it passes. So those are not the same things.
So your testimony is that if I want to hide something from the commission, I notify it to the commission under the wrong provision?
It can happen. I'm not talking about this, but I don't know what the claimants did. What was the counsel of the Karanovic Nikolic saying to the claimants? How can I know something like that? But what I know from this.
Is it your understanding that a firm with the reputation of Karanovic and Nikolic would do something to circumvent the law?
Of course not. I'm not saying that. We cannot know. It's confidential what they said to their clients. Maybe they really said the right advice. Maybe they said, you should do this. We don't know that. I don't want to speculate about it.
Madam, now I have an interesting, are you a practicing lawyer in Serbia?
Unfortunately, we are not allowed to represent parties at the court. We cannot be members of the bar, so we can only act as arbitrators. I'm saying unfortunately because we are full-time professors. It's our system is working like that.
But would you know whether lawyers in Serbia have an ethical duty to refuse an instruction which would lead them to circumvent the law on behalf of their client?
There are code of ethics, but I really wouldn't like to go into that to seek the provisions. And I told you, I'm not an attorney at law and I cannot be an attorney at law. I'm forbidden. So this is definitely something which I'm not involved in and will never be, fortunately or unfortunately, whatever.
If it helps, at least my understanding of this exchange, without the speculative issues about whether there was a filing under one law or the other, is that in response to counsel's question, the witness at length explained that the law on capital markets is different from the notification under the securities law. That's the bottom line that I take away from this. If you want to clarify, please clarify. But I think the witness, in her reluctance to speculate on motivations which are not evident in the document, that's quite acceptable.
Yeah, okay. So would you, actually you do attach as JL 022 a form notification of the notice of intent to take over, as you call it.
Yes.
Yes, so we will pull it up. It is a form. Would you know, so my first comment is that this is the only form that you have attached to your report, correct?
Yes, because it is available online at the Securities Commission website, so it's available to everyone.
Yeah, but then when I look at the beginning, it says on the basis of Article 12 of the law on takeover of joint stock companies, and then it refers to the official Gazette numbers where, and in the again way which is usual in Serbia, it states both the original text of the law and then all the amendments under the numbers under which they were published in the official Gazette, correct?
Correct.
And so from what is written there, we can see that this form is maybe from 2017, right?
Yes.
So we actually do not know whether there was a form and how it looked like in 2012, correct?
No, because it was stated by the law. And even before the amendments of the 2016, the same obligation existed, and it is written in the law that there is a notice which has to be submitted. And not only that, it has to be published.
My question was whether it was with respect to the form. So do we know whether there was a form stating what information needs to be provided back in 2012?
We do know because it was stated by the law. I don't have the form because this is the one available at the website of the commission.
So, yeah, so, but you didn't attach to your report
No, I
the
didn't.
then applicable form.
No, I didn't because the form is the same, because the notice of intent is the same. The only amendment was that this notice had to be sent 2 or 1 working day before, after the obligation has arisen, as I also noticed and stated in my reports.
Okay, so now let's go through the form with a grain of salt that this is a form from 2017. So it required,
Are you leaving us with a sense that the 2012 form is different?
well,
Or
the
is this just an
2012 form is not on the record.
I understand that. It's not on the record. We've got the 2017 form, but do we take away from your last comment, grain of salt, that you are leaving us with the speculation that the 2012 form is different? I just don't want the point to be lost.
No, it may have been different. I do not have it on the record either.
So
It is a point that Professor Lepetic is making. I would say it's for her to.
thank you.
Thank you. So if you look at the data which is required in that form, business name of the target.
Yes.
Is business name of the target provided in the notice which was sent?
Notice that no, because there was no target company. It was the company whose shares was acquired. Target company, this specific wording is related only to the takeover law. This form is related to the takeover law, and the other form that we have seen is has much broader aim. So that other form is submitted in accordance with the law on capital markets. So I don't think that you will find a wording target company in that form because the idea is different.
Yeah, and so the target company is what?
Target company here, in our case, would be actually Obnova.
Does the notice sent to the Securities Commission mentions that the object of the transaction is shares in Obnova?
It does.
Does it identify the business name of Obnova?
It does.
Does it identify the headquarters and address of
It
Obnova?
does.
Does it give the identification number?
No, I suppose so. It should be.
We can show it. to
Never
you.
mind. It's all the same except the related parties. Parties acting in concert. So that's
Okay,
the difference.
So the one thing which is not there is the information on relating parties acting in concert.
Yes, that is correct.
Is information on parties acting in concert relevant to assess whether any threshold was triggered by an acquisition of 70% of the shares?
No, I think that the commission might have known from this what it did see, what happened, that there is a new owner, that it has 70% of shares. But the commission could not have known about the parties acting in concert, that's for sure. And when you sent the wrong notification, of course that someone who is maybe diligent, he will notice, but mistakes can always happen. That's why I'm saying I don't want to speculate what happened.
Okay, so would you then agree with me that the information contained in the notice which was actually sent was sufficient for the SEC to know that a transaction has occurred, which, according to the then applicable version of the law, triggered the obligation to issue a takeover bid?
Yes, it did.
Thank you. That concludes my cross-examination.
Thank you very much. Redirect.
Thank you. I just have one question. Professor Lepetich, give me one moment, please, to go back through the transcript. I mean, maybe we can just go without the specific reference if we can. You made a statement regarding the Article 4 of the 2016 law on takeover and whether or not Mr. Broshko's satisfied the presumption under paragraph 2, Article 2, that he was a member of a management body. Sorry, Article
4, paragraph 2, item 2.
Yes, Article 4, paragraph 2, item 2, that he was a member of a management body of Rand Investments. And I think if I recall your answer, it was that that presumption did not apply.
According to Serbian law, if he was not a managing director. So if he was a managing director, according to any applicable law, I don't know, I said that I'm not an expert in my statements for British Columbia, Canadian law, neither Cyprus law. I really don't know these laws, I'm sorry. So if he may not be considered a managing director, I would say that this presumption is not applicable. Although I clarified that there are some legal scholars who recognized the de facto director's existence in Serbian law, but I'm not one of these. And I explained why.
And so on the point about the de facto director, the existence of a de facto director under Serbian law, does that engage any aspect of Article 4?
Actually, that is the whole point. I don't think so, because the wording is very clear. We can, of course, theoretically say what I already explained, that if there is de facto legal representative and legal representatives are managing directors of the company, there is some overlap. But there is only an overlap, because there may be some other de facto legal representatives who are really not de facto directors of some company. That's why I said there is an overlap, but not in totally, for me to be able to say that that particular paragraph of Article 4 covers de facto directors. But I wanted to add this just because there are some other opinions regarding de facto directors in Serbian law.
So just to clarify, are we talking about Article 4, paragraph 2?
Of the Serbian,
yeah, sorry.
Of the Serbian law on takeover. If it's the applicable law is the Serbian law, if the applicable law is the Serbian law. We are actually talking, if I maybe didn't understand your question, we are talking about the law on companies, Serbian law of companies, which actually says who are the directors of the company. And when you look at the law on takeover, Serbian law on takeover, if the applicable law is the Serbian law, you will have to see who are the managing directors and other members of the management and supervisory bodies according to the law on companies. That was I was saying. But regarding the law on companies, there are some different opinions.
But maybe I can clarify my question. Is the existence of a de facto director or something of that nature, does that engage any aspect of Article 4, like the entire provision?
No, we are talking about this particular provision of paragraph 2, item 2 of Article 4. So the question was, as if I understood the claimant's counsel in the right way, whether Mr. Broshko is a managing director according to Serbian law. I asked, you said according to Serbian law, and I said according to Serbian law, only the ones who are registered in the registry according to the Serbian law on companies provisions regarding the bodies of the joint stock companies may be considered directors. But I added that it is true that there are de facto legal representatives mentioned in the Article 32, paragraph 2 of the law on companies. I just wanted to give all the information that I have.
And does it relate to any other part of Article 4? So like
No.
any other paragraph,
No.
including the paragraph 8?
Regarding the paragraph 5, it's something completely different because the Commission may take any circumstances as an indication that there was an acting in concert. So it doesn't depend on these first 6 paragraphs before it, from paragraph 2 till paragraph 7. So for the Article 4, the last paragraph, paragraph 8, it wouldn't matter actually what was the exact title of Mr. Broshko. The Commission might have taken also this into consideration if it would have all the information what happened. Why not? It is not forbidden. I don't know, would they do that, but everything is possible according to this provision. This is something else. Those are the circumstances. Those are not the presumptions.
Okay, those are all my questions. Thank you.
Thank you.
Thank you very much, Professor Lepetic. The tribunal does not have any questions. I think we put some questions to you. I put some questions to you in the course of your testimony. We have a lot to think about on the basis of your evidence and the evidence of the preceding witness. But thank you very much. You are released from your responsibilities at the microphone. We're very grateful. Council, we've been going for about an hour. We have Mr. Georgiadis next, and he is due to give an opening presentation of 30 minutes. I think it's appropriate that we take a break at least for 15 minutes now, allow things to be reorganized to the extent that they need to. Then Mr. Georgiadis will have his 30 minutes, and there will be a reasonable opportunity for cross-examination following that before we take a further break. So I'm proposing to have a short break now, and then we will have a fuller break afterwards. So let's reconvene, let's say 25 to the hour. Perfect. Ready, able, and willing? Everyone? Yep. Mr. Georgiadis, welcome. You've been sitting patiently. We look forward to hearing from you. You should have your expert witness declaration in front of you. If you could read that into the record, please.
I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Thank
My
you very
name
much.
is Agis Georgiadis.
Yes, thank you very much. Before you give your presentation, let me hand you to Claimant's Counsel just to take you through the formalities of the correction of witness statement, etc.
Good afternoon, Mr. Georgianis. Mr. Georgianis, do you remember submitting 2 expert reports in this arbitration?
Yes, sir.
Do you have them in front of you?
Yes.
Could you please go to the last page of each report and confirm that there is your signature there?
I confirm.
Thank you very much.
Please go ahead with your presentation.
Agis Georgiadis, I'm a Cypriot lawyer. I've been practicing for almost 20 years. My practice is in dispute resolution, arbitration, and litigation. Over the years, I have had significant experience in corporate disputes involving issues of Cyprus and foreign company law, trust law, amongst other issues. I will be talking today about 2 matters. First, I will be referring to the meaning of seat under Cyprus law, and secondly, about the circumstances under which a trust can be created in the Cyprus law. I will start with the first point, which is the seat under Cyprus law. I have read the reports of my learned colleague, Mr. Ioannidis, and it seems that we agree that under Cyprus company law, the incorporation theory is followed, meaning that when one looks at the applicable test to define what is the law applicable to a company under Cyprus law, he would look at the place of the registered office. Under Cyprus company law, we do not have a concept like a real or effective seat, unlike jurisdictions like France, Germany, or Greece, which follow this different test. There is an extensive analysis in my reports about the introduction of the term seat. I've included the reference in the slides so that I don't bother you with all the details, but I'm available to elaborate and explain if there is a need for that. The first time that the term seat was added in the Cyprus company law was in 1999 with an amendment which is of no relevance to this case. It was in respect of companies that were affected by the Turkish occupation of a part of Cyprus. As I said, I explained that in detail in my report, so I will move on. Subsequently, there have been a number of amending laws which included the term seat, and these were mainly in relation to the transposition of EU law into Cyprus law. And it is my firm belief and understanding that the term seat was introduced to be used interchangeably and meaning registered office. Probably the best example I can give is section 354K. You can see that on the slide right now, that the general title of this part of the law is transfer of registered office of companies to and from the Republic. And later on, as you will see in subparagraph C, there is a reference to establishing the seat of a company in the particular approved country or jurisdiction. So it is evident from these references that the 2 terms are used with the exact same meaning in relation to Cyprus companies. Now, the registered office must be maintained within the Republic, and there is no requirement that the premises where such office is to be maintained should meet any particular criteria. However, given that there are several obligations of a company at that address, my understanding is that it can be implied that the premises must exist. Now, this office could be anywhere. It doesn't have to be the head office or a place of business, and it is actually very often the case, especially with corporations having several addresses, not to use their main trading points or offices as a registered office. As I mentioned before, every company, every Cypriot company must have a registered office in the Republic. This has to be designated. There is a particular form which is called it's HE2, by which this declaration is made to the registrar. And when this designation is made, it is very easily to ascertain where the registered office is of a company just by going to the public record and searching it for free. It is very often the case that companies hire law firms or other service providers to for corporate services in Cyprus, including registered office services. This may be done for many different reasons. It is a very usual case when we have companies of foreign interest. And traditionally, the reason why it was done was to benefit from the tax regime of Cyprus, but that is not the only reason. There could be many other reasons why somebody may choose to have a company registered in Cyprus and hire local service providers. Now, there was some discussion yesterday. I was present at the hearing yesterday. There was some discussion yesterday about the providers and the nature of their duties. I can say here that to the extent that is relevant in this case, the nature of the fiduciary duties of directors, as well as nominee shareholders, trustees, is following English law. So they have very strict duties of good faith towards the company and to the shareholders to some extent. And their role is not limited to blindly following the instructions of the beneficiaries. Now, there are also several obligations that the company must comply with in relation to the registered office, such as keeping certain registers and records there. But the failure to comply with these documents does not invalidate the designation or the fact of maintaining a registered office in the Republic. So if, for example, the registered of directors for some reason is moved out of the registered office, that doesn't mean that it is no longer a registered office. In the reports, you will notice that there is some disagreement with Mr. Ioannidis in relation to the criteria for a registered office to be considered as being maintained in the Republic. I believe that this is an academic issue, because even if we apply all the criteria proposed by Mr. Ioannidis, both companies, Coropi and Kalemegdan, meet them all. And this is something which, if you look at my first report, you will see that I have ascertained myself by paying a visit to the offices of HLB Cyprus, which is the place where the registered offices of both companies are maintained. And the facts that are stated on this slide were confirmed by myself personally. Now,
you realize you've just become a fact witness.
Sorry?
You realize you have just become a fact witness. You, I think, are not asked to testify to issues of fact, but just to issues of expert. That's a little bit of levity to aid you on your way.
I thank you. So, my position in the reports is that when we refer to the seat of a Cyprus company, we mean the registered office. However, because the registered office is of relevance to various matters, which apply different tests, I'm not asserting here that these tests should apply in this case. My position is that even if they did apply, in the circumstances of the particular case, my opinion is that both companies would be considered as seated in Cyprus under any of these tests. I will take them one by one. Under Cyprus conflict of laws, which follows the English common law, and of course European law in different aspects, the incorporation test is used to determine the applicable law, and accordingly, under this test, seat is registered office. In the BIT, the term seat is used and not residence or domicile. There is no authority under Cyprus law that I'm aware of that suggests that seat is the same as residence or domicile or place of management and control. From this, I deduce the conclusion that this is a reference to Cyprus company law by which seat is a registered office. Even if we apply the residence test, the residence test does not point to a different country. Even if we accept the position that the two companies were not exclusively controlled and managed from the Republic of Cyprus, and this was done partly elsewhere, still Cyprus would be the place of residence of both companies, with a possibility that the companies could be considered for certain purposes as also resident elsewhere. This is from Dicey and Morris, which is claimant's legal exhibit 210. In respect of domicile, under English and Cyprus law, domicile is the place of the registered office. Under European law, the domicile test is slightly different, and a company could be domiciled in different places. One of them being the statutory seat, that a different criterion may point to a different jurisdiction does not negate the fact that a company is also domiciled at the place of the registered office. So even if we applied the domicile test, the result would still be the same for both companies, and they would be considered as being domiciled in Cyprus. There was some mention in the reports of my learned friend for VAT law in Cyprus. I don't think that this is a relevant matter to the issues that we have here, but for what is worth, I should mention that under VAT law, seat is the place which is more closely connected to the transaction in question, and the test is irrelevant for the BIT because there is no reference to the place where VAT tax is imposed on a company. Similarly, with income tax, the test for deciding where a company is to be taxed is the ordinary residence of a company. There is no mentioning of the term seat in the law. But even if we apply this test, that would be the place of management and control. And I will explain very shortly where that place is for both companies. Now, when examining the management and control of a company, one needs to look at the nature of businesses of the company in question. In this case, we have two Cypriot companies which are simple holding companies. They are holding assets. They're not trading companies. They're not doing any transactional businesses. The purpose of Kalemegdan is to hold the Opnova shares, and these shares are held on trust for Coropi, and that is all that these companies are doing. So when we speak about the management and control of companies of this sort, and for the two companies in question in particular, the management and control involves basically submitting tax returns, financial statements, and issuing instructions on voting for the shares that are held by Kalemegdan. So the director's role was not limited to ensuring that the companies were compliant with applicable laws. The evidence shows that they were performing these activities. The directors were performing these activities. And actually, I've heard yesterday that this was done without requiring approval or instructions from either Mr. Rand or Mr. Broshko. Now, allow me to give an example here, because there is a lot of talk about what is the nature and how it actually works on the ground when a company uses the fiduciary services of a service provider in Cyprus. Now, the truth is that in the past, there has been some abuse of the trust regime and the tax regime in Cyprus. To give you an extreme example, I've had a case where I was involved as counsel, which was involved a Cypriot company that was the owner of shares of a very substantial business in Russia, where the nominee, the only registered shareholder and director of the company, was a Cypriot housewife who did not speak English at all. And we actually realized that when the bailiff went there to serve the claim form to her. That is not a case where if we applied the management and control test under any circumstances would be satisfied. But this is not the case here. This is not the case here, because we do not have some straw man or straw woman being the nominee. We have professional directors. HLB Cyprus is a very reputable firm in Cyprus. They offer accounting, auditing, and corporate services. They are very well esteemed, serious professionals, and they are not. And from the evidence that have been brought before me, it seems clear to me that they have been undertaking their role very seriously, this actually was done without requiring approvals and instructions from Mr. Rand or Mr. Broshko on most matters. Now, so even if we did have to apply the central management and control test in Cyprus, for the reasons that I've mentioned in the previous slide, I believe that the management and control of both companies was and remains in Cyprus. And this is also confirmed by the fact that the income tax of both companies was paid in Cyprus, which means that the Cyprus authorities were convinced that the central management and control of both companies is in Cyprus. Also because the majority of the directors was at all material times Cyprus residents, and that all directors meetings, at least all the directors meetings that I am aware of, took place in Cyprus. Now I will turn now to the second issue, which is the creation of trust, of a trust under Cyprus law. It seems that we agree with Mr. Ioannidis on the basic law position in relation to trust. Accordingly, it is presumed that the beneficial title follows legal title. A trust can be created without the requirement of any formalities. It is not required to be in writing, so a trust can be declared orally. The requirement for the creation of trust is for reasonable certainty as to three issues: the intention to create a trust, the subject matter, and the object. This follows English law, English common law and equity, and to all matters that are relevant to our case, the Cyprus trust law is the same as English law. There are some differences on certain matters, but are of no relevance to this case. Now, when we examine whether a trust was actually created or not, we have to look at the three certainties that were mentioned before. If there is some lack of clarity in relation to one or more of these certainties, this does not necessarily mean that the trust was not created. So if it is sufficiently clear that there was an intention to create a trust, but there is some ambiguity about some manner. It is possible that a constructive trust has been created. I'm not arguing in this case that there was a constructive trust, but I'm saying that even if we accept that there was some ambiguity in the original oral declaration of trust, this was the result of this was that there was still a constructive trust on the Obnova shares. From the testimony that was put before me, which is the testimony of Mr. Broshko and Mr. Rand, the actions of Mr. Obradovic and the trust deeds, which is not contradicted by any other evidence, it is quite clear that there was a trust on the Kalemegdan shares. There is an argument put by Mr. Ioannidis about the Articles of Association and in particular Regulation 12, but that is irrelevant to our case, and I explained that in both my first and second reports. I can elaborate on that if you ask me to. But my conclusion on the evidence that was put before me, applying simple, straightforward principles of Cyprus trust law, is that the shares of Kalemegdan were always, since the incorporation of Kalemegdan, kept by Mr. Obradovic on trust for Coropi, and therefore that Coropi was the beneficial owner of the Obnova shares at all relevant times. As I mentioned before, even if there was some ambiguity in the original declarations, there was a constructive trust for the same matter. Not that may be very important in the case because there was a gap between the incorporation of the company and the minutes by which the Obnova shares were agreed to be transferred to Kalemegdan. And on the day that it was resolved for the company to acquire the Obnova shares, the trust deed was executed. So even if there was any defect before that time, this was cured by the trust deed. Thank you.
Thank you. I think that was a briefer presentation than you were entitled to, but we're very grateful for that. I think we hand directly over to Respondents' Council.
Thank you, Mr. President. Good afternoon, Mr. Georgiadis. My name is Monica Dil, and by now you probably understand that I'm one of the councils representing Serbia in these proceedings, and I will be asking you some questions today concerning your reports and your presentation.
Yes, thank you.
You will be able to see some documents that we will be referring to on the screen. I understand you have your two reports in front of you, and I will just ask you to be brief because my time today is very limited.
I will make sure I will be brief.
Thank you. Thank you in advance for that. So I would like to begin with your experience. You have also referred to that in your presentation today. If we may have a look at your first opinion in paragraph 3.4, you stated that your practice focuses on international dispute resolution and that you have extensive experience in corporate law, the law on trusts, private international law, and in the resolution of international corporate disputes. You have also mentioned corporate disputes in your presentation earlier today. I would like to refer you also to your annex, which contained your CV, Annex A to your first opinion, where it states that you are a partner and head of dispute resolution at CGA, focusing on complex international dispute resolution, including arbitration and litigation before local courts and international tribunals. So your CV does speak a lot about your experience in disputes. Would you agree?
Well, I hope so.
Okay, so you do not mention in your CV or in your presentation any particular cases involving company law or trust law. Is that right? You didn't refer to any examples of cases you have worked on?
No, I didn't think that was necessary. I think that I do refer to a previous investment arbitration case where I was a witness. But if you wish me to refer to particular cases, I can try to do that to the extent that confidentiality allows.
I just wanted to establish, is it fair to say that your primary specialization is dispute resolution?
It is, yes, but
Okay,
what I
good.
said
Thank you.
before is that it is a dispute resolution. My practice is about 50% litigation and 50% arbitration.
Okay.
In litigation, most of the cases where I represent clients in involve issues like corporate disputes, trust disputes, commercial disputes, and occasionally construction disputes. So what we are discussing today are matters that are everyday work for me.
Okay. Being a litigator myself, I can very much relate to that. I just wanted to point out that you did not refer to any specific experience on company law or trust law cases. But let's move on to the round arbitration that you have mentioned. As you stated in your report, you previously testified in that arbitration for the same client. And in this other case, so that it's clear, one of the issues you have covered was also the issue of the seat on Cyprus law under the Cyprus law understanding, right?
Correct.
You did not opine on international law or the BIT meaning of the term seat.
No.
Did you visit, for that purpose, the registered office of the relevant Cyprus company in that
Yes.
case? Were they registered under the same address as Coropi and Kalemegdan?
Yes.
If I may refer you to paragraph 4.516 of your opinion. And we are now moving on to the understanding of the term seat. You stated that I agree with the position stated in the Ioannidis opinion that the definition of seat depends on context. So you agree there is no unified term seat in Cyprus law. Is that right?
I agree, yes. It's actually a term that is being used sometimes in case law to denote different meanings. We often use the term seat when actually the definition in the law is using different terms. So for example, in income tax law, as I mentioned before, there is no mention in the income tax law to a company's seat. It is the place of residence. However, in, let's say, everyday talk or in sometimes probably wrongly, we say seat meaning the same thing.
So there is a term, it's just that it's subject to interpretation.
Yes, of course, yes.
You also stated that the term seat and the term registered office in the Cyprus company law is interchangeable, and essentially the two terms under Cyprus company law mean the same thing, right? Is that your?
Yes.
And this is where you and Mr. Ioannidis disagree, basically, on the seat interchangeability of the term. Is that fair to say?
Well, it's not for me to say what Mr. Ioannidis says in his reports, but what I understand from his reports is that he does accept that Cyprus follows the incorporation theory. However, he suggests that in interpreting the BIT, one should not look at the registered office, but the residence of a company. That's how I understand it.
As we just discussed, you are opining on the Cyprus law, not international law, right?
Correct.
So in paragraph 4.5.8 of your first opinion, you refer to several provisions of the Cyprus company law, which use the term seat.
Yes.
And for the purposes of the tribunal and the transcript, seat in Greek would be edra. That's one of the words in Greek that I recently learned. Is that right?
That's the only word in Greek for seat,
okay.
Edra.
So here you list about six provisions or sections from the Cyprus company law that use the term seat or edra.
Yes.
And these provisions include section 365B to K. Do you see that?
Yes.
And you say here in the last sentence on that page, section 365B2K refers to a company's obligation to publicize any transfer of its seat to or from the Republic of Cyprus. So you agree that the term uses the term seat. And then in the last sentence, you say of this paragraph, in each of these provisions, the term seat has the same meaning as registered office.
Yes.
You confirm? Okay. I assume you are familiar with the full section 365B of the Cyprus company law?
Not by heart, but if you put it
Sure.
up, I can confirm.
So yes, that's what we will do. That's Exhibit C 530. And apologies in advance because the translation of that provision is not on the record. We only have it in Greek, but I assume it's not a problem for you. If you could please, if we could
Excuse
please.
me, sorry to interrupt you, but I think that the translation is available.
It's just that not the full translation of the Cyprus company law. So I will refer you to the Greek version
Okay.
if you don't mind.
Yes, of course.
That's page 331 of the PDF. And if you could maybe read for us and translate 365B to J.
So did you say 365?
B to J. Right before K, which refers to a company's obligation to publicize any transfer of its seat.
Okay.
Can you read and translate for us?
Yeah. The first provision, which is iota in Greek, is details for the registered office of the company and any change to it.
Okay.
And the next one, which is in Greek iota alpha, which is the equivalent of 11 or K,
Okay.
is any transfer of the company's seat.
Okay. So that's what you also say in your report, that the K number 11 refers to seat. So I understand the preceding number refers to registered office. Is that right?
Sorry, say that again.
So the provision you just translated refers to registered office.
Yes.
Whereas the provision immediately after refers to seat. Is that
Yes,
fair?
that's correct, yes.
So you are saying that the two terms in the provisions that immediately follow each other have different meanings, even though they are.
No, I'm saying that they have the exact
Different.
same meaning in relation to Cyprus companies.
Even though they are mentioned right after another and use different terms, you
Yes.
say that they mean the same thing.
Yes.
You mentioned that there was a number of amendments to the Cyprus company law in your opening presentation today. Is that right?
Yes.
Isn't that something that would have been caught if it was a translation issue?
But I don't know. There are many issues in the company's law. I also gave some other examples of bad wording used in the company's law. For example, the Greek word for director is symbolos. And in some instances, the word διευθυντής is used, which is not symbolos, but manager. So there are several drafting issues with the company's law, but I am not in any way involved in the drafting or the amending of these laws. So I do not know if there is any discussion about changing or correcting it.
Okay. But you agree that in this particular provision, one after the other, the law uses different terms and you say they mean the same thing.
Of course, I agree.
You also stated earlier today that you can't have incorporation in Cyprus without having a registered office in Cyprus. Is that right?
Yes.
If we may also refer you to paragraph 4.4.1 of the first opinion. You stated here that the term seat was not used in the Cyprus company law until 1999, and that it was introduced to set certain exemptions from the obligation to submit annual returns and other statutory obligations for companies that were registered before 1974 and had their seat or place of business or the whole of their property in parts of Cyprus territory occupied by Turkey. Now, you probably remember that Mr. Ioannidis submitted to the record relevant forms for these companies that they had to file in order to apply for these exemptions. Do you recall that?
Yes.
If we may pull up KI 035. So as you can see here, the form states, refers to director of the company which has been registered at the Registrar of Companies prior to 1974 and had its seat or place of business or all of its assets at an occupied area. So we just discussed that the registration in the registrar entails having a registered office, and yet the form separately refers to seat. So is it your statement that this is also a mistake?
It is bad drafting. It is the term seat in this context means registered office and nothing else.
So
I explained that in my report, and I also explained why it is impossible, in my opinion, for the term seat under this context to mean anything else but registered office.
So that was the Cyprus company law, some of the examples you referred to in your report. If we can now move to the Cyprus court's case law, which you also use in your reports, and that would be paragraph 4.5.15 of your first opinion. In fifth paragraph 4.5.15, you stated that the Cyprus case law uses the terms seat, registered office interchangeably. And then in footnote 70 to that paragraph, one of the examples for that statement as support, you refer to the OMAS judgment. Do you see that?
Yes.
C545. And you also say in, if we can move down a little bit to point 18, that the OMAS judgment distinguishes between the seat under Cyprus company law, which it considers to be registered office, with the seat of business for VAT purposes. So you actually agree that the OMAS judgment does not use these terms interchangeably. You rather say that they have different meanings under Cyprus law, depending on which law we are looking at. Is that
Yes,
right?
but if you look further up in my report, just a minute. Okay, the VAT legislation, as it applied at the time when OMAS judgment was issued, and I'm stressing that because it changed later on, referred to not to a company's seat, but to seat of business or any other permanent seat. And what the OMAS judgment says is that irrespective of the place of registered office, if the transaction to be taxed, the transaction in question, is more closely related to a business seat of the company elsewhere, then that is the place where VAT is imposed. So I don't really see the relevance to the case, to our case here.
But we have just seen that you refer to this case yourself, right? At footnote 70, you yourself mentioned the OMAS judgment. So you thought it's what
Yes,
was relevant.
Because it uses the term registered office and it differentiates that to the seat of business, not the seat of the company.
But it doesn't use these terms interchangeably. It rather uses them in different contexts.
I need to go through the judgment to be able to tell you that because I cannot remember the exact wording of the judgment. But if you allow me to read it, I can confirm or disagree with you.
Let's do that. We can't refer you to the one that you are referring to because it's just an excerpt, but we have another one, KI 020. That's the full translation of that's the full judgment. And if we can have a look at page 4 of the PDF.
Well, it would be more useful if we looked at the Greek text.
I assume it's down there.
Ms. Deal, would you like also, just as this has been called up, just to draw the witness's attention to the preceding paragraph in his expert report, which is 4.5.17, where he addresses the OMAS judgment in a little bit more detail, rather than just referring to the footnote reference.
Oh, yes.
So he can just refresh his memory, please.
Right. So as the president noted, you also summarize it in 4.5.17. And then if we look at, if I may have a look at first with you at the English version, because I don't speak Greek, and then if need be, we may refer you to the Greek version at page 4 of the OMA's judgment of the PDF. The paragraph that starts with, at first instance, it was judged that the imposition of the additional taxation was legal since the appellants as a registered Cypriot company, as it was apparent both from the 2 invoices, but also from the other evidence, had its seat in Cyprus. So that's one example of how the judgment refers
Yes,
to.
this is exactly what I am saying. In this judgment, I assume that the translation is correct and that the Greek word used in the judgment is edra. I'm not sure, but I assume that is correct. So assuming that this is the case, the reference here to the seat in Cyprus is the reference to the registered office, because in the OMA's case, it was disputed whether VAT should be imposed at the place of incorporation and registered office, which was Cyprus, or the place which was more closely connected to the transaction, which was Greece. So this cannot mean the place of the seat of business or any other definition. The only meaning that can be attributed to the term seat in the highlighted paragraph is the registered office of the company in Cyprus.
If we may also have a look further down in the paragraph that starts with the respondent, and in the middle of it, there's a sentence about the Article 10 of the VAT law, which I think you referred to earlier before.
Sorry, I've lost you. What paragraph is that?
Oh, that's we are still on the OMA's judgment on the screen, so you wouldn't have that printed out.
Can I see the number of the paragraph?
This is the page from the OMA's judgment.
Oh, sorry, I thought it was the report.
Yeah,
Sorry,
so we don't have that in the report. I just referred you to the report for the purposes of where you referred to that.
I'm sorry, please repeat the question.
So here you see that the court also follows that Article 10 of the VAT law concerns when a person for the purposes of Article 9 is deemed to be in Cyprus. And it is obvious from the wording and its general meaning that its reference to seat does not simply refer to the registered one as such. So the court here, I understand, explains that these are 2 different concepts, seat and registered office.
Yes, I can explain that. It's quite simple, basically. Under the VAT law that was enforced at the time, there was a reference to a seat of business. A company could have multiple seats of business. So if you had a company with a registered office in Cyprus that was conducting business in many different jurisdictions through branches or shops, retail shops or whatever in these different jurisdictions, then for VAT purposes, the tax would be imposed at the place which was most closely connected to each of these transactions. So this has nothing to do with the seat theory or the incorporation theory. This has to do with what is the place of the tax point for VAT purposes.
I understand, and this was just for the purpose to show that these 2 terms are not used interchangeably in Cyprus law, because you referred to that judgment to confirm the statement that they are used interchangeably, whereas as we can see from this judgment, this judgment is not about that.
Well, I do not agree, because the highlighted text you pointed to me before is a very clear case where the term seat is used to mean registered office.
But then the other one is not.
The other one is not, because it refers to the seat of business.
If we may also have a look at your second opinion now, paragraph 3.1.7, where you quote to a passage from the MIRA arbitral award, which explained, in your view, how the term seat is understood under Cyprus law. Do you remember that?
Yes, of course I do. It's I did not suggest that the MIRA award is used to interpret Cyprus company law. I'm just saying that it supports my position that under Cyprus company law, seat is registered office.
Okay, if we can have just shortly a closer look at this passage that you quoted. In the third line of the quote, it states, as confirmed by the claimant's legal expert, former Attorney General of Cyprus, Cypriot law does not recognize any notion equivalent to the French law concept of siège social or German law concept of real or effective seat. And then it goes on to say that Mr. Markidas, so that witness, proposed that instead Cypriot law adopts the incorporation approach, and that as a result, a company seated in Cyprus is one that is incorporated in Cyprus and maintains a registered office. So that is essentially your position in this arbitration as well.
I fully adopt that position.
You don't refer in this report, in this chapter or in this paragraph to any other scholarly works on Cyprus law, articles, publications, or case law confirming that position, though, do you? Your only reference to the fact that company seated in Cyprus is the one that is incorporated and maintains a registered office is the MIRA arbitral award.
I respectfully disagree. There are several authorities mentioned in both my reports. Allow me.
While the witness is looking for that, just an observation, you can correct me, counsel, or the witness. I think the reference to Mira investment in footnote 38 to that paragraph, which is CL 72, I think it's incorrect. I think that Mira investment is in the record at RL 20, but not at CL 72, unless I'm much mistaken. It's just for ease of reference.
Okay. We will double check that. So, Mr. Georgiadis, if you can just have a look at paragraph 3.1.7.
I haven't responded to your previous question yet, though.
Yeah, okay.
There are several authorities mentioned in my report which support the position that under Cyprus company law, seat is registered office.
Under Cyprus company law,
if you allow me, I will
just
indicate this. Otherwise, I'm sure that claimant's counsel would do so in their submissions.
If I may just precise my question, I was not asking about Cyprus company law at this moment, but rather Cyprus law, because that's what the passage from the MIRA award refers to. So the passage that we just looked at states that Cypriot law does not recognize any notion equivalent to the concept of real seat.
Yes, I agree with that.
Okay, whereas as we just discussed, this is not true because there are concepts of seat, for instance, in tax law.
The term seat is used in the VAT legislation, but not on its own. It's seat of, let me give you the correct term.
If we may move now to the incorporation theory.
But you're not allowing me to give you the answer. Just, I will be very, very brief. Sorry.
I would just.
Yes, it's seat of business. Seat of business, that is the term that is used in the VAT legislation. As I said, and I think Mr. Ioannidis mentions that there are many statutes in Cyprus using the term seat for many different contexts, but I have not been analyzing in my reports the use of the term seat in contexts which are completely irrelevant to the case. To the extent that the term seat is used under either legislation or case law from Cyprus that is relevant to the case, the term for in relation to Cypriot companies means registered office. That's very clear.
And do you take that from the theory of incorporation, as you refer to it? The incorporation theory, that's where we should look for the definition of the term seat, in your view?
That is the starting point, and I believe that Mr. Ioannidis agrees that the incorporation theory is applied in Cyprus, but it's not just a matter of applying a theory. There are strong authorities and strong wording in the company's law itself supporting this position.
So you are saying essentially that the meaning of the term seat, because it's not defined, is to be found by reference to the registered office. So we just simply, whenever we need to find what seat means, we just look at the registered address. That's your position.
Yes,
That's what incorporation theory means in your view.
yes.
So that's where you actually disagree with Mr. Ioannidis, because Mr. Ioannidis states that this is rather to be found by referring to residence under private international law.
I do not agree with that.
So in support of your statement that the incorporation theory is used to determine seat, you refer to a publication by Mr. Alexandrapoulou, which is C534, an excerpt from European company law. Do you remember that?
Yes.
If you could have a look at that and point me to where this passage says that incorporation theory is used in Cyprus to determine where the seat is.
Well, it's towards the middle, 1, 2, 3, 6 lines from the bottom, where it says which apply the theory of incorporation, and that is in relation to countries of Anglo-Saxon law, like Cyprus.
But it doesn't mention Cyprus, does it? This source.
It doesn't mention Cyprus, but I think that it is beyond any doubt that Cyprus is a former British colony and a common law jurisdiction following Anglo-Saxon law.
Sure, sure. What I was trying to understand is that in my reading, the source rather describes general terms and different concepts. So the passage that you refer us to simply says that there are two theories, incorporation theory and real seat theory, and it doesn't specify which one should be used in Cyprus.
Well, I don't think it's that general. I think it's quite specific, because after Brexit, the only two countries following Anglo-Saxon law are Malta and Cyprus. So it is quite specific, I would say. And if you see the title, you will see that it is freedom of movement in European company law. It does not refer to Anglo-Saxon countries in general, which could be Canada or Australia. It refers to Europe.
But it also isn't entitled Cyprus company law meaning of the term seat, is it?
Sorry?
It's also not entitled Cyprus company law meaning of the term seat, the source.
Well, obviously, yes.
You also stated that EU laws support your position under Cyprus law, that the term seat equals registered office, right?
Yes.
And one example that you refer to is regulation, the so-called insolvency regulation. So that's CL 146. And if we could have a look at page 13 of the PDF, and article 3.1, to which you also refer to in your report. Just bear with me a second.
Could you tell me which report and which paragraph?
Yes, that should be 3.2.2.8 of your second opinion. It's actually quoted there, so we may have a look at that. And the provision that you refer to here states that in the place of the registered office shall be presumed to be the center of its main interests in the absence of proof to the contrary. So would you agree with me that this is a rebuttable presumption?
Yes.
So this means that if there is evidence that company's actual center of management and supervision is elsewhere, then this insolvency regulation doesn't go to the default rule that registered office means.
Yes.
Okay. And this concerns Cyprus because Cyprus is the EU member state as well, right?
Yes, I'm not sure if this particular regulation refers to Cyprus, but I am aware that in some European law instruments, there is express reference to Cyprus and Malta for this particular issue.
And would you agree with me that because this is a rebuttable presumption, it actually does not prove your point that incorporation theory is favored at the EU level, or that it always refers us to the registered address, but it's just a default rule in absence of proof to the contrary? Is that a fair summary?
No, I do not agree, because this provision doesn't state that the seat of that does not say that under the different laws of member states, a reference to seat should be read as meaning something different to registered office. To the contrary, my argument in my reports is that EU law leaves it to the member states to decide on whether to apply the incorporation test or not. The reason why I'm referring to this provision in my report is to show that at EU level, there is a tendency to adopt the incorporation theory by giving prevalence to it. So that's my point.
You also refer to the so-called recast regulation in similar vein to the Brussels regulation. That would be 3.2.2.6 of your second report. Is that you're using that regulation for similar purposes as the one we just discussed?
I've explained that in my presentation earlier today, that this refers to domicile. And under EU law, the place of domicile of a company could be one of the three different, or could be in three different places or more, even more than that. But one of them is always the statutory seat, which in the case of Cyprus is the registered office. So if we have a Cypriot company with a registered office in Cyprus, then that company under EU law is domiciled in Cyprus. It may also be domiciled elsewhere, but it is also domiciled in Cyprus. That's what it says.
But if I'm reading the relevant paragraph 3.2.2.6, it states that the incorporation test looks at the registered office to ascertain the seat of a company is not a novelty of your first opinion. And then you quote the Brussels regulation to confirm that it's also adopted at the EU level.
Correct.
But it uses the term statutory seat. It doesn't use the term seat.
Because it's an EU instrument and the concept of a registered office is unknown in many member states. So if you refer, and if let's say you apply this to a Greek company or a German company, which uses the real seat theory, then the test would be different. The statutory seat may be different. So this is in relation to Cyprus companies and the way I read this EU instrument in relation to Cyprus companies.
My point was rather that it's something different because we are talking here about statutory seat and not seat under Cyprus law. Is that, you agree with me that these are two different things?
No, I do not agree. It basically says here that in Cyprus, statutory seat means registered office, and registered office under Cyprus company law in relation to Cyprus companies is the seat. So it's the same thing.
But would you agree with me that statutory seat is not the same term as seat?
You mean in what context? I mean, you use two terms, statutory seat. In the particular context, it has the exact same meaning, but I stress the exact same meaning in relation to Cyprus companies. I'm not arguing that a statutory seat is the same as seat or real seat or whatever else you may call it in Germany. That may be different, but under Cyprus company law, it is quite clear that seat, statutory seat, and registered office in this context are exactly the same thing.
I understand this is your position. If we could move on now to 3.2.7.5 of your second opinion. And you basically assert here, I'm sorry, point 6, so the next one, that even if the management and control test applied to identify the seat of Kalemegdan and Coropi under the relevant treaty, the seat of both companies would still be in Cyprus. And you also referred to that in your expert presentation today, right? So you have this sort of a fallback option that in case we apply the management and control tests, in your view, it's still in Cyprus. Is that correct? Okay. So apart from the argument about the registered office or address, your arguments for this are that there is a majority of directors reside in Cyprus, and that some meetings happen in Cyprus, or that Mr. Markicevic traveled to Cyprus for some meetings. That's at least what I read from your report. Is that a fair summary? These facts, in your view, confirm this?
I can explain that.
Could you just be yes or no?
I will be brief. In Cyprus, when we talk about the management and control test, it usually has to do with income tax and where such tax is to be imposed. So if we have a company of foreign interest that has been registered in Cyprus, then one will be looking at the circumstances of this case to decide whether tax is to be imposed in Cyprus, because the mere fact of incorporation in Cyprus is not enough. And as a rule of thumb, if that company has a registered office in Cyprus, has a majority of directors resident in Cyprus, and the board meetings and general meetings of the company generally take place in Cyprus, then this would point to the direction that the company is managed and controlled in Cyprus for income tax purposes.
You say this would point to a direction, but you do not refer to any specific case law or publications under Cyprus law that would confirm.
I'm not a tax expert, and it's not my job here to talk to you about tax. I'm referring to this matter because it is a rule of thumb. It's not a rule of statute. It is something that I know very well from my involvement in corporate cases, that this is how our tax authorities see the matter. But as I explained before, no matter what test you apply, in the circumstances of this case, the management and control of both companies was and remains in Cyprus.
Because of the directors' meetings?
Not just that. I said, we heard yesterday that the directors of the company were preparing financial statements, approving financial statements of the company without reference to the UBO or to any other person. So we are here concerned with two holding companies. These are not trading companies. The only thing they do, apart from issuing instructions in relation to the Obnova shares, is to issue and submit financial statements and tax returns. So the only thing that required some element of management or control was done by the directors, the professional directors of the company in Cyprus, without reference or control to any other person. So it is very clear in my mind that both companies were managed and controlled in Cyprus.
So are you saying that, for instance, Kalemegdan, when they were submitting their tax returns, they were doing it on their own and they didn't need to seek any instructions? That's your statement? Or
well, I am not saying that. The witnesses that testified yesterday said that.
Okay, but that's you opine on that, right? On that.
Of course, I do not have personal knowledge of the matter, but if I take that for granted, then yes, it points to the conclusion that I just mentioned.
What if I told you that Kalemegdan was to be instructed by Coropi in this regard? Would that change your position?
In relation to financial statements?
In relation to anything, that Kalemegdan was not able to exercise any administrative decisions or submit tax returns without seeking instructions?
You're probably referring to the document titled Letter of Instructions.
Right.
I am familiar with the contents and the wording, But the management and control of a company is a question of fact. Even if the wording of the letter of instructions was absolutely clear, that and stated, for example, that Kalemegdan should be controlled and managed solely with instructions of Mr. Rand or Coropi or somebody else. It doesn't change the facts. And the fact was that these instructions were not followed. That's what we've heard yesterday, that these instructions were never followed because the activities that were performed by the board of directors in managing and controlling the companies were done without reference to anybody else.
Just for the record, is that the letter of instructions that you referred to, C319? And if we could scroll down, is that by this letter, it is certified that the directors should always obtain instructions, directions, and written consent from Coropi for the implementation of any administration and fiduciary duties. No decisions and resolutions shall be taken without first having obtained the written permission.
Yes,
So
this is
are you-
the.
If I might just ask, is your statement that witness statements kind of override what this document says? Or what was your position? Because this document, in my reading, says that Kalemegdan was not able on its own to file to make
Well,
tax filings.
I think that you are reading, we are probably reading it in a different way, but this is not of any relevance because even if we read it the way you suggest, it was not followed. That was the fact. The fact was that the only activities that had to do with management control were performed without following these instructions. Now, whether that was a breach of contract or a breach of duty or some other, there was any other element of wrongdoing in it is irrelevant. It doesn't change the fact.
Can we also show you I'm not sure whether you were present here during the opening statements or did you
I
just
was
arrive
not.
on Monday? Okay, so if I would like to show you a slide from our opening.
Yes, can I add something there about the letter of instructions? You will notice that the date of the letter of instructions is the 26th of March. It's the day, 3 days after incorporation of Kalemegdan. And it's the day when the fourth director was appointed. It is very usual when local service providers provide fiduciary services to companies to ask clients to sign documents of this sort. They're usually called indemnity agreements. And their purpose is usually twofold. These documents usually say that I will not be doing anything without your permission, but whatever I do with your permission, you will indemnify me for it.
Mhm.
So this is, I see very clearly that the purpose of this document was to provide an indemnity to the local directors and not something else.
Okay, thank you for that. Although I think we are entering the contractual interpretation of that document, which I don't think is necessary at this point. I just wanted to refer you to the slide in our opening submission, which summarizes various statements made by the claimants before this hearing on.
Okay, please allow me to read it because
Of
I
course,
haven't
yeah.
seen it before.
I'm just explaining what it is before you,
Okay,
you
please do.
read. So these are statements from claimants' submissions made before this hearing about how control is exercised by Mr. Rand. And I just wanted to refer you to that because you mentioned that you heard the instructions are not followed. So if you could read through the passages. So I understand you
Coropi,
haven't.
yes.
I understand you haven't seen these sort of statements before.
I've seen some of these references because I have read the evidence of Mr. Rand and Mr. Broshko. I haven't seen them in this form, but I'm happy to answer your questions if you like to ask something specific about it.
So my question is, based on those statements, are you sure that claimants, the instructions are not followed? Because that's what you said earlier.
That's what I heard in evidence yesterday.
Excuse me, may I just seek some clarification here, because I think hearing the witness slightly differently, and I'm looking at the transcript, and the question was, this is at 16:40:26. If I may just ask, is your statement that witness statements kind of override what this document says, or what was your position? Because this document, in my reading, says that Kalemegdan was not able on its own to file tax and to make tax filings. And the answer was, well, I think we are probably reading it in a different way, but this is not of any relevance, because even if we read it in the way in which you suggest it was not followed, that was the fact. The fact is that the only activities that had to do with management and control were performed, and then the language of the witness is, without following these instructions. So he seems to be saying, or you seem to be saying, that management and control activities were performed without following the instructions. Counsel, you seem to be reading that as saying that the instructions were not followed. And there is a space between those, and it would be helpful if you could clarify that. And to the witness, you, of course, when you are including in your evidence what you heard yesterday, is what I understand you to be saying. You are repeating through your own prism the factual testimony. The reading of the factual testimony ultimately is going to be a matter for the tribunal. I think you are asked to address issues of law, but let me just try and clarify before handing the microphone back to Respondents' Counsel. When you say that management and control activities were performed without following these instructions, are you recalling the evidence which suggested that Mr. Rand and Coropi only very seldom gave instructions, and therefore the directors went about their management and control business invariably without needing or receiving instructions? Is that what you are saying?
Well, thank you for the opportunity to clarify the matter. Yes, I'm not suggesting that there were instructions which were not followed. I'm saying that they were performing activities without having to seek instructions from Mr. Rand or Mr. Broshko. So in that sense, the provision in the letter of instructions that was referred to me by counsel before was not followed in my understanding. But this is not just a matter of the evidence that I've listened to yesterday. There is an elaborate section in my second report about management and control, where I explain that even before I've heard yesterday's evidence, my position is that the management and control of both companies was at all material times in Cyprus.
I'll hand the microphone back to Respondents' Counsel. Thank you for clarifying, but I suspect that the clarification will raise questions.
Thank you, Mr. President. Indeed, also for the clarification. I think the expert already clarified what I was looking for. So, Mr. Georgiadis, you referred just now to your report where you elaborate on why the management and control is in Cyprus, right?
Yes.
So that's what I was getting at earlier. So you say you refer to tax to the Cyprus companies being tax residents at paragraph 3.277, for instance. You also refer to, in the next paragraph, to the fact that the majority of directors of both companies were resident in Cyprus. Then you list the names of the directors with the residence. And then at 3.2.7.11, you refer to Mr. Markicevich's travel to Cyprus. And then at 3.2.7.12, you conclude, according to Cyprus law, it is the directors of a company that exercise management and control and not shareholders. So this is essentially the essence of why you think the management and control is in Cyprus. Am I understanding this correctly?
Yes, I also, in my presentation, I've referred to a particular legal exhibit. It is it should be claimant's legal exhibit 207, 208, and 209, where it is stated that the management and control test has a lot to do with the appearance that the company gives to a third party. So if we assume that a person would go to Kalemegdan or Coropi in order to enter into a transaction with them, and that person went to a Cypriot lawyer, asking whether the signature of Mr. Rand and or Mr. Broshko would suffice to bind either of these companies. The answer would be clearly no. If the same person went to the same lawyer and asked whether the signature of the directors of these companies, and especially Kalemegdan, were put, or there was a resolution of the board of directors authorizing a person to enter into a transaction with the person in question without reference or approval from the UBO, and ask whether this would be binding on the two Cypriot companies, the answer would be clearly yes. So the appearance of both companies was that management and control of them was in Cyprus. And there is strong authority to support that.
You also refer to Exhibit C706 as one of the authorities which explain what management and control means in Cyprus. Do you remember that?
Yes. Well, this is not an academic publication. It is a publication by a law firm, but it is a very reputable law firm which is very heavily involved in corporate law. So I would consider this to be strong authority on Cyprus law.
So if we look at page 7 of this PDF, the last paragraph, the management and control notion refers to the management and control of the business of the company. It refers to the decision-making process to set down the fundamental policies, the key strategic decisions, and the procedures to meet the targets of the company.
Correct.
So you agree with that this is where management and control is exercised under Cyprus law, where key strategic decisions and fundamental policies are made?
For income tax purposes, yes. For in deciding residence, no.
But you are referring to that in the section of your report where you say why management and control is in Cyprus.
Yes, because my argument is even if we apply any of the tests, the result is still the same.
Exactly. Are you familiar with the Lerstate judgment? I'm not sure if
Which judgment?
I'm pronouncing it right.
Sartas.
Lerstate, KI 051.
Sorry, I didn't get it.
Yeah, we will pull it up. That was invoked by Mr. Ioannidis. Do you remember this reference? Are you familiar with that?
I have read it, but I cannot recall now the context of a specific case. But if you allow me to read it, I can answer your questions.
I just wanted to refer you to a paragraph which refers to the directors' meetings. And it was invoked in Mr. Ioannidis' recent report. Which I understand you have read, the third report of, the third opinion
yes, I
of
have.
Mr. Ioannidis. Okay.
Sorry, where are we looking?
Yeah, exactly. Apologies, Mr. President. Just a second. Page 21 of the PDF, KI 051. There is no assumption that CMC, which is defined earlier as central management and control, must be found where the directors meet. It is entirely a question of fact where it is found. Where a company is managed by its directors in board meetings, it will normally be where the board meetings are held. But if the management is carried out outside board meetings, one needs to ask who was managing the company by making high-level decisions. So wouldn't you agree that this authority confirms what also the report that we just looked at states, that management and control is where the key decisions are made? Yes or no?
No, I do not agree. I can explain, of course, if you give me the chance.
In your view, this judgment doesn't confirm that?
It says, it probably refers to income tax. I am assuming, because you didn't give me the chance to read the full case, but I assume that it refers to income tax. And I'm saying that for income tax purposes, the test of management and control is a question of fact. The factors to which I referred before, majority of board of directors, place of meetings, etc., are a rule of thumb. They create a presumption. They do not necessarily point to the place of management and control. However, when we talk about residence, which is what Mr. Ioannidis is suggesting in his reports, the test is not where the key decision making on policy matters is made. The test is where the actual control and management of the company takes place, and especially in the eyes of third parties. And I have cited authorities to support that, which I referred before.
But you have not referred to any case law that would contradict this judgment.
But I do not oppose that. I'm saying that this refers to income tax.
Understood. Mr. Georgiadis, if we could just briefly move to another topic, the registered office. You stated in your presentation today that the names of the companies, Coropi and Kalemegdan, are affixed outside the building.
Yes.
So in present tense, as in are right now.
Well, it's in my report, so it refers to the date of my report. I'm not sure if they are still there today, but I assume they are. I haven't visited the building after the date of my report.
And that was 20 December 2023, right?
20th of December 2023.
This is not the first time you were there, right?
It was the third time I was there.
Okay. And do you recall that when you, so the previous visits were for the purpose of the previous arbitration, the RAND case? Right?
I had, the second visit was for the RAND arbitration. And the first visit was more than 10 years ago when I was asked by one of the partners to have a meeting and discuss our services and explore the possibility of cooperation, but we've never actually worked together on any matter.
Okay. And do you recall that when you visited the premises for the RAND case, you also submitted a report showing the names of the companies that were registered there? And do you remember whether that Coropi and Kalemegdan were not named? The names were not affixed then?
I did not check that because at the time when I visited to check for the case was Sembi Investments, I think, in the RAND arbitration. So when I visited, I looked for that particular company's name. There were several names affixed, but I didn't check them all because I didn't think that it would be there would be another arbitration for the same client.
So was that, just to be clear, was it outside the building or the name?
It is outside the building.
And to your knowledge, are Coropi and Kalemegdan the only two companies registered on that address, or are there more companies?
Well, I do know that there is at least one more, which is Sembi Investments, but I think it's safe to assume that there should be many more because HLB Cyprus is a corporate service provider. I don't think it would be sustainable if you only have 3 clients.
Understood. I just wanted to clarify that. And let's move on to trusts. And your first opinion, point 111. You say here that you received instructions on 4th December 2023 from Claimants Council, right?
Yes.
Have you reviewed claimant submissions regarding the trust issues or otherwise that were submitted in this arbitration before that date?
Before the 4th of December.
Yeah. I mean, not that you review them before that date, but submissions that were made before 4th December 2023. There were at least 2.
You mean pleadings?
Yes.
I believe so. Maybe the initial submission of pleadings from both sides, but I'm not sure.
And you reviewed them after you were instructed?
Well, my job was not to review the pleadings. My job was to review the report of Mr. Ioannidis. So I may, to the extent that Mr. Ioannidis was referring to pleadings, I may have looked into them, but I didn't go through them in order to answer to the pleadings. My job was to answer to the report of Mr. Ioannidis.
I understand, but I was trying to establish when you had the look at the pleadings. Was that before you were instructed on 4th December or after?
I don't think it was before, because I think that the 4th of December is probably the day of my formal engagement. I may have received documents a few days before that, but I certainly haven't reviewed them before my formal appointment on the case.
I would like to show you a passage of one of these submissions, Claimant's Memorial, dated 31st
Yes.
March 2023, paragraph 95. It states here, based on the trust deeds, Coropi therefore became the 100% beneficial owner of Kalemegdan. As a result, Coropi also became the indirect beneficial owner of the Cypriot Obnova shares. That's not really what you are saying in this arbitration, is it?
This was drafted before I was appointed. I have discussed this with Claimants Council. When I prepared my first report, I was told that this position was put in their pleadings. I told them that this is not entirely correct, because in my opinion, the trust was not created on the day of the trust deeds, but the trust was created on the day of incorporation of Kalemegdan, which was about a month before that date. And to the credit of Claimants Council, they did not ask me to change my opinion, but I understand that in subsequent pleadings, they adopted my position.
Thank you for that clarification. I was under the impression that earlier today you said in your presentation that this issue of 1 month before the trust deed is not that relevant, but I understand it actually is relevant since you clarified this with the council. Wouldn't you agree?
Look, I do not act as counsel here, so I do not want to bind the claimant as to what is relevant or not in this arbitration. In my mind, because between the date of incorporation of Kalemegdan and the date of the trust deeds, Kalemegdan did not have any asset. This shouldn't be very relevant to the case, but there may be things that I am missing because I am not briefed to comment on the entirety of issues in this case, but only on specific matters of Cyprus law.
Can we have a look at 533 of your first opinion? So that was, I understand, after you reviewed these submissions. You state here that in the second line, there is some ambiguity as to where the beneficial interest in the initial issued share capital vested before the date of the first trust deed, i.e. before 23rd March and the 26th of April. So you admitted that there is no clarity about this first month.
Yes, but I also explained, I think quite thoroughly, that the evidence that was put before me, which is the letter of instructions, the fact and the wording of the trust deeds, and the actions of all the persons involved resolve this ambiguity. And that my conclusion is that on the evidence, there was an express trust from the date of incorporation. It is analyzed in both reports, but I think it's more extensively analyzed in my second report.
So just that I get this right, and you would appreciate that it's very important for us to establish when the beneficial interest took place and how. So you're saying that your conclusion that an express trust was created is based on the trust deed and the letter of instructions? Is that what you just said? You stated.
Not really.
I think quite thoroughly that the evidence that was put before me, which is the letter of instructions, that's what you just said. So I'm just trying to understand what is the basis for your conclusion that there was an express trust. Is it the trust deed or is it the letter of instructions or something else?
Well, if I refer you to my second report, paragraph 4.2.2.3, I do refer there to the evidence that was made available to me and on which I based my conclusion.
So that
Then,
includes.
as I said before, and I think Mr. Ioannidis agrees,
Mhm.
there is no need for any formality or requirement in writing. So if Mr. Obradovic went to the offices of HLB Cyprus and said, these shares I hold on trust for Coropi, that would suffice. But the evidence is stronger than that.
Just for the record, in this paragraph you referred to, you state, in the present case, there is strong evidence confirming the declaration of trust, including the letter of instructions, the trust deed, and the oral testimony of Mr. Broshko and Mr. Rand, right? That's what you just referred
Yes, if
to.
you take, for example, the letter of instructions, we have 3 professional directors here who sign a document which talks about the beneficial ownership being vested elsewhere. There is no reason why 3 professional advisors would do something like that if it was not clear in their minds that there was a trust in place.
So that's about the letter of instructions. At
Yes.
paragraph 522 of your first opinion, you actually stated, in my opinion, the letter of instruction was not intended to create a trust.
I didn't say it was intended. I'm just saying that it confirms that it was created. So
So the trust existed before?
Sorry?
So the trust existed before the letter of instructions? Is that your view?
Well, and is the date of the instructions the same as the date of incorporation? If it's the same, then it's not before, it's on the same date.
That same date, okay. You also stated you stated today that you agree with Mr. Ioannidis that these 3 certainties have to be established, so that certainty as to property, intention to create a trust, and beneficiaries. And that's the applicable test to assess whether there is a trust or not under Cyprus law.
Yes, this is very basic knowledge.
Okay. So if there is certainty as to these 3 things, an express trust is created. I'm just struggling to understand, from your opinion, what's the threshold of the certainty? Because you mentioned today that there has to be sufficient clarity as to this intention, for instance. Do you remember mentioning that?
Yes, it's with the threshold, you mean what is the evidentiary burden? Is that what you mean?
When are we certain as to the intention? That
Well,
would
you
be
don't
my
need to be
question.
certain under Cyprus law of evidence.
Didn't you?
I'm not sure what level of proof is required in these proceedings, but I don't think it is absolute certainty.
I am not actually referring to evidentiary proof. I'm referring to the certainty test that you just confirmed applies in Cyprus law. So how do you establish certainty?
Sufficiently clear.
Sufficiently clear. So in your first opinion at 4.228,
438.
4228, probably maybe that's the second. Apologies. Yeah, that would be second opinion, I'm sorry, 4228 of the second opinion. And you stated here, it is the settler's intention that must be established to create a trust, and the settler in this case is Mr. Obradovich. Do you maintain that?
Yes.
So taking from what we just discussed, there needs to be sufficient clarity as to the intention of Mr. Obradovich. Wouldn't you agree?
Sorry, say that again.
So taking from what we just discussed about the certainty, the sufficient clarity, as you called it, we would need a sufficient clarity of the intention of Mr. Obradovich.
Yes, correct.
Okay. And Mr. Obradovich is not, you haven't seen any witness evidence from Mr. Obradovich, am I correct?
No.
So where do you find this sufficient clarity of his intention?
Well, I do mention that in the paragraph that I've referred to before, which is (4.2.2.9) and 4.2.2.3. I'm saying that there is evidence of Mr. Broshko, Mr. Rand, there is letter of instructions, there is the actions of Mr. Obradovich, the actions of the board of directors.
What actions
So
of
that
Mr. Obradovich do you mean?
Well, Mr. Obradovich has asked for a company to be set up. He was a member of the board of directors.
Have you seen
And
any
the professional,
documents?
sorry, and the board of directors, the professional directors of that company have signed documents about the trust.
Have
So
you
it is beyond doubt. Now, if you're asserting that you cannot prove the intention of Mr. Obradovich without the evidence of Mr. Obradovich, that's not correct, with all the respect. Mr. Obradovich could have been unable to give evidence for many different reasons. It's not the only way to prove a statement by presenting the maker. And I can say that with some certainty. Allow me to say that I teach law of evidence for more than 10 years. So it is quite clear in my mind that this is not the case.
And do you understand that Mr. Ioannidis disagrees with you on that? So in his view, we would benefit from a statement from Mr. Obradovich.
Well, as I said before, I'm not the one to say what Mr. Ioannidis' opinion
But
is.
you understand that this is the disagreement, right?
I understand that we disagree, yes.
You stated in the transcript just now that 1710:59. Well, Mr. Obradovich has asked for a company to be set up. In which document did he ask for it? Can you point me to a document?
Well, that's something that I assume because he was registered as a shareholder of that company. And in order to do that, you have to sign a document in person or by power of attorney. So the possibility of the company being registered without instructions by Mr. Obradovich, it's very remote.
So you assume that he asked.
I safely assume.
Would part of this assumption be resulting from the trust deed and the fact that he signed it?
No, because even before that, because the first trust deed was signed on the 26th of April, if I'm correct. But Mr. Obradovich was appointed as director and became a shareholder of the company about a month before that.
Mm-hmm.
And in order to effect that, Mr. Obradovich must have signed certain documents. So it is safe to assume that he asked for the company to be registered.
But you haven't seen those documents, am I right? You just assume that they exist because he was on the board or because he was the shareholder?
Well, I know very well that it is not possible for such a transfer. For example, sorry, I'm very confident to say that it was not possible under Cyprus law for Mr. Obradovic to be registered as a shareholder and become a director without signing. So it's a very safe assumption.
Ms. Teal, at some point quite soon, we're going to need to take a break. So you tell me whether you've got the end of your line of questioning or whether you want to continue for a minute or two more, but we've been going now for about 100 minutes. And I think it's fair to the witness and to the rest of us into quite a hot room. that we
I'm
take a break.
I'm happy to take the break now, and also just for the tribunal's purposes, I don't need much more time generally, but of course, I understand that.
Let's take that break because there's then going to be redirect and then there's
Of
going to
course,
be tribunal questions. So let's take a break for 15 minutes. Studios, you are sequestered, admonished not to speak to anyone. You know the drill. I'll see everyone back here at 5:30. I propose that we leave the door open. And we have been throughout the day communicating with the staff here about turning the temperature down. And that has not, Oladimeji, would you just leave the doors open, please? We are assured that the heating will be turned down, but in any event, it may be the last stretch. So in the hot seat has a new meaning. Ms. Dear, let's go back to you for your further cross.
Thank you, Mr. President, and I promise from my side the hot seats will not take very long. Mr. Georgiadis, welcome back. So can we move to paragraph 224 of your second opinion? You stated that even if there was a defect in the initial creation of the trust, i.e. between the date of incorporation of Kalemegdan and the date of the first trust deed, which there wasn't, the result would still be the same because a constructive trust with the same effect would have been created during that period. So that I just get it right, is your opinion that it is an express trust or a constructive trust?
An express trust.
So why are you referring to the constructive trust concept?
Because I'm saying even if I am wrong and there has been no express trust at the date of incorporation of Kalemegdan, there would still be a trust, but that would be a constructive trust until the date of the trust deeds, when whatever there was before was replaced by the trust deeds.
And when would you be wrong as to the express trust?
Excuse me?
When would you be wrong as to the express trust?
Well, I am not wrong.
Then why are you proposing this alternative?
Because it's not for me to decide, but for the tribunal. The tribunal may find that my argument is not convincing.
Would that refer to your argument on the clarity of intention or something else? As in, I'm trying to understand in which case the tribunal should look at the constructive trust at all.
I don't really see the possibility of a defect in the clarity of intention. There is no description of the subject matter in writing. So I see a weakness in the oral, in the declaration of trust that was done at incorporation there. If I were to judge that, I would have had second thoughts on whether this did actually create an express trust or not. But I have done this exercise, and in my mind, there was an express trust.
So you are now referring to the trust deeds, the C66, if we can pull it up. So just we are sure where you see this potential weakness.
No, I'm not referring to trust deeds. I'm referring to the period before the trust deeds were entered. So it's the period between the end of March, when the company was set up, and the 26th of April, when the trust deeds were entered. From the date of the trust deeds, I think it is beyond doubt that there was an express trust in place. Before that date, for the period of 4 or 5 weeks before the trust deeds were entered, there is some ambiguity, which in my mind still does not negate the existence of a trust. And that trust is most probably an express trust.
Is it also fair to say that this ambiguity, in your view, was cured by the witness statements you have seen before submitting your second opinion?
It wasn't cured. It was the testimonies. Are you referring to the written testimony or the oral testimony? Yes. The written testimonies that I have read, which is that of Mr. William Rand and Mr. Broshko, is evidence which, in my mind, supports my position that there has been a trust from the date of incorporation.
And in your view, actually, in your words from your reports, this is actually strong evidence, right? That's the words that you're using.
I'm not referring to the evidence of Mr. Broshko and Mr. Rand alone. I'm referring to a few pieces of evidence, and I'm saying that the totality of evidence is strong evidence that it has always been the understanding that the Obnova shares would be held through Kalemegdan on trust for Coropi.
So we have clarity starting from the trust deed, but we have ambiguity as regards to what happened in the month before. Is that correct?
I'm saying that there is a weakness in the evidence before that date, but that ambiguity should not be read as negating the existence of the trust.
In which case that would be a constructive trust.
No, my opinion is that it was not. It was an express trust. But even if I am wrong, there still was a trust, and that was a constructive trust. The possibility of there being no trust at all in those 4 or 5 weeks before the first trust deed is, I would say, very remote.
If we can, because you referred to witness statement, the first witness statement of Mr. Rand in your report at paragraph 37 and 40. First witness statement of Mr. Rand, and that would be, for instance, in your report, second report 4223. That's where you refer to witness evidence. So if we can have a look at Mr. Rand's witness statement, maybe first page to refresh your.
There is a cross reference to my first opinion,
Okay,
and that is the reference to the testimony.
That would be
helps.
5-1 of your first opinion, probably. That's where at least the
It's
point where
5-3 of my first opinion.
where you refer to witness evidence that you have seen.
Yes, it is. Is this the evidence of Mr. Broshko or Mr. Rand?
Mr. Rand, and that's what I
Okay.
wanted to.
So that would be paragraphs 15, 33, 40, and 41 of
Okay.
the witness statement dated 23rd of February, 2024.
Okay, so let's have a look at that in paragraph 40. Maybe let's have first look at 37, just for context, so that we know where we are in time. You say here, you see that Mr. Rand testified here that while the ownership of all of my Serbian companies would be held through Cyprus, I retained Mr. Obradovic as the nominal owner of Kalemegdan. Before he became the nominal owner of Kalemegdan, Mr. Obradovic agreed to always follow my instructions with respect to any matters related to Kalemegdan. And then if we go to paragraph 40, Mr. Rand testified that in furtherance of Coropi's beneficial ownership, I later instructed Mr. Obradovic to conclude 2 trust deeds with Coropi. So this assumes that the beneficial ownership existed before the first trust deed.
Well, I do refer to a few other paragraphs as well. So if you isolate a reference in the witness statement, it may not give the full meaning as I suggested. But if you also read paragraphs 15 and 33 and 41, I believe that it is quite clear that it leads to the conclusion that there was a trust before the first trust deed was entered.
That's sufficient. That's the point that I was trying to make. But you refer to paragraph 40, right? Also, so in furtherance of Coropi's beneficial ownership, I later instructed Mr. Obradovic to conclude the 2 trust deeds. So why would Mr. Rand instruct Mr. Obradovic to conclude trust deeds in furtherance of Coropi's beneficial ownership if Coropi had already been the beneficial owner of Mr. Obradovic's shares? That's what I'm not clear on.
Well, he should have done it from the beginning.
He should have done it from the beginning.
Yes, I mean, if you have a trust on shares on a company that holds substantial assets, you want to have that in writing. So it was very reasonable for the trustees to be entered. Now that they were not executed from day one of incorporation is not best practice. But as I said before, it doesn't really change much because on the date when it was resolved for Kalemegdan to acquire the Obnova shares, the first trust deed was entered, which in my mind, clearly shows that it was important to formalize the trust on the date of taking that decision.
So just one more reference on that point. Your second opinion 4229. 4229.
Yes.
The evidence, you stated it was not necessary for Coropi to have expressed an interest in or have paid any amount for the Obnova shares, as there are no such similar requirements for the creation of a trust under Cyprus law. The evidence shows clearly that it was the common intention, inferred, if not expressed, of Mr. Obradovich, Mr. Rand, and Coropi that Kalemegdan shares would be held on trust for Coropi. So was it an express or inferred intention?
Well,
Because
as I say here, even if it wasn't expressed, it was inferred. The evidence that was put before me does not include the actual conversations. But there is nothing, at least I do not recall in the testimony of Mr. Rand or Mr. Broshko quoting the conversation with Mr. Obradovich saying that I hold these shares on your behalf.
Understand.
So I do not know what the discussion was, but it doesn't really change anything because it is quite clear from their evidence, which I understand that is not contested, that that was the intention, the clear intention from the beginning.
I would say we're missing evidence from Mr. Obradovich on that, but to tackle it from a different angle, is Mr. Georgiades' consideration an important element in your view when we are looking at creation of trusts?
No. There is no requirement for consideration for the creation of a trust.
There is no requirement, but would it be something that you would also look at?
No.
To
It can be relevant.
To infer an intention, for instance, or?
If there's a trust arrangement which involves some form of consideration, that consideration or the absence of consideration could be relevant in many different scenarios, which I can explain, but it will take some time because they are quite plenty.
At 4 to
Sorry, I haven't finished. I'm just waiting for it.
Okay.
But in this case, I don't really see the relevance because there is no such requirement. And in any case, I was not asked to advise about the issue of consideration. It's not even, I do not even know if the fact of there being a consideration or not is a matter of Cyprus law or Serbian law or something else. I was not asked to comment on that.
At paragraph 4228 of your second opinion, you quote to Cyprus case law, according to which
the Adamu case.
Yes, correct. And towards, like, I think, fifth line from the bottom, sorry, somewhat in the middle of this paragraph, a contract or an express trust as at the time of the acquisition may not be established because of lack of certainty or consideration or non-compliance with statutory requirements in writing. So that would show that consideration may be an important point when deciding on whether the trust existed or not under Cyprus case law.
If the trust is created by contract and there is no consideration, the contract is invalid, so it does not create a trust under Cyprus law.
And you do not refer to any consideration
But
being...
still, it may create a constructive trust.
Understood. You do not refer to whether or not a consideration was provided in this case, right, in your reports?
No.
But you have referred to witness statements that were that we have heard yesterday. You probably have heard Mr. Broshko testifying about the consideration that he had provided to Mr. Obradovich.
I've heard part of that testimony. I'm not sure if I've heard the whole testimony on that matter, but I am confident that I've heard most of it.
Do you remember that Mr. Broshko mentioned that it was around 10 euros, the consideration?
But that was nominal consideration. If Cyprus law applies, which I do not know, then even €1 would be sufficient, because we have a principle which is very known very well known to English lawyers, that any consideration of value is good consideration. And Cyprus law follows English law on this subject, with the only difference that in Cyprus, past consideration is good consideration, unlike English law.
If we look on the top of the paragraph with the case law that we just cited, it refers to the authority now classic in the speech of Lord Diplock in Gissing versus Gissing, right? Do you see that? The
Yes.
English case that it refers to. So if I may now direct you to an exhibit submitted by Mr. Ioannidis, KI 07. And page 15 of the PDF. Of the Greek version, yeah, page 15 of the PDF, but there is an English quote. As you can see here, the Greek section refers to the same case, Gissing versus Gissing. And then if we scroll down to page 16, in the middle, this inference of a trust is readily drawn when each has made a financial contribution to the purchase price or to the mortgage installments. The financial contribution may be direct. It may be indirect. And then it does not matter who pays what, so long as there is a substantial financial contribution towards the family expenses, it raises the inference of a trust. But where it is insubstantial, no such inference can be drawn. Wouldn't you agree that this contradicts?
No,
your
it doesn't.
statement
I will
that-
explain. It's quite simple, at least from a common law perspective, it's quite simple. If I buy a car and my wife pays 50% of the purchase price of that car, and the car is registered in her name, that doesn't make her an absolute owner of the car. Because I have contributed to the purchase of the car, there is a trust, which could be a constructive trust or a resulting trust, meaning that I am entitled to part of the beneficial ownership of that car. So putting this simple example, this is what it says here. It doesn't mean that there has to be a contribution or that has to be consideration to create a trust. It says that in circumstances where the legal title vests with a particular person and there is a claim by another person that he or she is entitled to part of the beneficial title, then he or she must prove one of the ways he can prove the beneficial interest is by proving financial contribution. And it is a very usual matter in family disputes.
I understand. I referred to the family case law because you referred to that in your report, but also the example that you just referred to assume that the wife pays 50% of the purchase price. Would it be different if it was 0.5% of the purchase price?
Well, the beneficial interest would obviously be different.
Exactly. And just very last point, Mr. Georgiadis.
I'm not an expert in family law, but I think that there is a presumption. I think that there is a presumption if a car is purchased by a married couple and is registered in the name of one of them, there is a presumption that maybe a third or something like that is of the beneficial interest vests with the other person. But as I said, I have never done family law, so I may be wrong.
Just my last point. You might remember that Mr. Ioannidis concluded that if Coropi had been the beneficial owner of Kalemegdan in 2012, it would have been reflected in Coropi's financial statements. Do you remember?
I remember that, yes, of course.
And do you agree that it is not reflected in the financial statements for 2012?
Well, I see a reference there to the principal activity being a holding company. I don't recall the contents of the financial statements, but in any case, I believe that Mr. Ioannidis is not citing an authority for that. And I'm not sure if his position is correct, whether this should be stated in the financial statements and in what way. But even if there was an obligation to do that, and it wasn't done, it doesn't change the fact that there was a trustee. Maybe there was a mistake in the accounts, if I assume that his position is correct, but that doesn't dissolve the trust.
But you agree that the highlighted part states that during the relevant period, which is for the year ended in December 2012, the company, meaning Coropi, remained dormant. That's what it says, right?
Yes, but I do agree that this is what it says, yes.
Thank you. That concludes my questions, Mr. President.
Thank you very much. Redirect.
No questions, Mr. President.
Thank you, Mr. Georgiadis. I think there are some questions from members of the tribunal.
Good evening.
Oh, I'm sorry. Paragraph 4.2.2.4 of your second report. And I just want to get your view on something that your colleague, Mr. Ioannidis, referred to, because he mentioned this question was arising under Section 51 of the Companies Law. And you say there that if you go down and scroll down a bit, it's not clear if such defect, and you say that he makes the allegation by without referring to documents that were in the evidence. So I think he does refer to some documents. So I'll take you to a few of them, and just to get your view on it, just so that we have the view of both experts. So Section 51 of the Companies Law is at KL 42. So perhaps we could bring that up. And just for context, just to remind you that the context here is that because the contribution of shares to Kalemegdan in exchange for shares of Kalemegdan, because that contribution was in kind, there had to be a contract for the sale of the shares. That's the point that is being made, and that seems to be confirmed in Section 51 of the Companies Law. First of all, is that your understanding as well, that if the shares are being contributed in kind in exchange for other shares, then you would need to present a contract?
Yes, this is what it says, yes.
And just to be clear, this point seems to be more relevant to whether Kalemegdan paid consideration for the shares that Mr. Obradovic contributed to that company, rather than the trust question, just to put it in context. And am I right in thinking that the reason there has to be a contract is that would be the basis upon which the state would calculate stamp duty?
I think you are correct, but I am not 100% sure.
Okay. And then if we go to the registry, and this is at KL 43, if we can have a look at that one. So this is referring to the allotment of shares. If we scroll down a little bit, and this is the amount that represents I think that's fair to say, the nominal value of the shares that were contributed. But you see there, it says, when it says form of payment, it says cash. That's incorrect, isn't it?
I do not know, because the evidence in relation to the consideration was not put before me. I was not asked to give an opinion on this matter.
Okay. Well, I represent to you that the evidence is that no cash was provided. It was a share exchange.
If I have no reason to doubt what you say. If the payment was not made by a payment of money, cash doesn't necessarily mean cash banknotes, but a payment of money, then this is incorrect.
And what would be the consequences of that as a matter of Cypriot law?
Well, we probably need to go back to the relevant article of the law to see that, but it wouldn't invalidate the transfer. Maybe it was. Well, I don't know. I prefer not to assume, but look at the provision.
You might need to scroll down a bit.
I do have a clean copy of the Greek version of the company's law, which, if you, with your permission, I could look at and point you to the right provision.
I think it goes on to talk about the consequences there. That's helpful. Oh, the Greek version. Sorry, is it there in the same document? Scroll down.
You scroll down. There's the Greek.
So it says in paragraph 2 that if the agreement was not put in writing, the company delivers to the registrar for filing within a month from the allotment the required details of the contract, having the same stamp duty as if the company was in writing. If there is, paragraph 3, if there is no compliance with this article, every officer of the company, meaning the directors and secretary, is liable for the omission, and a fine may be imposed not exceeding £250 for every day that the omission is continued.
I'll note simply that the English translation says 427 euros.
It's probably because they've changed that from pounds to euros. One Cypriot pound is equivalent to approximately 1.71 euro.
I understand that, but the English text is purporting to be a translation of the Greek text.
Maybe it's the unofficial translation by the law commissioner, and maybe it is based on a previous edition of the law, not consolidating on all the amendments. But I do not know, because it's not an exhibit in my report, it's an exhibit of Mr. Ioannidis.
Okay, on to the trust question then. You said at some point in your testimony that if Mr. Obradovic went to the offices of Kalemegdan and said, I declare the trust, the shares I hold on trust for Coropi, then that would be sufficient, which is sort of a graphic illustration of what an oral express trust would look like. The difficulty I have here is that we don't have witness evidence from the person who would have been making that declaration, Mr. Obradovic, and we don't have any witness evidence of people who heard that declaration, which in this case, given that was a declaration that would have been made to Coropi, would have had to have been the board of directors of Coropi. So we don't have witness evidence from the person making the declaration, and we don't have any witness evidence from the person who allegedly heard the declaration.
Well, I do not know the circumstances under which the declaration was made. I understand that it was quite clear in the minds of Obradovic, Rand, and Broshko that this was the intention, but...
Just pausing there though, we haven't heard from Mr. Obradovic, and there's nothing in those two other witness statements of Mr. Rand and Mr. Broshko that says on such and such a day a declaration of trust was made to me. We don't have anything.
We have the letter of instructions.
Okay, fair enough. So let's move on to that. But I think we can agree that on the date, because you say that the express trust was created on the date that Kalemegdan was incorporated. That was on the 23rd of March 2012.
Correct.
Okay, so we don't have anything at that point that would evidence the express trust. But then you mentioned the letter of instruction. That came, and I just wanted to clear up that my understanding is that came 3 days later, on the 26th of March.
Yes, that is the day when the fourth director was appointed. I don't know why, but that was the date. It was probably asked for the reason I mentioned before, that this is not the purpose of this letter was to expressly provide for an indemnity for the professional directors. So that's my understanding of it.
Okay. So this is the difficulty I have with this letter of instructions, because it purports to be a letter of instruction from Coropi to the directors of Kalemegdan. Is it possible, as a matter of Cypriot law, for the directors of a company to say that they'll comply with instructions of someone else without consulting the 100% owned shareholder of the company? Because the 100% shareholder of the company here is Mr. Obradovic, and there's no reference in this document to any consent that the 100% shareholder is giving to the board of directors to fulfill the instructions of the third party.
Well, actually, again, in my mind, this shows clearly that the professional directors who signed these instructions had it very clear in their minds that this is what was the understanding between Mr. Obradovic and the other related persons.
But that's a slightly different point. My point is that, as a general matter, is it really possible for a board of directors to agree to fulfill the instructions of a third party without consulting, without an agreement of the 100% shareholder? There's no agreement referred to in this letter. Mr. Obradovic is not even mentioned in this letter.
Well, there is no, I'm not aware of any written agreement, but I think that it is quite unlikely that the understanding of the directors was anything but that there was such an agreement.
Why wouldn't they say so in this letter? That would be the obvious thing to do, wouldn't it? I mean, if there was an agreement or a trust or something in place, you'd expect the foundation for this, which looks highly unusual, to have been set out. The other reason I say it looks highly unusual is that this sort of thing was expressly prevented by the Articles of Association of Kalemegdan, Regulation 12, which you referred to, which has been at the point of some exchanges. That says expressly that this sort of thing shouldn't and can't happen.
Okay, well, there are two questions, basically. The first question is about why there was no reference in the letter of instructions, which is not something that I'm aware of. I assume that this was probably a standard form document used by HLB Cyprus, which is not of Rolls-Royce drafting. So I think that's the explanation for it. In relation to the second point, which is about Article 12, I respectfully do not agree with this position, because that is not what Article 12 does. What Article 12 does is, as I give the example in my reports, if, for example, there is a registered owner of shares, and he holds shares with a nominal value of 1,000 euro, and there is a call on the shares, so that he has to pay 1,000 euros to the company. And that person presents a trust deed saying, you shouldn't ask me to pay, you should ask Mr. X to pay this amount. The company doesn't have to not recognize the trust, but has the right not to recognize the trust. So that is what it says.
Can we just bring up the text? I'm not sure where it is, but it's somewhere.
Article 12.
Yeah, it may be. There we are.
It's in paragraph 7.22 of the first opinion of Mr. Ioannidis.
I think we've got on the screen.
Oh, sorry.
Yeah.
Sorry. Yes, can we go to the Greek test? I think you're looking at the memorandum.
Are you reading or are you waiting for the question?
I'm waiting for a question.
Oh, no, sorry. I thought, do you want to elaborate anything further on Regulation 12? I mean,
Well, I remain to the position that I've put before, that this does not mean that a company cannot accept. It means that it is not bound to accept. And in this case, the company did accept, the trust did.
what evidence do we have of that?
We have the letter of instruction signed by the 3 professional directors, and we also have the trust deeds.
But I mean, as I said, the letter of instruction doesn't even refer to Mr. Obradovic. So you're saying that that the express trust existed on the date of incorporation, which was 3 days earlier, and you're saying that Article 12 doesn't prevent the company from being bound by the letter of instruction.
No, I said that the letter of instruction on its own does not prove the trust. It is part of the evidence that proves the trust. The letter of instruction does not refer to Mr. Obradovic, but I find it extremely unlikely that 3 professional directors would have signed it knowing that the registered owner of the shares is Mr. Obradovic, unless they knew very well and they were satisfied that the understanding was that there was a trust. Yes, this is my position.
Okay. And just finally, hopefully, could we bring up Mr. Rand's first witness statement? Paragraph 37. And it says that in the second sentence, well, I'll read the whole thing. While the ownership of all my Serbian companies would be held through Cyprus, I retain Mr. Obradovic as the nominal owner of Kalemegdan. Before he came the nominal owner of Kalemegdan, Mr. Obradovic agreed to always follow my instructions with respect to any matters related to Kalemegdan. Now, my reading of that is that if there was a trust involved, it's more likely to have been in favor of Mr. Rand. Because how can you have a situation where Mr. Obradovic would be under a fiduciary duty to act in the best interests of Coropi, and at the same time do everything that Mr. Rand told him to do?
My understanding is that the arrangement between Mr. Rand and Mr. Obradovic was concluded before the incorporation of Kalemegdan. because of their various activities together, and because the various investments were made with the money of Mr. Rand and sometimes registered in the name of Mr. Obradovic. And I read this statement as meaning that even before he became the nominal owner, he was the registered owner of Kalemegdan, which was on the 23rd of March 2012, the day of incorporation of Kalemegdan. There was an understanding even before that, that the matters of Kalemegdan would be dealt with his instructions. This is how I read it. But I don't see how this contradicts what I said before.
Well, you can only execute instructions relating to matters concerning Kalemegdan once Kalemegdan exists, right?
Of course.
And so this says that Mr. Obradovic is going to fulfill the instructions of Mr. Brown in relation to matters involving Kalemegdan. And at the same time, what you're saying is that Mr. Obradovic owed fiduciary duties, presumably to execute the instructions of anyone in favor of the beneficiary, which would have been Coropi.
I am not to say what Mr. Rand had in mind. I think that the wording of this paragraph could have been more precise. It is probably because the issue of trust law is something which is quite complicated to non-common law lawyers. But it doesn't change the essence of the matter, which is that the understanding between them was that there would be a trust. Now, the trust...
Where does it say that?
Well, I referred to the relevant paragraphs before. I think it's if we go to paragraphs 15.
Fifteen talks about Mr. Obradovic being a nominal owner. This is when Mr. Rand invested in 2004, or even earlier, 2005.
So this is relevant, and also paragraph 33, according to my report.
33 talks about the Ahola family trust. It's not really the same point.
And then paragraphs 40 and 41.
That talks about the trust deeds. It said, I later instructed Mr. Obradovic to conclude 2 trust deeds.
Yeah, so...
But again, your conclusion is that the trust existed on the date of the incorporation of Kalemegdan.
Yes.
Yeah. There's nothing really we can draw from this that talks about establishing a trust on that date, is there?
Well, this is my opinion. It is for you to decide.
No, that's fine. Finally, just in relation to the constructive trust point, I understand that constructive trusts arise by operation of law, but you need a court judgment, don't you, to declare the constructive trust?
If there is a dispute between the settlor and the beneficiary.
Yeah.
But we don't have this case here.
But in order for a constructive trust to be recognized, there needs to be a court order, doesn't there?
Not necessarily. If it is contested, if there is a constructive trust and the parties act in compliance with the trust, there is no need to go to court. It doesn't, or if, as in our case, when there was clearly an express written trust deed from the 26th of April, if I'm not mistaken. If you're suggesting that they should have gone to court to declare that there was a constructive trust between March and April 2012, then I respectfully disagree with that position.
No, that's my point's slightly different because in the alternative, you're saying that there's a constructive trust if there's no express trust.
Yes.
And am I right in thinking that you're inviting the tribunal to make that declaration that there's a constructive trust? Because either we find there's an express trust or we find there's a constructive trust.
Yes. In the alternative, yes.
I'm just wondering whether the tribunal really has the power to do that, because we would be making a declaration that would have proprietary consequences as a matter of Cypriot law, which may affect third parties.
Well, I do not see why you cannot. But in any case, the relevant asset was transferred to Kalemegdan on the 26th of April. And on that day, we have a trust deed. So unless there is something that I am missing in this case, I don't really see much relevance in there being a trust before that date.
Well, because we have to establish that Coropi had some sort of proprietary interest as of the date of the alleged breach of the treaty, which was before the shares were ultimately transferred.
Well, then you will need to decide on my point.
On the constructive trust point.
Yes.
Okay, thanks very much.
Thank you.
So, Georgios, let me just follow up on this line of questioning briefly from Professor Douglas. And let me start with a sort of prosaic point, just to test it, and appreciating that you are not, as you've said, a family lawyer. And although I am an English qualified lawyer, I'm not a trust lawyer. But I just want to pull at the string a little bit. As you gave the example of a husband and wife buying a car, and you said, well, there would automatically be a constructive trust that was established. But insofar as these issues may be contested, and they may be contested for all sorts of reasons, whether it's family law reasons, whether it's tax reasons, whether it's sale reasons in due course or whatever, I presume that in the absence of a document, there may be all sorts of other explanations. One of the spouses may have said, I'm prepared to give you the money to buy the vehicle. And that's going to be highly material to the question of ownership or the question of constructive trust. So I will invite you to make any comment on that you wish to make. But I don't put it to you for comment. I just put it to you for the observation, at least from my perspective, that simply the deed may not be enough. You will have to inquire behind the deed. Do you accept that?
Yes.
Okay, then let's move on. I understand your position to be in your cross-examination testimony and now in response to Professor Douglas that taking your last point first, as you put it, you don't understand the relevance of the debate that's been going on here about when the trust was established. Was it the 23rd of March or the 26th of March or on the 26th of April 2012? And just putting that point to one side, your evidence is that there was an express trust at the time of incorporation, and if you are wrong on the express trust, then there was a constructive trust on the date of incorporation, around about late March.
Correct.
What were the terms of that express trust?
That the shares would be held on trust for Coropi. So in the absence of any limitations to that, I take it that the absolute beneficial ownership of these shares vested with Coropi.
It's usual, certainly in the context of an express trust, that there would be evidence in somewhat more detail of the terms of that trust, whether it's the beneficiaries or the purpose or anything of that nature, because there may very well be circumstances in which if you identify the beneficiaries, that the beneficiaries may get together and decide that they're going to terminate the trust. And I'm just wondering if you can reach a conclusion as an expert on this, that there was an express trust when you can't actually identify the terms beyond the terms that you've just articulated?
Well, I've seen in my practice many trust deeds, and some of them are very long, detailed, and elaborate. Some of them are very, very short. I have seen trust instruments which are just one phrase saying that I hold the shares on trust, the X shares for Y, and that is sufficient under Cyprus law. So I think that as a matter of good practice, there should have been more details put down on paper from the date of incorporation of Kalemegdan. But the fact that this was done does not change my opinion, which is what I said before, that a trust was in existence from day one.
Thank you. I mean, of course, on the trust deed of the 26th of April 2012, so a month later, there were quite some more significant details that were gone into. If that can quickly be called up, that may be helpful. This is C66. If you can just scroll down towards the bottom of that page. Now this deed is made pursuant to consideration of the above witnesses follows. The grantor hereby declares and directs that the trustees shall hold the shares on the following trusts, and no need to go into the detail, but you've got A, B, C over the page, D, E, F, G, H. I mean, here you've got a declaration of trust, a trust deed in quite some significant detail, but your evidence is that an express trust arose a month earlier, but just with a bare bones of the shares are held on behalf of Coropi.
Yes, and this is confirmed by the wording. If you go to the preamble of this document, you will see that it refers to, in paragraph A, it says that the grantor is beneficially interested. So I understand that this was put in the preamble to, at least this is my understanding of it, that it was assumed that the beneficial interest vested with Coropi before the trust deed was entered. This is how I read it.
Well, it may or it may not be. I mean, it does not, this does not, for example, say, in recognition of the express trust that was established on the 23rd of March or the 26th of March, we hereby reduce that express trust to writing and embody it in the trust deed.
I agree with what you say, and I think that the wording could have been better, but reading this in combination with the other evidence has led me to the conclusion that was put in my opinion.
Thank you. Now, your first expert report and Mr. Rand's first witness statement were both signed on the same day. They both have the same date. May I ask you, did you see Mr. Rand's witness statement in draft as you were drafting your expert report?
Yes.
Did you take the draft of that witness statement either expressly because it was put to you in these terms or implicitly because you understood that this was the claimant's position as an instruction as to certain facts? Because Mr. Rand said, you know, this was his relationship with Mr. Obradovich in terms of what Mr. Obradovich's responsibilities were and the trust relationship. The fact that you were reading his witness statement in draft as you were preparing the report, and it says in very explicit terms, did you understand that as either as an instruction or an assumption that you should be making for purposes of your report?
With the exception of evidence to which I refer and which I have ascertained myself, the other references to evidence that was given to me, either in the form of testimony of Mr. Rand or Mr. Broshko, or there could be something else which I can't recall at the moment, was taken by me for granted. So I did not question that. I assumed that it was correct, but that is to the extent that such evidence is referred in my opinions.
That's helpful. and advances my understanding, but let me just make sure that my understanding is correct. Are you saying that insofar as you read this evidence, even though it was in draft, you understood this to be an assumption which should inform your report?
Yes.
Right. Because in response to Professor Douglas, when you were identifying the various paragraphs in Mr. Rand's witness statement, which you had then subsequently relied on in your witness statement, as we were going through them one by one, they did not quite seem to address the point that is in fact captured elsewhere in Mr. Rand's witness statement when he talks about his relationship with Mr. Obradovich.
Well, I may have not referred to all the paragraphs that were relevant, but if there was a mistake on my side, I do apologize for that. But I did include the references to the paragraphs that at the time of writing the report, I thought made my point. And going through them again today, I remain in the same position.
Thank you. Let me take you, well, let me just ask my colleague, Mr. Jan, if he's got any questions on this line, because I've got some other questions, but if you would like to ask continuity.
Very brief in this line. And then I have a different one. My understanding from your evidence today is what that you said, that the fact that existed a trust deed, a written trust deed, later on, in your opinion, make it, would I say, it cure any ambiguity or any problem that would exist with the previous trust under the Cyprian law, correct?
Yes, that is my position.
Can you elaborate a little bit on that, how this worked legally? What is the relevance in your view of this trust deed of April 26 as compared to what may have existed before?
Well, even if I am completely wrong about the period between end of March and end of April, and there was no trust, which I do not believe that this is the case, but even if I am wrong, from the 26th of April, which is the date of the first trust deed, 100% of the beneficial ownership of the Kalemegdan shares were held on trust for Coropi. So that is what I say in the relevant part of my opinion.
Yeah. Thank you.
Yeah. No doubt we will hear from counsel precisely what the relevance of that 1 month period is in due course. That's not a question to you. I just have one or two other brief questions, and this is in relation to the first part of your testimony on the question of seat. You reference in both your, I think, first and second witness statements, the Mira investment decision. I don't need to take you to it unless you need to refresh your memory. I think, if memory serves me, it's well, I don't have the reference. Let me just see if I can find the references.
Is that in my second report?
I think it's both your first and second reports.
I think I
quote. So Mira is at 4.3.2 of your first report, and I think in further elaboration, if I can find it. And in your second report, it's at 3.1.6. And it may be that you just like to refresh your memory on the second report, because I think it's a little bit more elaborate. 3.1.6 is on the screen. Can you just go up a little bit?
316 and 317.
Yes, and 3018.
Yes.
And you say the conclusion that under Cyprus company law, the term seat has the same meaning as registered office was confirmed by the tribunal in Mira against Serbia and arbitrator Park and Siak against Montenegro. Also, this has long been a position in Cyprus case law, as was correctly put by the Mira against Serbia tribunal. And then there's a quotation. And 3.18, importantly, the Mira award had the benefit of witness testimony from Mr. Georgios Ikovu, a former Minister of Foreign Affairs and Signatory of the Cyprus-Serbia BIT. So you align yourself very fully with the MIRA award on this issue.
Yes, but as I said before, I was not instructed to give an opinion on public international law, but on Cyprus company law.
I understand, but the MIRA award addresses Cypriot law. You quote that paragraph and you align yourself.
Yes, I fully adopt that, yes.
Right. The MIRA award, perhaps we can pull it up just briefly. It's RL20. Uh, 022, yeah. And if we can scroll down to paragraphs 89 and following. 89, first of all. 89. And Mr. Georgiadis, I don't need you to read this closely. I will just talk you through these paragraphs. You'll see paragraph 89. It says, since there is no definition of seat in the ICSID Convention nor in the BIT, and no uniform definition under international law, the arbitral tribunal considers that the term in question must be interpreted by way of a renvoi to municipal law. In Barcelona Traction, the International Court of Justice affirmed, etc., etc. Let me just ask you as a preliminary matter, there's no reason why you should be familiar with it, but are you familiar with the Barcelona Traction decision?
No.
No. So, Council, I'll put you on notice. We're going to put questions to you about Barcelona Traction. I will simply represent to you, just it's not relevant to a question that I'm going to ask, but just to fill out your.
If you can add there, I have read references to Barcelona Traction in literature.
Mm-hmm.
I have never read the judgment.
Right. Not to worry about it. The long, detailed judgments going back to the early 60s and 70s. But just for your comfort, just to give you a sense of what Barcelona Traction decided, was proceedings involving between Spain and Belgium, and there was the question, it was a question of diplomatic protection. Can a state assert an interest vis-a-vis another state in respect of a company? And the question that arose there in the context of diplomatic protection, and I'm stressing this also for Council, because that's rather different from the circumstances that we face. The question arose was, what was a sufficient connection between a company and a state in order to enable a state to assert a right of diplomatic protection? So they were looking at company, at connection. But you will see in the MIRA award, if you go further down to paragraph 90, and this is what I believe you are aligning yourself with. It says the concept of a seat of a legal entity remains essentially a municipal law concept derived from the civil law tradition and is foreign to Cypriot law, which is rooted in English common law. As confirmed by the claimant's legal expert, former Attorney General of Cyprus, Cypriot law does not recognize any notion equivalent to the French law concept of siège social or the German law concept of a real or effective seat. And I understand this to be consistent with what you are saying. Are you content with that?
Yes.
So
but
just
if I can add something.
Yes.
If there are circumstances where a Cypriot court, for example, or a Cypriot authority is considering whether a company is seated elsewhere, and that the place in question is a place following the real seat theory, then it will look at the real seat theory to determine whether the particular company is seated in the particular jurisdiction, but it will not apply it for a company having a registered office in Cyprus.
So you anticipated exactly the point that I was going to ask you, because let me put to you a number of propositions to make sure that I understand your testimony on this. I understand that you accept that in some jurisdictions, seat and registered office are different, but that your evidence is that in Cyprus, seat and registered office are the same.
Yes.
I understand that you would accept that in those jurisdictions in which a seat has a distinct concept, that will connote the center of management or control.
If that place is
If that place, yes, if that place has the concept of a siege social, that what that other jurisdiction, a civil law jurisdiction, perhaps somewhere, would understand by it is the place, the center of management or the center of control, but that is not the position in Cyprus.
Yes, yeah, that's correct. Of course, I do not know what the position is in every possible jurisdiction following the real seat theory, because there may be variations to that. But I understand that the general position in real seat jurisdictions is that we look for the place of central management and control.
Right. I think those are all the questions that I have, and I'll hand. You want to say something further?
Can I give an example to explain on exactly on your point? If we have a Cyprus company registered in Cyprus with a registered office in Cyprus, who intends to move its registered office to Greece, it is actually reincorporated in Greece. This means that the Greek authorities will not be happy with the transfer just by looking at the transfer of the registered office, because their real seat theory, they will be asking about where the real seat of the company is. Now, if we reverse the example, and the Greek company wants to transfer to Cyprus, the Cypriot registrar will not care where the real seat is if there is a declaration and other requirements are met. And there is a declaration that there is a registered office for that company in the Republic. That is all that is required. So the real seat theory may be relevant in Cyprus, but not in relation to companies having a registered office there.
Thank you. That's understood.
Okay. A very simple question, Mr. Mamena. The first question that Professor Douglas asked you about the contract, the need of a contract for the contribution of the shares. I don't know if you recall that question. Yes. At the beginning of yes, okay, under Cyprus law, and I want to show you a document that we saw many times yesterday. I don't know if you have been seeing this document, which is C342, which is the agreement on the capital increase of Kalemegdan.
The minutes?
No, it's the agreement of capital increase.
Can I?
Yeah, no, of course. Do you know this? Have you seen this document?
Yes.
Which is subject to Cyprus law, etc. Would that under Cyprus law would account for a contract for the contribution of the share? You can.
Can I get the chance to read the whole document, because I have seen the document before, but because this question was never put to me, I didn't really think about it. But I can try to give you the best possible answer now.
If you don't feel comfortable with that.
No. If I read it, I believe that I can probably give you an answer. But I need.
It's short.
2 minutes.
It's short. It's short.
Go to the Obnova shares, please. If you can go upward. I will just repeat for the record. I've asked if you can go to the Obnova shares, which is on the next page. Yes, paragraph 114. Yes. I assume that this amount in paragraph 2.1 corresponds to the amount that was in the document HE12. That was the allocation of shares that we've seen before. So I think that this document does qualify under the provision of the company's law that I cannot recall now, but was referred before in relation to the obligation to present an agreement.
Okay. I just want to confirm that then there was a question when was asked to you by Professor Douglas. If you want, you can. I mean, I think
You can just see the last page.
There is.
Yeah.
That's applicable law.
Yes, the agreement is, of course, under Cyprus law, but there may be a renvoi because of the shares of foreign companies. So there may be issues of Serbian law affecting this agreement, but under Cyprus law, on its face, and I stress that this is the first time I'm asked to answer to this question, it appears that it satisfies the criterion.
Of Cyprus law?
Yes.
Okay. Thank you.
Any redirect on the tribunal's questions?
No, thank you, Mr. President.
Thank you. Just a short one. Could we please show the witness document C65? And this will relate to the questions about the 1 month of trust.
And this is an evidential question rather than a submissions question.
Yes, I will just show some information, some data to the witness, and then I will ask the witness whether he wants to expand on his answers to the tribunal in light of that information. So if we scroll down, please. So we see this is the corporate register of Coropi Holdings Limited. And
yes.
What I want to show to you is the list of directors of Coropi. Oops. It seems that we've been working too long today.
I think it's referring to me.
Yeah. No, it's fine. It was just reopened. It's fine.
So what's the last document?
Okay, so let's make it easier. I represent to you that in March and April 2012, both Mr. Rand and Mr. Obradovic were directors of Coropi.
Yes, I think it's mentioned in my report.
Yeah. So, and my only question is whether, this fact is relevant for your answers with respect to, the evidence you have seen with respect to the establishment of oral trust back in March. Yeah, now we have it here. So we can see on the third line that Mr. Obradovic was a director from March 2010 until June 2013. And on the fifth line, we see that Mr. Rand has been a director since March 2010.
Yes, this is also, there is also a reference to this table in paragraph 3 to 710 of my second report. And it is a relevant matter because the fact that they were both directors of Coropi and, shows that these two persons were involved in setting up this arrangement. So it was clear. It's not possible that it was not clear to the professional directors that these two persons had some form of arrangements between them, and they had an understanding of what this arrangement was. So it supports this argument, I think.
Thank you. That was all.
Thank you. No doubt, Council on both sides will return to the issue of the relevance of this period. Mr. Georgiadis, thank you very much. It's been perhaps a slightly longer afternoon than you anticipated for us as well, but we very much appreciate your assistance, and you're excused from your responsibilities as expert. So
thank you for your time and attention.
Council, appreciating that it's late, but I nonetheless would just like to take the opportunity to simply turn the pages on the questions that we put to you in case you've got any questions to us by way of clarification. And although there may be a number of others that we'll add, I also want to add immediately two other questions to the end of that. But do you have the document that was sent to you in front of you or on the screen? Yeah, they're over there. I can take you through each of these question by question, but you have probably had an opportunity to read them. Let me give each of you in turn an opportunity to raise any questions of clarification that you may have with regard to these questions. Mr. Pekan.
Actually, we do not have any clarification questions. It seems clear to us what the tribunal would like to hear.
That's easily done. Okay. Respondents' Council, any questions?
I don't think we have anything at this stage, but we have only had very preliminary, superficial look in the break, right? But it seemed plausible and clear.
The tribunal takes it under advisement that Council says our questions are plausible. Which, let me just add two further questions which arise out of the issues that we've just been talking about. This is to both parties. We would like you to address the relevance of the period late March, 23rd, 26th of March to 26th of April as regards the trust theory. Does it make any difference given that there was a trust deed on the 26th of April? So we'd like you both to address that. And then if you could if you could consult, or perhaps as we've directed the claimant to put various documents into the record, and this is just for our good order in case the tribunal wishes to refer to them, could the respondent please take the responsibility of putting in the Barcelona traction judgment into the record, please? That's our request, and it's the judgment of the 5th of February 1970. You'll find it on the website of the International Court of Justice, just so that we have that on the record.
That reminds me that I do have a question. Would
Yes.
the tribunal like us to put that on the record before Friday?
Well, insofar as you're going to may wish, you or respondent may wish to refer to these in your submissions, it may be useful to have them before Friday. The only other point that I'd make, and then we will close, is that you will have seen, quite apart from the detailed questions, you will have seen questions 1, 2, and 3 are really asking you to make closing submissions. So I don't know whether you've got any further in addressing these issues, but I won't ask you to address this now. But I anticipated yesterday we are going to ask you, please, perhaps tomorrow morning when we deal with housekeeping matters, whether you have either preliminary or final views as how you think Friday afternoon should happen. Thank you very much. It's been a long day for everyone. The room is now a little cooler. Yes. So much appreciation to everyone, to the court reporter, and to all the staff of the World Bank for indulging us here. Thank you very much.
Thank you.
Another long day, but we're on track. This makes a difference. Yeah. If you want to rush. Or is it- or you're just never gonna make it?
have like 20 minutes.
Just arrange it for another evening or another time. You can't.
She, okay, I might.